the panelists will enlighten us on new mechanisms on how we can engage member states, the policy organs, but also maybe enlighten us on what new actors we can actually bring on board on the table beyond the usual suspects that we have. So I will invite the first speakers. It's a joint presentation we will have from Clement Mavungu, who works at the Pan-African Parliament. We also had heard from him yesterday. And we also have Professor Rachel Mullery, who is a professor at the University of Bristol. They will jointly submit on an African model law on implementation of international human rights obligations, a potential tool to assist AU member states in the implementation of the judgments of the African Court on human and people's rights. So I kindly invite you. You have 10 minutes to make a submission so that we give time for discussions later on. Yeah, you have the floor.
Thank you so much. I think there's a PowerPoint, but I'll start for reasons of time, and if it comes up, then I can talk you through it. So I'm going to talk for the first 5 minutes, and then I'll hand over to Clement. So we've already heard yesterday all of the challenges in terms of implementation and the various initiatives that could be put in place to sort of address that implementation gap. Thank you. And we also heard that the reasons why states might not implement are complex. We heard a lot from Dr. Tarasai on political will and trying to dig a little bit deeper as to why states fail to implement or only implement partially. And some of these reasons, these are not the only ones, are to do with a lack of knowledge of the decisions. I think many of these we heard yesterday. A lack of understanding about precisely what's required to implement. And then a lack of infrastructure or systems that enable us to identify who's responsible and who will coordinate any state action in the domestic level. What we've seen, and I think again reiterated yesterday, is that implementation is not automatic. Processes are required to implement the range of remedies, whether that's paying compensation, opening an investigation, conducting a retrial, prosecuting individuals, adopting legislation, training officials, or any other measures. And although the legal status in international law of decisions from the African Court is very clear, and Article 30 requires states to undertake to comply with the judgments of the court. What is less clear is the legal status of those decisions in the domestic legal order. And clearly, what we've seen is that African court decisions and decisions from the supranational level require some legal basis in national law in order to be fully implemented. And so a solution has arisen, and you can find examples of this across the world and within the continent, of what's known as enabling legislation. And this really is the embeddedness that Professor Franz was talking about yesterday. And this enabling legislation, so domestic legislation, gives legal effect to an African court decision or judgment or other international bodies' decisions within the domestic legal order. And what we want to present on today is those types of enabling legislation, and then whether the Pan-African Parliament can develop a model law on enabling legislation. So why might this type of enabling legislation be needed? So as I said, Article 30 has states undertake to comply with the decisions of the African Court. But is there an obligation to provide for legal effect of the court's judgments within national legal orders? And obviously the challenge, and I think this was Justice Bensouda's comment yesterday, comes when the decision of the African Court conflicts with binding national law or domestic court judgments, placing national courts in a very difficult position. Justice Stella also yesterday raised the possibility of foreign judgment laws and talked eloquently about the possibility of those, but they don't tend to apply to supranational bodies' decisions. So this is where enabling legislation comes in, and it can take a number of forms. I've given some examples there, but these are not the only ones. So it can provide for legal effect of the international judgment in the domestic legal order. And we can see this in a number of examples across the inter-American system, for example. It can also provide for a procedure for the reopening, revision or review of proceedings, for example, taking the decision of the international body as new evidence or new facts, and thereby enabling changes at the domestic level. It can also require that mechanisms by which compensation is ordered and then paid are set up, or establish national mechanisms on implementation, reporting and follow-up, which again we've heard about yesterday. And just before I hand over to Clement, so what about model laws? What can model laws do? So there are various examples of model laws across the continent, and these include a model law on access to information, a model law, a police law, and so on. They can provide practical guidance. They set a standard and a benchmark against which national law can be measured. They can baseline, but they can also go further and provide leadership in this area and be a model of current sort of best practice. And they can also set a regional standard, so they're homegrown and be tailored to the specifics of the continent. They can be limited, so we've seen that enabling legislation can be limited to specific types of remedies or particular courts, and a model law can offer a sort of comprehensive and holistic approach. And the actual process of adopting a model law can be really useful in terms of advocacy and raising awareness. So I think my 5 minutes is up. I'm going to hand over to Clement.
Thank you very much, Professor Murray, for the conceptual part of our presentation. I will go to the practical part of our presentation and make a conclusion, a quick conclusion. And my intervention will be on actually presenting what, the content of the proposed model law could be. Again, if the PowerPoint presentation is not projected, I will still proceed to say that the proposed law could include a number of elements, particularly providing for some guiding principles, and these principles could include the principle of respect for supremacy of the international order, to ensure that even if there's an enabling law to facilitate implementation of court, human rights decisions, it must be clear that decisions from the court or any international jurisdiction should supersede national law. Secondly, the principle of victim-centered approach, equality before the law, non-discrimination on any grounds, gender sensitivity of the process of implementation of decisions, transparency, accountability, and diligence in the implementation of the decision. Secondly, the model law could also clarify competence within the domestic jurisdiction to state which specific jurisdiction or judge could be competent to order or to enable implementation of decisions. And we propose that as far as decisions of the court are concerned, once they are registered by, once they are notified to the Ministry of Foreign Affairs or any other ministry in charge of receiving notifications from the court, they could be then registered to the relevant court or jurisdiction for implementation. But the jurisdiction should be at least the jurisdiction that is the immediately superior to the one where exhaustion of remedies was either done or denied. Secondly, the model law could also provide guidance on how to execute decisions of the court where orders for payment of compensation were made. And in this case, the proposal is that the competent jurisdiction will simply order for the execution of the order of the Afghan court without having to touch on the substance of the decision. Only where the Afghan courts makes an order which is not precise or which is not precisely indicating the quantum of the compensation may the national jurisdiction dissect the order of the court and provide for some quantum for reparation. Thirdly, there could be cases where claims are made or invoked before the national court which are connected or incidental to the case or to the judgment of the tribunal. We also propose that in such a case, the national judge could be able to address those claims and provide remedies. Yeah. And then the model law could also cover, I think, many other aspects covered in our paper, but I think I will skip some of them and insist on communication on the implementation of the decisions, communication between the national authorities and the court on the one side, and between the national authorities and the beneficiaries of the judgment. The model law could also make provision for budget planning because the implementation of decisions may have financial implications, and it is being proposed that there should be a provision within a national budget to cover for implementation of decisions, and then oversight of the implementation, which will put together a coordinated mechanism for various departments and institutions concerned by the implementation of the decision. Having said that, I will just move to the conclusion and say that our proposal for the model law implementation acknowledges that a model law to enable implementation of decisions of the court is only one tool in the implementation armory. And we believe that it's going to bridge the gap between supranational and national jurisdictions in a very practical way, offering a product which can be adapted by specific countries, taking into account sensibilities of the systems, whether you are in a common or civil law system and other possible systems. We also, while proposing for this model law to assist in the implementation of decisions of the court, exploring whether it could actually not be limited to the court. It could actually just be a model on implementation of decisions of human rights bodies, including the Commission and the committee. But we are aware that the binding nature of decisions of the court vis-à-vis those of the Commission could probably be an issue. We believe, however, that it could still, even in the case of decisions of the Commission, be used particularly where specific member states are willing to implement decisions of the Commission or of the committee. Having said this, we thank you very much for your kind attention. Thank you, Madam Chair.
Thank you very much, Clement Mavungo and Professor Rachel Murray, for the joint submission on the model law. We will save our questions and discussions for later. Let's proceed to the next presentation on the politics of compliance, evaluating the role of the African Union Executive Council in monitoring the implementation of the decisions of the African Court. This is a presentation that will be made by Dr. Jafet Bigon. I hope I have pronounced it properly, who is the African Regional Advocacy Coordinator at Amnesty International. You have the floor and you have 10 minutes. Don't make me to interrupt you by finishing in the 10 minutes time. Thank you.
Thank you, Adiam. I'll try. As Adiam has mentioned, my presentation is titled The Politics of Compliance, and I'm looking into the role of the Executive Council. This is a topic that was already well covered yesterday by Justice Anukam during her context-setting presentation. But to set us off, I just wanted us to have a recap on really what does the African Court envision in regard to the role of the Executive Council. And this takes us to Article 29.2, which provides that the Executive Council shall monitor the execution of the court's judgments. So essentially, the African Court Protocol envisions political supervision of the execution or implementation process of the court's judgments. And Article 29.2 is not different from Article 46 of the European Convention on Human Rights, which also accords the European Council of Ministers the responsibility and the obligation to monitor the execution of the judgments of the European Court of Human Rights. The second provision that also Justice Ankom referred to yesterday is Article 31, that provides that in its activity reports, the African Court shall specify particularly the states that have not complied with the judgments of the court. So it puts a spotlight and asks the court to put a spotlight on governments and states that have not complied with the decisions or judgments of the African Court. So that is really the statutory framework and the role that the African Court envisions from the African Court on Human and People's Rights. Secondly, what is then the performance of the Executive Council in performing or executing Article 29(2) and Article 31. When you look into the history of the Executive Council and its engagement with the reports, the activity reports of the African Court, at least 3 particular issues or patterns of engagement comes out. The first is perhaps the most dominant form of engagement that the Executive Council does, and this is the normal political rhetoric. In each and every of its decisions, you'll find a line that says, we note with concern the law implementations of the judgments of the African Court. Then it goes to say that it calls for the states to ensure that they have complete compliance. This is a general statement, not directed at any state in particular. No one leaves the Nelson Mandela Hall at the AU headquarters shivering and saying that the Executive Council actually said we should comply with the decisions, and therefore something is going to happen with us if we don't. It's rhetoric. Everyone knows that the Executive Council has said that nothing is going to happen. No one should take any action. The second is where the Executive Council then moves actually beyond the rhetoric and specifically demands a state party to implement the decision of the court. And this has happened at least once in 2017, when the executive asked the Libyan government to implement the judgment or the order of the African Court. And here, this is where we would hope that we all move into, that this is where the Executive Council will move into, specifically mentioning that country XYZ has not complied and we would like it to comply. And if this example is anything to go by, then it shows that there is a possibility that actually a form of engagement can emerge. Because in June of 2017, Libya then told the Executive Council that we are going to submit a report to the court and to the Executive Council showing the measures that we have taken to implement that decision. Unfortunately, that process never with logical conclusion. So that process, we really don't know what would have come out of it. But it just gives us a snippet of what can happen if the Executive Council actually starts calling specifically to states like X, you have not complied, you need to do it. The third way that the Executive Council responds is executive overreach, where then it misinterprets its role and actually, like it did in 2018, asks the court not to include the names of countries that have not complied with the judgments of the court. And this is what I refer to executive overreach, and this is where we do not want the Executive Council to go in terms of its engagement. Now, I want to propose 3 things for us to understand why the Executive Council behaves the way it has behaved, and the record of performance that I've presented to you, why does it behave like that? There are 3 things that I want to present to you to explain that. The first, that we need to understand the nature of the states and the behavior of states in relation to political compliance. This is a topic that Dr. Tarisai had already introduced yesterday. 2, we need to understand how decisions are made at the Executive Council and the dynamics that inform those decisions. And then finally, we need to understand the broader context within the African Union ecosystem that influences the behavior of the Executive Council. Now, on the character of states and the behavior of states in terms of compliance, I'm proposing that you can look at these states that form the Executive Council and the member states of the African Union into 4 major groups. The first is the cooperative state. This is the state that complies with the judgments of the court or other regional bodies on human rights. This is your Burkina Faso. It receives the judgments and takes measures to implement it. This is a rare state. We only have 1, for instance. Then we have the calculating state. This is the state that's perhaps more difficult to deal with. It actually accepts the judgment. It says we are happy with the, we may disagree with the judgment, but we are going to comply. It actually starts to take measures. It forms a task force, for instance. Or it implements one of those decisions that is easy. It has low compliance cost. This is, for instance, your Kenya. It doesn't say that we are not going to implement the OGEC decision. No, it says we are going to comply. So what does that? It deflates the pressure on it. It tells you that we are going to do something. So you keep on hoping. Then 1 year goes, 2 years, 3 years, nothing has happened tangible. It may even present a report to the court. But the report is not necessarily substantive, but it ensures that we are in some form of dialogue. but full compliance is not taking place. Here, these are the states that actually usually engage in partial compliance. Then we have the indifferent state. This is the state that actually remains silent. It doesn't acknowledge that the judgment has been. It doesn't respond to the communications sent by the African court. It doesn't say a thing. It moves as if the decision or a judgment of the court was never made. It is silent. Then we have, on the opposite side, the recalcitrant state. This is the state that openly says, we are not going to comply with the judgment of the court. This is the state that says, we are going to withdraw. It's your Tanzania, it's your Rwanda, it's your Benin, it's your Cote d'Ivoire. Because of an order or a judgment of the court, it throws a tantrums and walks out of the court. This is a state that can also become aggressive. It may start to call the court names. This is a rogue court. This is a court that is influenced by other actors. So it actually goes aggressive. So we need to understand this, at least 4 of these forms of states for us to understand how to approach them. Then in terms of decision making of the Executive Council, you know that the Executive Council makes decisions primarily on the basis of consensus, and rarely does it put questions that it discusses to a debate. Now, the unanimity and the consensus approach of the Executive Council has led to a situation where the decision-making process mimics what I call the WhatsApp dynamic, the WhatsApp group dynamic. In every WhatsApp group, there is always the vocal critic. Those who post, those who talk, and they have debate, while the rest are only listening. These are the states that will read the reports of the activity reports of the African court, and will stand and say, Article 59, we raise an observation, we raise a reservation, because it's there, it says X, Y, and Z. They are very vocal, but their vocalness is usually really an attack or actually to undermine the provisions of the activity report. Then there are the faithful followers. These were in the WhatsApp group. They will like, they will put an emoji. They don't say much, but they will clap and just show that they are there. The faithful followers in the Executive Council almost do the same. They support the vocal critics, either by silence or by saying, I agree with my sisterly republic country of X. And they join the vocal critics, though not very aggressively as the vocal. Then there is the silent majority. They simply listen as the vocal critics and the faithful followers discuss the issue. And always, almost always, it's the positions taken by the vocal critics as supported by the faithful followers that takes the day. That would explain some of the decisions that you see in the Executive Council, the Executive Council decisions relating to the African Court activity reports. Then finally, in 2 minutes, there are broader issues that we need to take into account when thinking about the Executive Council. First is that within the African Union as a whole and the Executive Council, there is a general culture of reluctance to criticize each other. But Article 29 and Article 30 really requires states to look into each other and say, you are not complying with the decision of the court. You need to do something. But because of the reluctance of, criticizing and genuinely, honestly talking to each other within the Executive Council, this does not happen. And it's not just within the Executive Council. In the African peer review mechanism, it rarely happens, yet the African peer review mechanism was meant to be that heads of state will honestly speak to each other. Professor Hansungule Michelango, who has attended some of these sessions, tells us the best that heads of state do is to say, we congratulate you, we pat your back for doing X, Y, and Z, but rarely to say that you are doing this wrong, you need to change direction. Secondly, is that there is a largely non-functional sanction regime within the AU. So, although Article 23 of the Constitutive Act provides for sanctions, including for non-compliance with the decisions of the organs of the African Union, the African Union rarely activates its sanctions regime. It only does so in two areas. When there is an unconstitutional change of government, they suspend you, and this is an action of the Peace and Security Council, and occasionally when a country has not paid its assessment contributions. then they might be stopped from attending the meetings of the African Union. Those are the only two areas where sanctions are actually imposed on a member state of the African Union. Outside that, you will not find anything else. So there is really a largely non-functional sanction regimes. For instance, when a state has bluntly said it's not going to comply with the judgment of the African Court, the Executive Council, the AU Assembly, the AU in general will not act. Then thirdly and finally is the poor rate of implementations of the decisions of the AU itself. We are asking the Executive Council to ensure implementation of decisions of the African Court. Yet in reality, they are not implementing their own decisions. The decisions they themselves have made, they are not implementing it. In 2017 Kagame report, he says that the African Union has adopted 1,500 resolutions, for instance. But you cannot be able to tell which of these actually have been implemented. The reality is that there is really low rate. Finally, moderator, two opportunities that I think we could try to move these discussions forward. One is, of course, a very articulated process in the draft framework of reporting for monitoring execution and judgments and other decisions of the court. Submitted to the court in 2019, up to now it has not been formally adopted. If you look into that draft framework presented by the African Court, it provides for the steps that the PSC, the Executive Council, should take to ensure that it takes its monitoring role more seriously. Secondly, recently, in the last 5 or so years, the PRC has activated its subcommittee on human rights, democracy, and governance. This is the subcommittee that should essentially take up the monitoring role, according to the framework that has been submitted by the court. And it's this subcommittee that should now actively look into the reports of implementation, see what has been implemented, what has not been implemented, and then engage with the state party. I submit. Thank you.
Thank you very much, Dr. Jaffet.
Un grand merci, Dr. Jaffet, pour cette présentation bien détaillée.
Examples to our daily life so that we can understand it better. We really appreciate. Let's move to the third presentation we have in this panel, which is on the road towards implementation of the African Court decisions in Ghana, CSO's role and effective stakeholders engagement. The presentation will be made by Agbenu Do. I hope I have pronounced your name properly. Agbenu Do is an advocate in Ghana, and he's the focal person for Ghana of the African Coalition for the Court. Yes.
Thank you. If you follow Dr. Jaffet closely, then you have to be careful. Yes, implementation of decisions of the African Court is not a one-man business. It needs the buy-in of others. And the role of CSOs, civil society organizations, is very crucial in making sure that the decisions are not only made by the courts, but these decisions are implemented. In Ghana, the CSOs have been very instrumental in advocating for upholding and human rights standards and rule of law. And they have served as the intermediary between and the bridges between the international judicial mandate and also the national compliance. Now, these CSOs do three main things. One, they monitor the state response to implementation of decisions that are made by the courts. They also create awareness of the existence of these decisions and embark on advocacy strategy to help countries that decisions have been made against, to make sure that they understand why they should implement those decisions, and also help them to take the necessary measures that can help them implement those decisions. Yes, it is effective stakeholder engagement will result in coordinated efforts and helping government to come to the realization that they need to engage others in helping to implement the decisions of this court is very crucial. There are a lot of CSOs that we can, other partners that we can engage to help us in our various countries to make sure that decisions that are made by government are executed or implemented. Some of these bodies include the judiciary of the country, government agencies, professionals like lawyers and businessmen, and also academia, the media, and also international partners. All of them are needed to help get government attention in implementing decisions of the court. In 2019, the African Court Coalition, under the RWI, African Regional Program, undertook a study, and the study shows two main things. That one, there's lack of coordinated implementation mechanism at national level, and also there's a need for some of the countries to domesticate their laws, to domesticate the African Court Protocol into their laws to make implementation easy. And that has been the case of Ghana. And in making sure that these findings are implemented in Ghana, the African Court Coalition assisted to implement or appoint a focal point in Ghana. With the African Court Coalition assistance, the focal point help in creating awareness about decisions that are made against Ghana by the African Court. And I must say that no major decision has been made against Ghana except two others, which Ghana as a country had a problem in implementing. Like the Bible says, that those who are faithful in what is least are also faithful in what is much. So if small decisions cannot be implemented, then it means that when the bigger decisions are made, Ghana may not be able to implement them. The focal point in Ghana, with assistance of the RWI, prepared a baseline report which revealed two main things, like I've said: non-compliance of the decisions of the court, and also the requirement to implement or to domesticate the African Court Protocol into the laws of Ghana. In 2023, we carried out the second phase under the implementation project, and two main things were done. First, we organized CSOs and lawyers meeting to create awareness on the challenges that Ghana is facing in implementing decisions of the court, and also to do follow-ups on Ghana's move with the Attorney General and TRAJ, that's the Commission on Human Rights Administrative Justice, to see what the country is doing to implement decisions of the court. One major outcome of this meeting with the CSOs and professionals was the formation of CSOs Coalition. And this CSOs Coalition was formed in 2023 and has been advocating for implementation of the court decision in Ghana since its formation, and also to create awareness of the decisions of the court. Since its creation, the coalition has engaged various actors, especially government and non-government actors, to make sure that the road to implementation of decision of the court is charted in a way that becomes easier in the future when such decisions are made against the country, so that the country can implement those decisions without any excuse. So together with the African Court Coalition, the Ghana Focal Point has developed a comprehensive advocacy strategy as a guidance to help us in assisting the country or our country to implement decisions of the African Court. The process has just started, and we are happy to invite all of you to assist us in making sure that the various elements that are captured in this advocacy strategy that has been developed by the Focal Point and the African Court Coalition are executed to the letter, so that the results can be achieved. The number of things that have been done will include helping the country to change or make some changes to its laws. Ghana does not recognize decisions of the African Court as foreign judgment or international judgment, on two grounds. That one, the laws of Ghana, especially two laws, our Court Act at 459, 1993, and our High Court Civil Procedure Rules, especially Order 43 and 72, do not recognize the decisions that are made by foreign tribunals, such as the African Court, as foreign judgment or international judgment. As such, when such judgments are brought to the attention of government, they are not taken seriously and are not implemented. Now, what is the CSO's role in helping that decisions that are made by the court are implemented? Well, they have identified 6 of these roles, and I quickly want to go through them. And these are recommendations that I am making to all of us here to make sure that decisions that are made by the court against our country are implemented. And we can garner support to put pressure on our government to implement these decisions by undertaking the following. One, adoption of effective and practical advocacy strategy. Yes, it's important for CSOs to adopt effective advocacy strategy to make sure that these strategies provide guidelines that will help their country to implement decisions that are made. In Ghana, when the CSO coalition is formed, we have put in place a management strategy. So we have a secretary chairman and the focal point as those who take part in the day-to-day advocacy activities of the CSO's function. And the coordination team makes sure that all aspects that can be adhered to make sure that the decisions are brought to the attention of everybody, especially the beneficiaries of the decision, are carried out. So we develop a number of things which we encourage us, all of us to do, that we have advocacy objectives, we have developed time frame, we have targeted state and non-state actors that we have identified. Key aspect of the advocacy strategy is to help stakeholders to come to support the efforts that the CSO's coalition is making to make sure that the advocacy strategy works. Communication strategies form an important part of this, and we want to encourage everybody that in your country, please reach out to the civil society organizations in your country. They are one of the major sources of assisting you to put pressure on government to make sure that decisions are implemented. Another thing we want to encourage us to do is engaging policymakers and other relevant state actors to make sure that these ones come to understand the role they have in implementing decisions of the court. After all, they entered into or signed into the treaties or the protocol. And so once the court made the decision against them, they should be encouraged to implement them. In 2019, the African Court Coalition studying on implementation of the African Court decision identified knowledge insufficiency as one of the major reasons why states do not implement the decision. And so in engaging them, we want to help these state agencies, these policymakers, to come to understand why they need to take action. But like somebody said yesterday, today you are in power, tomorrow you are out of power, and you could become a victim, and the court will really come to your rescue. So we want to help them. In Ghana, since the formation of the court, the CSO's coalition, we have engaged a number of people. We have engaged a number of parliamentarians who would help us to amend our laws to make decisions of the court part of our law, so that it becomes easier for those decisions to be implemented in Ghana. And then another thing we want to suggest is building coalition and collaboration with other stakeholders. Yes, coalition, and you know, in the world today, what we need is not competition, but collaboration. Collaboration with other stakeholders would help us come to get government attention. We are not fighting with government, no. We are just helping them to understand that the position they have taken to give power to the courts to make decisions on their behalf, it is in their own interest and in the interest of their citizens. So we want to collaborate and help these ones to allocate resources, especially for the implementation of decisions of the court in their annual budgets. And also, we want to help these ones, the least opportunity they have, should be able to create awareness about the existence of the court, how the court works, and the mandate of the court, and the need to implement decisions of the court. Another thing we want to suggest is creating awareness through national and regional platforms. There are a lot of platforms that we can take advantage of and create awareness to help a lot in getting attention of government. You know, once the citizens understand that these courts are the last resort of safe haven for them, that if everybody says you are not good, the court will come to your rescue, the citizens will support us. We want to take advantage of these platforms. In Ghana, we have started moves to take advantage of some of these national platforms. So we have entered into an agreement with the Ghana Bar Association so that at the next bar meeting, which is scheduled for September this year, we will be giving platform, the coalition will be giving platform to speak about the mandate of the court and the need to implement decisions that are made by the court. We are also liaising with the judiciary so that at the next meeting of the judges and magistrates of Ghana, and we have one of our best judges who is also sitting in the court, and he's assisting in this, so that during the association, Judges and Magistrate Association meeting that is also scheduled later this year, we will be giving platform to speak about the mandate of the court and the need to execute judgment that are delivered by the court. Some of these platforms will help us so that we are not only disseminating information about the court, we are also making the court known to people. It will surprise you that there are a lot of lawyers who are not aware of the mandate of the court. For some, I'm not even aware that there's a court called the African Court on Human and People's Rights. When we get attention of these people, everybody will come on board. Yes, judges make decisions, and so when they understand better the role, the mandate of the African Court, they would include decisions that are made by the court, even in their judgment, and that will go a long way in helping the decisions to be implemented. We also want to, thank you. Another thing we want to suggest is conducting capacity building training for various actors. And so capacity building training for various actors is also very crucial in helping people. If you don't know something, you are not able to explain it well to people. And so this capacity building training will help various actors to understand very well the work and mandate of the African Court and the need for state parties to implement decisions that are made by the court. And some of these state actors include the media, academia, and even community groups, and get their attention, and so that these ones will understand better, know about the existence of the court and its mandate, and also be able to assist. And the last thing we want to suggest is to conduct research and data collection. And this one will be done in collaboration with academia, especially or research institutions, to understand the behavior of states, why states refuse to implement decisions that are made by the court, and then help in allocating resources to these states so that they will get the necessary mandate and the skills they need to implement. We want to make these few recommendations. One, we want to help states to get the needed technical and financial support that they need to be able to execute or implement decisions that are made by the court. Because we're surprised that some of the states do not know or do not even have the skills that are needed to help. And this CSOs coalition would help this very much. So in your country, we want to help states to come to understand that there's the need for them to have people who have the expertise to be able to implement these decisions. And we also want to establish monitoring and evaluation systems that would assess how the court works. And so, like somebody said, there's the Executive Council. Is it doing its work? We want to monitor those things and make sure that the Executive Council does not only exist in names. The judgment of the court is not only symbolic. It is something that must be translated into actionable platform that benefit those who brought the case to court. Otherwise, then there's no need to bring the case to court. Yes, decisions of the court must be implemented in every way. The road towards implementation of the African Court decision in Ghana has just started. It started with the collaboration, support, and assistance of civil society organizations. It is working and has started working. The behavior of the state of Ghana has been very cooperative since this year so started. And in every aspect of the invitation to either meet the Attorney General, his deputy, or any officer of the Attorney General's office, the collaboration has been very, very supportive. And we want to encourage others also to use the soft diplomacy type to engage states and then also get the attention of civil society organizations so that in all all of us will make sure that the court does not only exist in name, but its impact is felt by everybody. Thank you.
Thank you very much, Gbenu, for the presentation. We now move on to the last presentation on this panel, which is on implementation crisis in the African Human Rights Court. Can social media platforms fill the void? And we get to hear from Dr. Anthony Etuvota, who is Senior Assistant Chief Legal Officer in the Delta State House of Assembly in Nigeria.
Good morning, Your Excellencies. Morning, my dear colleagues. So we've been here to talk about the possible ways we can improve compliance with the decisions of the Africa Court. And then different scholars have come up with different proposals on what they feel should help to enhance the chances of compliance. For we have chosen to look at the role of social media, particularly a platform called the X, which used to be the former Twitter, as a possible medium by which we think we can also explore to increase the chances of compliance. Your Excellency, I want to share some few incidents that happened in different countries on the Africa continent and how this X was applied to casual government behavior towards responding to the demands of the people. I start with a case in Ghana. Just a moment. Okay. In 2021, a young man called Kaka Muhammad was killed, was first of all assaulted by unknown assailants, and a day after he died in the hospital, and that triggered the hashtag Justice for Kaka. And from 26th June, when that incident happened, to September that same year, the government did not just only respond, but they ensured that panel of inquiry was set up. Findings from the committee was also put into consideration, and by September, they were already in court. Also, the popular case of Noble Zogo that we have been talking about, we have known the part of Burkina Faso complying with the decision of the court, but perhaps most of us also didn't know the role social media played in helping to put the government to sit up. We have those findings, and they are all in the paper. The beautiful part about this social media impact is not just getting the state to sit up, it also makes the state to respond within a very short time frame. And then we also found the same behavior in Mali with hashtag Free Rasbath. That has to do with a radio activist who was also arrested, and the hashtag was activated, and the government responded, and that led to his release within the shortest possible time. It didn't end there. In Nigeria, we are all aware, or most of us should have been aware of the EndSARS protest, where the people came together calling for disbandment of a squad called Anti-Robbery Squad in Nigeria, and that also was triggered by the killing of a young man in Delta State, and the video went viral, and then that triggered outcry, campaigns, advocacy, a lot of protest. Of course, initially, it was resisted by government, which also led to the shooting of the popular Lekki Tollgate shooting. But at the end of the day, government responded. The desire of the people were met within the shortest possible time. And it didn't end there. We have stories in different countries. As a matter of fact, when we're doing this research, we have gone up to 32 countries, and we had stories where this hashtag social media was put to use, and government came to respond to the yearnings of the people. Your Excellencies, if we have been here for the past days talking about the way forward in improving compliance, what does this story, what do we learn from this story? Is it something we should just disregard to feel is meant for the young people? Just as a scholar alluded to yesterday, that the earlier we admit to the fact that majority of the population in the Africa continent, over 50% are now youth. And then you also try at least to look at what do they do? By which means do these people get their information? How are they engaged? What is the measure by which you can get civic direct engagement in Africa country? Again, we come back again. How does this apply to the issue of compliance? Because perhaps it doesn't make sense at this point. This may not be a responsibility for the court, but then I look at the follow-up actors. Because once decision has been given and the next thing we hear that the particular state respondent has failed to respond, then stakeholders begin to take up different steps, which include naming, shaming the state actor or the respondent state, trying to cajole what Dr. Tarisai addressed yesterday as political will. And at the end of the day, the so-called political will that we have been fighting to bend, has it really we haven't gotten any result as much as expected. Then what do? That has been the issue here. Your Excellencies and everyone in this house, we have looked at how we should look at this X model, which is the Twitter, as I've said. And then it works this way. Now, the follow-up actors, instead of picking up this whole issue of non-compliance and then you escalate it, then there's something else you could also do. So we advise that, first of all, in that respondent state, every respondent state has an influential social media handler, the one that has public credibility, because the fact that you can trend news and you have great numbers of followers doesn't mean you have public credibility. And we are talking about decision of the court, so we don't need it to be quoted out of context. So the human rights organizations need to find out the influential social media handler in that particular respondent state. Then number two, the influencer would then engage the X handle to frame the subject of non-compliance as an important issue of societal concern. I pause here to explain something. There is also a concern that most persons in the Africa continent doesn't know the happenings, the workings of the African Human Rights Court, let alone the decision. So it is also possible that my neighbor would have been a beneficiary of the court decision, yet I do not feel any concern about whether the decision is complied with or not, because I don't see how that benefits me. And then we are talking about protection of the human rights of those in the Africa continent. So it's very significant that they are brought into the driving the follow-up processes. And one of the ways to do that is to engage in social media. So that, first of all, what that happened, number three, is that the influencer then continues to amplify, fast-trend the information, spread the information, and the issue, thereby raising awareness by the public to incite social mobilization in order to attract the attention of the wider civil society in the respondent states, and by extension to other member states under the Africa Human Rights System. The social media is something that once you drop a story, it goes viral. So it is not just the state concern that will be disturbed when you put their issue on the public platform, especially when it is on a negative note. Other neighboring states and concerned stakeholders within the region and beyond the region will definitely be aware of what is going on. And the fourth approach is, when that happens, you are not also just looking at the state. So I will come down to that. But when that happens, you begin to escalate the issue over and over. Then it gets to a point where those who are concerned will feel ashamed. And then there are possibilities that they may be consigned. And most importantly, those who ordinarily will not even be interested in what is going on in the Africa human rights system or the Africa court will definitely be aware. And then that may also form their radar in assessing government performance at one point. But another very important point that I need to address at this point is when you do follow-up strategy or you put all of those mechanisms, who do you assess or who do you look at as the non-compliant actor? Do you deal with the state as a unitary state, or do you deal with the state as a disaggregated state? So that takes us again to the prediction of the liberal theorists, who predicted that compliance is also very possible when you are able to disaggregate the state and identify the different strands of society embedded in the state. The importance of that is state doesn't have preference, so to say. According to the theorists, their prediction is that the preference of a state is determined by the conglomeration preferences of the individual that makes up the state. So what does that mean? When you apply this model, you try to identify the specific non-compliant actor. For instance, when the court gives decision to say pay compensation to the victim, that decision perhaps is directed to the executive. When you also give a decision requiring a state to amend its legislation, definitely not to the executive. That is a focus on the legislature. When you also give a decision requiring a reopening or a retrial of a matter, that responsibility, by virtue of separation of power, is to the judiciary and not to the executive. But then when you focus your light, your searchlight, on the state as an entity, thereby coming to report that the state lacks political will to comply, that to me is fallacious and is misleading. Because you cannot then say a court gives decision to say amend your legislature. Then you are not getting feedback from the state. And then compliance actor or follow-up actors come back to say the state lacks political will. It is not the state that lacks political will. Identify who has been the blocker of that compliance process. If it is for the legislature, point out who are the actors. So for us, we also try to disaggregate the image of the state. Then for the executive, we identify the head of the executive, most likely the president, then the attorney general. I try to resist the temptation not to argue that the office of the attorney general is as important as the office of the executive president in terms of compliance. I was speaking with Eunice yesterday, and I think there are a lot to learn from her. I am saying this because, first of all, I have been in the parliament for over 10 years, so most of these things I say is from a practical perspective. The office, the executive head most time don't even have time to read. Most of them are not lawyers. And even when they are lawyers, they are not also grounded in human rights issues. Not to the extent that they should understand what compliance means and the importance of responding quickly to decisions from the court. Who does that and whose responsibility? It is the Attorney General. The Attorney General has the ear of the President. I don't know of a state as of today that the Attorney General won't have access to the President on issues that have to do with law. I don't know of any such state. So in that case, the model is suggesting that we identify the Attorney General first when a decision is focused on the executive. Another very important actor is the Minister for External Affairs. Then you look at the legislature, you look at the head of the legislature, you look at the Speaker or the Senate President in whatever nomenclature they are called. But very importantly, because of time, is the role of the civil servants. I have not seen or anybody talking about the role of civil servants. They can be blockers to a compliance process. And then you need to bring them out. And I will conclude by saying that each of these actors have one incentive or the other to comply. For instance, the executive, you feel that they are so monstrous and they are heartless. No, they have a soft spot. They have somewhere you can hold onto and they will comply. For instance, for the ones, especially the incumbent going for re-election, you need to beam your searchlight and make these issues trend on social media to shame that executive. And then the opposition party may catch on it. And at the end of the day, that may cajole compliance from that executive actor. The Attorney General wants to sustain his appointment, otherwise he will be laid off. The civil servant doesn't want to be appointed out unless he is denied of promotion and all of those eternal punishment. So all of these persons, they have their role to play. And then when you begin to beam this light on them and spot them out, that will push them to do the needful if they are the blockers. However, if they are not the blockers, if it is the executive himself that says don't comply, that becomes a bit a challenge to the model. However, if that becomes the case, I also introduced that there are influential politicians within every government sector. And those influential politicians, even when all chips are down, that it seems difficult that the executive head will comply, find out, the follow-up actor should find out those influential politicians in every state, reach out to them. They will have a way, they sleep with these governors, they play with them, they go out with them. He will be able to make them see reasons why they should consider compliance as a better incentive than non-compliance. Then what is the prospect of this model? Even though we are not promising that it will be a perfect antidote to compliance, but we can assure you of two things. One, it will raise awareness about the happenings and the decisions of this Africa Court. And secondly, it would then motivate every other person within the state structure to begin to take these matters of non-compliance very serious and factor it as among other important issues of societal needs as a basis to assess government performance. And of course, that may give them a basis to raise electoral costs against the incumbent government, and that will lead to individual justice in a short term, and in the long term, it could also lead to constitutional justice. I think we should give this a chance. Thank you very much for listening.
Thank you very much for that presentation. Let's now open the floor for comments from the honorable judges, and looking at the time, maybe we'll allow a few colleagues from the registrar, but judges, you have the floor should you wish to yes, you can go.
Merci, Madame.
Thank you very much, moderator. Good morning. I really don't have questions, but some comments to make with regard to the national judges who need to execute our decisions. We need to differentiate between a national judge that is bound by the treaty and a national judge that is required to implement a decision of the court. There are some things that can be executed, but we have a certain number of things that also need the intervention of the state, like the review of the law and all that. The judge cannot automatically undertake these things. So we have some other entities that have to start this process before these decisions are executed. And that's the major issue. The decisions are not really very easy decisions to execute by the national judge. When they read the decisions of the African court, this is an interpretation of the human rights that we do, the charter, the protocol, as well as all the source documents of the human rights. This is the role of the judge, but with regard to the application, unfortunately, they need to wait for the government to intervene, to change the law, to change the constitution, to do something else. This is the power the national judge does not have. We need to differentiate all this. We don't always need to say that the national judges don't execute our decisions because they don't have this power. With regard to this model law, is it a law that needs to be prepared at the national level by the state? Is it a law that the African court could work on? We need to have some details on this because this is a good idea, but we need to really have more information. Does this law exist elsewhere? Has research been undertaken to do a comparative analysis if this has been done, if there is a law that has been done to facilitate execution of international decision? Now, with regard to this idea of saying that we need to ask for help from other countries. We need to understand that we don't have a lot of countries that can support us, but we need to go and ask them to use diplomatic channels to sensitize their peers to help them understand that this execution is, when it's done, it will be helping to implement a treaty, a convention, and also ensure that the different processes that need to be taken are taken before the execution of the decision. This is a recommendation that I'm making. Now, with regard to the intervention of the colleague from Ghana, I agree with what he said. We have other countries and other people who should take on this example. I would like to ask him, will he try to come to work with us? We have a colleague with us who could also provide more information to provide some examples on how to move forward on these proposals. For everything that was said on journalists, media, and all that, I think that goes into the role of the focal point. Is the focal point that should be the intermediary between us and the state. Is the focal point that should explain to the state or those who hold this power of the executing the decisions what needs to be done. We need to focus on the focal points. I can summarize everything that has been done in the relationship between the state and the focal point, and it's the focal point to tell us who we really need to talk to and who can have the power to execute the decisions. I'm sorry for having taken much of your time. Thank you very much.
Thank you very much, Honorable Justice. Anyone who would like to take the floor? Okay, we can finish with the judges and I'll come to you.
Okay. Bonjour à tous.
Good morning, ladies and gentlemen.
I want to salute the panel for a job well done and the new insights that they have brought to bear regarding the implementation of the decisions of the African Court. Now, my sister, Justice Shafika, has said a lot, so I'm going to be very brief because I think most of the ideas I have in mind she has already alluded to. Now, let me start with the last paper by Dr. Anthony Atuvota regarding the role of the social media. I mean, I'm hearing this for the first time that we could actually use, and indeed, it's a very good platform that we could use. And as my sister Justice Shafika has said, perhaps the focal point could consider this. And I'm also excited about the idea of identifying the blockers rather than just say political will as a whole. Let's know who and who is directly in charge regarding the decisions. So when it is the time of the Attorney General, the social media should estray the role of the Attorney General. When it's the time of the court, or just like that, breaking it down, I think will help and deliver us from that general terminology of lack of political will. Now we are more specific. That's a good one. Then regarding the issue of Ghana, the paper by Mr. Barrister Doe, I also find that quite interesting and a bit also very worrisome, the fact that the judgment of the court is neither a foreign judgment or an international decision. So I wonder what category and how then, if your law already says you would not recognize the decision of the court, so how then do we go about talking about implementation? But I'm glad Justice Ajay is here. He sits at the Court of Appeal in Ghana. Yeah, on my right-hand side, I've already hinted him that he will need to throw more light on that because it's strange to us. Yes, and lastly, this idea of an African model law. that has been proffered by PAP. I also find it very interesting, and I ask, who will drive this process? Who is it? PAP, is PAP taking up this responsibility to come up with a draft law in this regard? Or is it throwing it to who? We will need to know who actually would draft this, and I will really be very excited to know if PAP would take up this responsibility, because after all, they are the legislative arm of the AU. I so submit. Thank you.
Thank you for the well presentation, and good morning to everybody. Yes, I would like to talk about a few things. The first one about Ghana. Ghana recognizes African courts. Ghana recognizes international decisions. If you look at the Article 41 of Ghana's constitution, it is on international relations, and it talks about international bodies and their agencies. Then if you also look at the Article 73 of the Ghana's constitution, it also talks about international relations with respect to international bodies. So Ghana recognizes international bodies as well as their decisions. But if I understood him, what he wanted to say is that it is for enforcement. If it is for enforcement, there is no provision in any of the laws to enforce international decision, and it is perfect. Let's look at Inter-American Court. Inter-American Court, the enforcement is made by Council of Ministers. In the European Court, it is made by Council of Ministers. It is only 12 years ago when they decided to involve some of the national courts. Because, for example, let me use my country. If the Supreme Court decides on a matter, and the matter comes to the African Court, and we take a different position, and we ask the same court to enforce it, will the court enforce it? That is why in most of the international courts, they use diplomacy through the Council of Ministers to enforce, apart from the few ones that they can lobby for the national courts, provided there is a legislation to that effect. Otherwise, national decisions are not meant to be enforced by the national courts. That is the general principle. Then let me move on to the second one. The second one about Burkina Faso. You know, Burkina Faso has been doing well, but do we know the basis? The basis is that whenever a president is in power and the president is overthrown and a new one comes and there is a decision, the new one enforces it to show that the previous one was hopeless. So we must understand it from that basis. Let us get a decision against the current government and see whether he will enforce or not. That one is another thing that we need to look at. Then the last, in connection with the last speaker, that whenever we make decisions, we should direct it to Attorney General to this. Please, African court and all international courts, the respondents are the states. Respondents before the courts are the state. And therefore, you cannot bypass the state to direct an agency under the state to undertake an activity. What you do is that when you give your judgment, it is directed to the state. Then the Council of Ministers or the Executive Committee, as the case may be, when they are going to enforce, then they will lobby them. But for a court to say that I'm directing a judgment against an agency under a state, you cannot do it anywhere, because that agency was not a party before you in the court. Thank you.
Thank you very much, Honorable Judges. A final chance to Grace. You have another mic.
Thank you very much, moderator, and the presenters. Very interesting reflections, and good morning to all participants. I have a question to Professor Murray and Clement about the model law. I heard you say that it is one of the principles should be that the national courts can look at the quantum where it is not clear. Don't you think this will result in some kind of instability? If the quantum is not clear in the court judgment, there's the option of requesting for interpretation. So, I mean, was that considered? I feel that could cause some challenges. And then secondly, because the topic is about the role of other actors, and I'm linking it with the session we had yesterday, panel 3, where we had from the Commission, the committee, and PAP. I'm wondering, perhaps there's need to tie all this together to say that during the state reporting process, there should be a way of having these decisions of the court. Of course, that was already talked about yesterday by the representatives from the Commission and the committee in the concluding observations. How about in the APRM process, the questionnaire, and then the Parliament? I know they have a committee on justice there. Other than the statement that Clement told us about yesterday, perhaps this is another mechanism so that everything is tied together. I wish ECOSOC were here. We could have heard from their side on the CSOs. And then lastly, for Dr. Biegon, after we've mapped out this terrain of the AU decision-making process, at the end, what's your recommendation on who should take it up? Is it the court that's supposed to do all this investigation, or other actors, or I didn't hear about that? Thank you.
Thank you very much. So in the interest of time, I think let's give the panelists an opportunity to okay, 30 seconds if possible, sir, and then we take it from there.
Thank you. Congratulations to all the panelists who have talked about the role of the Attorney General in Ghana. The Attorney General is a member of the government, but in Benin, the Attorney General is a little bit different. It's connected to the judiciary, and in our country, it is the head of state who executes decisions and treaties. When there's a decision concerning Benin, it is the Ministry of Justice to communicate to the different agencies with regard to what needs to be done, as I said yesterday, with the separation of powers. It's very hard that the executive asks some agencies to execute some decisions that they do not agree with it. The speaker who was talking about Ghana, it's like you are really saying that we can use internet, Facebook, and others to put pressure to the government. You know, these are things that could provoke chaos, especially when we are talking about citizens, the diaspora who are out, who can sometimes talk about these things freely. It's not the same with the people who are really inside the country. You can be arrested, taken to prison, and all that. This could create chaos in the country.
Panelists, I would really appreciate if you can manage with 1 minute each of you. So we will go in the order we had the presentation, because most of the questions were also directed to the first presentation. Please, you can go ahead.
Thank you very much for the questions. Just responding to Judge Chafika's question around whether there exists sort of model laws out there. From what we understand, there's no existing model law on enabling legislation. So if this were to come off, this would be the first. But what there are examples scattered across different pieces of legislation, different countries, different criminal procedure codes, for example, focusing on specific international bodies. So either they are in relation to, say, the Human Rights Committee of the UN or the Inter-American Court judgments or particular remedies. And so the idea of this model law is to bring all of those examples together under one sort of umbrella. so that you have a sort of compilation of ideas of how these different remedies could be implemented. And again, the involvement of the African Court and other stakeholders will be crucial in the process of drafting this. And I'll leave it to Clement to say more about the Pan-African Parliament's specific role and leadership in this. And just in relation to the sort of instability potentially that's introduced with our suggestion around compensation, where the quantum is not decided by the international body. As Clement mentioned, although our paper focused on the African Court, one question in drafting this model law is whether this also should be applicable to decisions of other international bodies, so the African Commission, the African Committee, UN treaty bodies. So it's comprehensive. And in that context, obviously not all of the bodies determine the quantum at the international level, and so then setting out a process by which that could be determined domestically, we think should be an important part of the law. Thank you.
Merci beaucoup.
Thank you very much. I would like to talk about the role of the national judges. This is linked to the question that was asked, to say that, in principle, if a decision of the court is executed, the intervention of the judge should not be necessary. When it becomes necessary, when the execution is not undertaken, especially for issues that call upon the state to undertake some procedures. And this particular case, we thought that the judiciary system could help in this case. Number two, the model law is only proposed to ensure that there is harmonization in all African countries, because if each African country comes up with their law, with their own law, we might have a different implementation mechanisms, while what we want is to ensure that the execution of the court's decisions are executed in a uniform or a harmonized manner across the continent. Now, given that we need to head towards harmonization of laws or practices at the national level, the African Parliament has a role to play related to its mandate. But given that there's a question that is also of importance to the court, the development of this kind of law needs the involvement of all stakeholders, the committee, the commission, as well as the academia, civil society. So it should not only be the job of the African Parliament. Now, with regard to the countries that already have such laws, Professor Murray responded to this question, but I would like to say that there's a similar type of laws in some African countries. You'll agree with me that a certain number of our countries, like the DRC, Cote d'Ivoire, Kenya, South Africa, have the implementation laws for the Rome Statute that also have clauses on the implementation of international decisions. We have some countries that also have implementation laws of the decisions that have been undertaken at the UN level. So we can get inspiration from all this. Now, my sister Grace asked a question of the quantum. I think Professor Murray answered this question. but is need to have an arsenal of alternatives to ensure that the judge that understands the principle and that needs to execute the decision understand what they need to do, but at the same time to have the possibility of going back to the court whenever necessary to get interpretation. All these opportunities should remain open, given that the judge does not touch on the content, on the very content of the decision of the African court. Thank you very much.
Thank you. I had one question from Grace, the Deputy Registrar. Yeah, so my ultimate recommendation really is that the Executive Council, which is mandated statutorily to more seriously take the role envisaged under the court protocol, essentially creating the structures and the frameworks for it to have the capacity to actually execute its supervisory role. So similar to what the Council of Ministers in the European system does, because Article 29 is pretty much similar to Article 46 of the European Convention on Human Rights. And as a starting point to adopt the framework that has already been proposed, which provides for a step-by-step procedure, including what will be the role of the African court in that context. And here it's good to acknowledge that the court actually has started by having an implementation unit or individuals who already are collecting data on the extent to which decisions of the court have been implemented. But also ultimately, one of the structures that the Executive Council or the AU will need to adopt is the technical unit within the within the African Union Commission that actually on its part also does the supervisory role. Because the PRC and the Executive Council is composed of politicians, but they will need a secretariat level support that helps them actually conduct that supervisory role. In the Council of Europe, there is the Department of Supervision of Execution of Judgments of the European Court. That department is the one that does the day-to-day heavy lifting of the analysis of what extent have the countries actually complied with the judgments of the European Court. So a similar structure within the African Union Commission that is embedded to the Executive Council or the PRC. That is really the role that I envisage that would complement what the court is already doing in terms of gathering data. But then at the political level, a similar structure that helps the implementation and the compliance process. Thank you.
Yeah, thank you very much. The question to me is from Justice Sandukam. Yes, so Justice said Dennis J is right. The country of Ghana does recognize international decisions and international judgments, and the laws I quoted, the Court Acts and the High Court Civil Procedure actually provide for how decisions that are made from foreign judgments can be executed. But the law is silent on execution or implementation of decisions or judgments that are made by foreign tribunals, such as the African courts. And because there is no provision in our law as to how to execute judgments of these foreign tribunals, the country is handicapped. You can see the willingness of the state, the willingness of government to implement or execute judgments. But they are handicapped because the law hasn't provided for any procedure. And so we say that there's no coordinated mechanisms for implementation of foreign judgment, decisions of the African court in our laws. And that is where the civil society organizations, plus the focal point and other people are needed to help get the institutions that have the mandate to amend our laws to make provision for execution of such decisions. And like I said in my presentation, the cooperation is very good and has started very well. We just have to continue the way we started. And I'm sure the next time we come here, we will report on what we have completed and how Ghana is responding positively. But yes, the state is willing, but the state is handicapped because the law does not provide for how that execution can be done.
All
right. I think I have two questions to respond to. The first one, I will take responsibility if, in course of my explanation, that
Peut-être que je n'ai
point
pas
was
très bien
not made
expliqué.
clear. It's not intended to say that
On ne voulait pas dire
decisions of
que
the
les
court
décisions de la
related
Cour
to the,
doivent être dirigées
different actors
aux différents
embedded in the
acteurs
state structure. No.
intégrés au niveau de la structure de l'État.
Definitely the decisions must
Alors,
be
les
directed to the
décisions
state as a
doivent
unitary
être
entity,
dirigées
even though
à l'État,
the whole processes
même
that
si
lead to
les
final
différents
ratification
processus
of international treaties
qui permettent la
may also
ratification
be
de
by
traités
the
internationaux
advice and a lot
peut se
of
faire
homework by bureaucrats and
par
technocrats
les
and all
bureaucrates,
that.
les
Therefore, the
technocrates, les
president now
experts
stands
dans
as
différentes
representative of the
structures.
state.
Et
In terms
le
of
chef de l'État
ratifying, the
est
state
représentant.
appears as a unitary entity. However, in follow-up, my emphasis has always been on follow-up. When you want to follow up on decisions, you don't need to look at the state. Otherwise, you may not really be able to know who are the non-compliant actors. And you need to identify these persons in order to pile pressure, in order to get the public to know who is the blocker. Otherwise, you will just be talking and talking. And in most cases, when you think that the president actually listens to your complaints, you may be also missing the point. So it is the people that will let them know that, okay, there's something going on the internet. Your attention is drawn to it. And there are a lot of business and a lot of dialogue that happens back home, you know. So that's why I said that we need to untie it. We need to let it open so we know who and who, and then begin to direct our pressure to those persons. In response to the second question, one of the uniqueness of this model is that those era where government begin to resist the activism of NGOs and human rights activists is already addressed by this model, because sometimes you don't even know where the pressure is coming from. In social media, you don't know who is who. The hashtag may not just be attached to any real name. It's just a movement, is a community. So then you will just see it trending. Every one day it goes faster, and it gains the attention of people, and the idea is to shame the government. And so it depends on how you are able to frame the issue. Otherwise, the eternal human rights activists who should have been exposed to government resistance may even be covered by this model, because you don't know who is who. And so that's really the point. I hope this makes sense to us. Thank you.
Thank you very much. The REACH panel, I think, has enabled us to see points of collaborations between the court, PAP, in taking forward the issues of the model law, to fine-tune the nitty-gritty details and make sure that the mandate of the court is properly incorporated in the model law. We have received submissions on the role of the Executive Council, but also perhaps to add on how the court can also engage the Executive Council and the subcommittee on human rights, democracy, and governance as an entry point to lobby for the submissions that have already been made to complement the implementation. Finally, our former member of the committee, Professor Beniam, used to say, the committee is not an activist committee, but an active committee. And it applies, I think, to all the organs. The court doesn't have the mandate of activism as much as the CSOs do. So that complementarity of having the advocacy bit of it from the other stakeholders, including the use of the social media platforms by other actors, has come out in a good way. And please, another round of applause to our panelists. Justice Stella still wants the floor. I cannot say no to a judge. So a final comment, but from there we'll end the session. Thank you.
Thank you very much. Thank you for indulging me. There's a point raised by the Deputy Registrar, which I believe the panel has addressed, and I think it's so very important, because we're looking at the role of other actors in the implementation of the decisions of the court. Who are the other actors beyond the court, clearly, or the state parties? I think one major one, as she said, is the use of this peer-to-peer review. Because I recall regarding the Maputo Protocol, the Banjul Commission had to require that state parties in their periodic reports should allude to how far they have complied with the Maputo Protocol while rendering their periodic reports before the commission. It became mandatory. So you must tell us, while you are reporting as a state party, how far you have gone towards the implementation of the Maputo Protocol, that is the protocol for women. And then also, I also recall that before the United Nations Human Rights Council, where we also make periodic reports, also of importance is the report on ONCAC, the anti-corruption protocol. Each state will report on how far they have complied. So it becomes mandatory. So now what are we saying in essence, which I believe is what Madam Grace is saying, is that why countries are making their periodic report, these are our sister bodies, other actors, like the Banjul Commission, even PAP, and other bodies that we have reporting obligations to, they should insist that reports should be made on compliance with the decisions of the African Court. I think that will go a long way as well. Thank you.
Yes, thank you very much for that recommendation. I think it will be flagged by the papers that that will incorporate this comment, but also in moving forward, the organs, the committee, the commission, PAP, APRM, ECOSOC, perhaps need to sit down and further calibrate on how we can take this forward, maybe have a joint framework. That's something that can be considered as an outcome as well for this session. Thank you very much for your attention. For the panelists, over to the main moderator. Thank you. Yeah, a round of applause would be good as they go.
I think they deserve something better than that, don't they? Thank you so much, distinguished panelists and the moderator for such a wonderful job. You'll all agree with me that that was a very enlightening start that we've had with session 1A. And in case if you're wondering if it can get any better than that, then I would like to tell you to hold on to your seats, because that was just the first part. We're just about to get into the other sessions that are going to take it to the next level. So, honorable judges and distinguished delegates, so we are about to dive into the next session, which will be 6B on the agenda. And I would like to mention that we won't be taking a break, just so that we save on time. But the good news is that you actually don't need a break to grab your coffee. You can just quietly slip out and grab a cup of coffee. Just make sure you don't walk out in large numbers so that we still keep things going on. Think of it like a secret mission, something like James Bond, but of course with a minimal espionage and more espresso, so that we can keep the sessions with high energy, the discussions flowing, and caffeine levels even higher. So now let's welcome the amazing, the next amazing panelists for the next session. And I have a list of 4 panelists who I'm going to welcome to the stage. The first one is Dr. Victor Ayeni. Please, if you may take your seat on the stage. Second is Patience Sitole. And then Dr. Jennifer Haven Mike. And Professor Diego Agulo. Professor Diego Agulo. And this session will be moderated by Esther Mnaro. So I'd like to welcome them all to the stage. So namaliza. So thank you so much. So Esther Munaro, for those who don't know her, she is the program manager at the office of the CEO at the Pan-African Lawyers Union. She's an active litigator, holding over 10 years of post-admission experience, such as litigating before the Kenya National Court and currently litigating before the East African Court of Justice, as well as the African Court on Human and People's Rights. So let me welcome, without much further ado, let me welcome Esther to take over from here. You have from now until exactly noon. Please.
Thank you, Guilford. Please clap for Guilford so that he gives us funding for the next meeting. Thank you. Honorable judges, Honorable Deputy Registrar of the African Court, Ms. Grace Kaikai, distinguished guests, our donors. It's very important to mention donors, by the way, when you come for these meetings. Otherwise, we will not have anyone to pay for our tea and our water. Good morning. It's still morning. Are people here? Good morning. Good morning. Misha, good morning. So I will introduce our first panelist. We have so many doctors in the room. I think I'm going to make sure that I go back to school, because every time I look at the program, I'm like, these people are younger than me, and all of them are doctors. So the doctors, please mentor me, so that next time I'll also be Dr. Munaro. So Dr. Victor Ayeni is a senior lecturer on sabbatical at the Faculty of Law at the Nkule Ajasin University, and twice visiting research fellow at the University of Hamburg in Germany, inter alia, among other things. I can't go through the entire biography because it will take the whole day. Dr. Ayeni, over to you.
Good morning, honorable judges, participants. My presentation, it's actually going to be very brief. I'll be speaking on a topic that has been flagged in the last session, and that is the possibility of a collaboration between the African Commission and the African Court. First of all, let me start by saying that implementation is actually a collective problem. It's a problem that is common to all international human rights bodies, so it is not unique to the African Court. So my proposal this morning is that the solution lies in collaboration and cooperation. So what I intend to do is to make a proposal or a list of things that the court could do in conjunction with the commission in order to enhance implementation of the decision. And just before I do that, let me say this, that collaboration and cooperation is actually the keynote of human civilization. Whenever humans face difficult challenges, collaboration and cooperation is the method of overcoming them. Now, I identified 5 problems that the court is currently facing. Now, we have spoken about all these problems in the course of the session: non-ratification of the protocol, failure to make the declaration, the sudden withdrawal of the declaration, and then non-compliance with decisions, and curiously, failure of states to file reports. You know, so I'm going to speak about these 5 problems. When you look at it, these problems have statistical implications. You know, for example, when in 26 years, the court is able to have 12 states make the Article 34.6 declaration, that could mean that we have 1 declaration in 2 years. And by implication, before all the African Union member states who made the declaration, that could be in more than 100 years from now, if we go at the rate we are currently going. So I believe that is a problem that needs to be addressed. Of course, the withdrawal of the declaration limits access to the court. It sets dangerous precedents for those member states that currently make the declaration. It promotes resistance, contestation, and non-cooperation. It undermines the role of the court on the continent. So, having said that, I've mentioned that implementation is a general problem. We have discussed the status of implementation yesterday. So I'll be speaking a little bit about what is implementation monitoring. Implementation monitoring basically is a process of gathering information about the status of implementation. The purpose of that exercise is to ensure that what the states, the actions taken by the state, satisfy the requirements of the decision. So, of course, who should monitor? This was discussed yesterday. I propose here that for monitoring, the victims, the applicant, NGO representatives should monitor. That is one, civil society monitoring. The second level of monitoring is monitoring by the mechanism itself, that is judicial monitoring. Then the body, the political body that sets up the system should also monitor. That is political monitoring. I guess that we talked about all this in our various sessions yesterday. Just before I jump to the need for collaboration, these are the theories, because I want my proposals to be guided by the theories. The theories of human rights law compliance. One, that states comply when they do cost-benefit analysis, when there is something there for them to gain by complying. Then secondly, and this is very important, is states comply when they are persuaded to do so, and when there is repeated interactions. The principal theory there is the transnational legal process theory. So, and as Professor Rachel Murray previously said, compliance is not automatic. The fact that the court makes a decision does not mean it will be implemented. At the international level, there is a need for a process, and that is why collaboration is important now. So, and there are two layers or two pathways to ensuring that there is compliance. One is the enforcement model, which is being mentioned in the Council of Europe. But in Africa, as Dr. Japhet Begun has mentioned, the Executive Council is not doing much. So it's been suggested that there is limited prospect for political monitoring on the African continent. So that leaves us with the second model, the discursive model, persuasion. So soft power diplomacy and repeated interaction. That is what the Inter-American Court is using. That is what the United Nations Human Rights Committee is using. And that is what I'm recommending that we should also do. We should also use in Africa. But how do we go about this? Number one, the court should continue to work with the Executive Council and other AU policy bodies to realize the enforcement model. That line of action should continue. The second, the court should continue to work with states to develop their capacities and implementation infrastructure. That was highlighted by the representative of the Commission yesterday. That line of action also should continue. The third line of action is that the court should look inward and develop a set of follow-up mechanisms in order to monitor the implementation of its decisions. However, there is a plan. It's been argued that because of the judicial nature of the court may be constrained in the number of promotional and dialogical engagements that the court could have with states. And in this area, the Commission and the Commission has actually done quite well. So I'm making two models of collaboration. The first model is that the court should consider working with the Commission and the committee on a number of areas. The second model of collaboration is what Justice Anuka has mentioned previously, that the Commission or the committee on their own, in their various processes, can highlight non-implementation of the decisions of the court. So we have two models. Why am I making this case for collaboration? Number one, research has shown that the three major human rights bodies in Africa, they have different strengths and weaknesses when it comes to implementation monitoring. So
you have 2 minutes.
To start from there. Yes, thank you. So, of course, we have talked about the ineffectiveness of political monitoring, the failure of states to file reports, And the fact that Article 2 of the protocol requires that there should be complementarity, so on the basis of complementarity, we can discuss collaboration. So some of the areas I've highlighted includes, number one, that we should have collaboration in the following areas. I'll just mention them. I'm going to leave the floor open so that you can make more suggestions. Number one is state reporting process. I'm arguing that the commission, as was mentioned by the Deputy Registrar of the Court, the commission could, in considering state party reports, highlight cases of non-compliance with decisions of the African Court. Then the second area is in the area of implementation monitoring, implementation hearing. Number one, during implementation hearing, the commission could highlight cases of non-compliance with decisions of the court. I'm also arguing here that it should be possible for both the court, the commission, and the committee to hold what I'm calling a special implementation hearing. For example, we see in Kenya, there are cases, the Oget case, you know, we have the Endorois case, the children of Nubian descent case. They all highlight issues of indigenous people, and I think it's possible for these three bodies to come together and have a discussion with one country so that is also possible. Then another area which has been mentioned, I don't know, okay. Yes, is special mechanisms. The commission has a lot of these, and they have done a lot of work. So I think the special mechanisms when they visit countries can also highlight non-compliance with decisions of the court. I also mentioned that we can consider the possibility of a joint mission by the court and the commission to some countries. It could reduce cost, it could increase efficiency. Again, other areas, just to wrap up, there could be a joint study on implementation of decisions of the courts and the commission. And I want to argue that the engagement with the Executive Council ought to be collective. It should not be taken by the court alone. Then the engagement with state actors to build their capacity and implement domestic implementation infrastructure also should be collective. So all the institutions should work together. So just in 1 minute, what am I recommending? Number one, I'm recommending that the court should collaborate with civil society to build the capacity of states and develop domestic implementation infrastructure. The court should work, should also intensify engagement with the Executive Council and other policy organs, but it should do this in collaboration with the Commission. And I'm also suggesting that we could have joint implementation hearing with the Commission, we could have joint mission, we could have joint study. And finally, that the Commission or the committee can ask questions about non-implementation of decisions of the African Court during state reporting process, during implementation hearing, during missions, during promotional visits. And I conclude this way, that implementation does not depend on one actor or one factor. It is possible for, it is a function of a multiplicity of factors and actors working together in synergy. Alone, the court can do so little, but together, the court can do so much. Together with the commission and the committee, we all can do so much. I want to thank you very much for listening to me. Thank you.
Thank you, Doctor. I will call upon our next speaker, Ms. Patience Sitole. Patience Tandeka Sitole recently completed her LLM degree and is currently a teaching assistant in ethics and jurisprudence at the Witt School of Law. I don't want to eat into your time.
Thank you, Chair. Can everyone hear me? Okay. Good morning, everyone in the room and those who are joined online, especially everyone from back home in South Africa. It is a great honor to be standing before you. I have learned so much from the other speakers, and I hope to also contribute to this discussion in a meaningful way. So as a starting point, I will outline the objectives of this presentation. The first point is to explore the role of actors such as the African Commission, among many others. Secondly, it is to examine instances where actors such as respondent states have collaborated to efficiently implement the court's decisions. Thirdly, it's to look into instances where collaboration is still required. And lastly, I will make recommendations on how to encourage collaborative efforts among the different actors. So the common theme in the role of actors other than the African court in the implementation process is that there's a great divide between theory and practice. I refer to a variation of a quote that one of the esteemed speakers mentioned yesterday. The quote reads as follows: "Theory without practice is sterile. Practice without theory is blind." So to start off with the African Commission, the Commission is empowered to interpret provisions of the Charter for any organization of African Unity member in terms of Article 45(3) of the African Court. This is quite significant in that it simplifies the content of the Charter and it enables state parties to understand their obligations, which in turn encourages such states to implement the court's judgments. In addition to that, the Commission is set to encourage national and local institutions concerned with human rights and give its views or recommendations where necessary. However, this is important, right? But however, in practice, the Commission typically works collectively with the African court only when it brings matters before it, and not so much once the decisions have been handed down. And this depicts the great divide between theory and practice. And to move on to the Executive Council. The Council it ought to be notified of the court's judgments, and it's expected to monitor the execution of such judgments on behalf of the African Union Assembly. And it has a duty to report back to this assembly. However, in practice, the Executive Council has infrequent and short meetings. Additionally, the Council is known for its inaction towards non-compliant states. And this too depicts the great divide between theory and practice. As you can see, there's already a pattern of a divide between theory and practice, like I mentioned before. Thirdly, with state parties, they are also obliged to uphold and give effect to the rights and freedoms of their people. They're also supposed to play an integral role in the implementation of the court's decisions because they are closer in proximity to the complainant and they are oftentimes readily able to implement the court's judgments. However, in practice, such states tend to develop a defiant attitude towards the court and they choose to ignore the court's decisions, again, indicating the divide between theory and practice. Same with the judiciary at a national level. For example, the South African Commission the South African Constitution, rather, in Section 233 asserts that the interpretation of legislation should be consistent with international law. This provision empowers the court to apply decisions of the African Court to domestic matters, which expands the reach of these judgments, and especially for those who are not able to litigate for themselves. For example, the OGEC decision could very well be applied by the National Court to the scenario of the indigenous Khoisan people of South Africa. However, national courts tend to adopt a more conservative as opposed to radical decision-making. South African national courts, for example, often limit their remedial power by making conservative judgments to avoid overstepping or violating the separation of powers, again, depicting the great divide between theory and practice. The last actor that I will mention is civil society organizations. These organizations are empowered to participate and bring matters before the court. This is important because, as mentioned by one of the speakers from before, NGOs sensitize the public using different types of media. And NGOs also play a role in the follow-up processes. However, there's often an issue of red tape that limits CSOs, for example, the criteria of NGOs to obtain observer status is inconsistent, as seen in the African Commission's rejection of the three human rights NGOs application for observer status on the basis that they are not human rights defenders. And this is in direct contradiction to its Article 451 and 2 obligation to protect the human rights of all persons, thus resulting in the NGO's inability to approach the court, and it prohibits them from applying themselves in the implementation process. And this, again, depicts the great divide between theory and practice. I will also speak on the instances where efforts to collaborate have been made. There are only 2 cases, namely Thomas v. Tanzania and APDH versus Cote d'Ivoire, where the respondent state requested the interpretation mechanism of the African court. It is clear that they use these interpretation mechanisms. However, only 2 cases is not enough. Whereas we have instances where efforts to collaborate have not been made, and in these instances overpower the instances where collective efforts have been made by state parties. For example, in the Ogiek case, a progress report was not provided. In Umuhoza versus Rwanda, the state had a blatant attitude where it said that it would not comply with court's orders, and it went to the lengths of withdrawing the competence of individuals and NGOs to file cases directly before the court. I move on swiftly to recommendations. Before I move on, it is quite clear that there's a serious great divide between theory and practice. As I said, there's a continuous pattern of this. However, we can remedy this by the following recommendations. So the African Court can lead the collaborative efforts by encouraging respondent states to use the court's interpretation function more often. Doing so will enable the court to provide clarity and counter any issues that might hinder the implementation of its judgments. Secondly, the African Court can establish follow-up site visits, wherein it follows up on the progress of the respondents, which is a mechanism that is already built into the African Court Establishment Protocol. And next, as mentioned earlier, the Executive Council is quite limited in its engagements with the Assembly. According to literature, the Council and Assembly only meet twice a year, and when they do meet, it is for an hour, which means that not much can be done during this time. Additionally, as mentioned before, the Council and the Assembly have not used any of the enforcement measures that they ought to have used against the states. This calls for changes such as these organs enforcing measures against non-compliant states, more frequent meetings, and the scheduling of such meetings in a manner that enables the Council to communicate all pertinent information to the Assembly. Lastly, the African Commission and the African Court need to collaborate to simplify and create certainty in the processes and criteria against which a CSO's observer status is granted or denied, as this will facilitate the involvement of CSOs in matters that are brought before the court. This means that organizations such as NGOs will be empowered to get involved in the matter and provide the court with the feedback that it requires on how the implementation of the decision is going, which will allow the court to stay informed. In addition to that, the CSOs will also push the respondent states where such state is reluctant or unwilling to act by creating campaigns that will pressurize the respondent state and cause such state to implement the court's decision. That's the end of my presentation. Thank you.
Thank you so much, Patience. She kept it short and sweet. That's what we say in Kenya. Our next speaker is Dr. Diego Agulo. He is an assistant professor of law at Comillas University in Madrid, Spain. You have exactly 11 minutes.
Okay, I think I have a presentation, but I will just, for the sake of time, continue without it. So, hello everyone. It's a pleasure to be here with you. I'm a private international law professor, assistant professor. So I'm learning so much from all of you that are human rights experts and public international law experts. So any feedback that may receive from you is more than welcome, okay? Here and afterwards during the lunch, of course. So my presentation is entitled, Does Foreign Investment Law Care About Human Rights? A look at the potential impact of the African Court on human and people's rights decisions on investment arbitration. So, first of all, regarding the agenda of my presentation, I will make an introduction to the topic, okay, to the relation, why this topic is important. Secondly, I will talk about the relation between human rights and investment arbitration. Third, I will address a very important leading case. Okay, here is the presentation. Yeah, that is the Urbaser against Argentina case. Then I will also address the role of international human rights bodies and tribunals in investment arbitration. I will also mention briefly the African Arbitration Academy BIT model. So we have a BIT model on this as well. And of course, I will finally address the potential role of the African Court on human and people's rights on investment arbitration. So, okay, so investment arbitration has been, as you may know, criticized by academia and by politicians and by many people during recent times, right? What is investment arbitration? So we have an investment treaty between two or more countries in order to protect investments made by foreign investors in the host state. And this foreign investor, of course, is a national of one of the countries that has signed the bilateral or multilateral investment treaty. So even if they have been so criticized, we still have right now over 3,000 bilateral investment treaties in the world. Some of them have been ratified by African states together with non-African states, but we find also many investment treaties, bilateral and multilateral, ratified between African states, right? And some of them are also party to the African Court Protocol, right? Some of these states that have, of course, ratified as well investment treaties. During the last years, so there has been attention has been put to the relation between investment arbitration, this system that we have to protect foreign investments, and human rights. So what's the relation in a scenario of an investment arbitration? Bilateral investment treaties, and this is something important to me, they refer, many of them, to international law in the writing, right? And also, we find many, not many, but some awards that interpret bilateral investment treaty together with other international law instruments, doing a systemic interpretation between the in bilateral investment treaties and other instruments of international law. And of course, this includes international instruments on human rights, international conventions on human rights. So in an investment arbitration, a human rights issue can be alleged by a state as a defense, saying, for instance, I'm a state and a foreign investor has brought a claim against me before ISDS, before exiting the World Bank, and the state can say, look, I withdraw the permit to you to operate in my country because I'm applying an international instrument in human rights, or because you are not complying with human rights, right? And I have to withdraw these permits because this is my role as a state, make human rights enforced, right? There is another element here important, that is the other way around, the regulatory chill that we find sometimes. That is a state not implementing human rights laws, right, most of them, and this is something that is happening regarding a right to a clean environment or climate change laws, because of the fear of having an investment claim brought by a foreign investor, right? Also, of course, a human rights issue can be brought by a foreign investor in a claim, right, against the states. We have foreign investors that are also individuals, right? And they may say, look, you didn't protect state my foreign investment, but you also didn't protect the human rights that I think that I have, and I'm alleging before this investment tribunal. And something interesting is counterclaims brought by states. So a state can bring a counterclaim against a foreign investor, and here I bring the Urbaser against Argentina case. So in this case, we have a counterclaim. So this case is based on a bilateral investment treaty ratified by Spain and Argentina. So we have a Spanish investor, Urbaser, that made an investment in the province of Buenos Aires, of Great Buenos Aires, based on a contract. The investor was supposed to provide clean water to a given population in the city of Buenos Aires. So, you know, there were problems between the investor and the country and Argentina. So the investor said that Argentina was making so difficult the investment, was putting a lot of impediments regarding the investment, and brought a claim before the World Bank against Argentina. What Argentina did, Argentina brought a counterclaim against the investor, also before the World Bank, before this ISDS tribunal, saying that the investor did not comply to the international human right to water, because it stopped providing water to people in Buenos Aires. Okay? So for me and for many, this is something new. Those of us who come from the civil law perspective, we study public international law as a law that is applicable to states, to international organizations, and to the relationship between them. But here we have Argentina claiming that, you know, an international law, the national human right to water was not being complied by a private party, by a company called Urbaser, in this case, a Spanish foreign investor. So what did the tribunal, the investment tribunal, said in the award? Something very interesting. They applied Article 31.3.c of the Vienna Convention of the Law of the Treaties regarding the systemic interpretation of the treaties. They did the systemic interpretation, the bilateral investment treaty between Argentina and Spain, and international law, including international human rights law. And they said that this thinking that many people have, that international law does not apply to private parties, is something old, right? That the new trend is to apply international law also to large corporations. But it said something, you know, it narrowed it a bit. And it said, well, the state has, of course, is obliged to comply with international law, with international human rights law, also in obligations to perform, right? To perform in order to make these human rights compliant. But the private party has not an obligation to perform, has an obligation to abstain from committing acts that would go against human rights of the other people, right? But this decision has been used in dissenting opinions, for instance, made by Philip Sands, by Professor Philip Sands, and he's been cited so much during last years, from 2016, that we have this case, and investment tribunals are applying human rights and human rights instruments together with bilateral investment treaties, right? In this case, it said, look, Urbaser, the foreign investor, didn't have an international law obligation to provide clean water to the people of Buenos Aires. But this obligation was contract-based. So, okay, we discuss if this contract was complied or was not complied, but this is not an international law obligation, but only a contract-based obligation, right? So my point here is, okay, what is the role of international courts and tribunals in this investment arbitration thing that I'm bringing here? Well, international courts and tribunals do apply and do interpret international law, right? And international conventions and international treaties on human rights. And the decisions, the judicial decisions of these international tribunals on human rights are part of the legal framework of international law, are international law, okay? So if investment arbitration tribunals apply human rights, they should follow the decisions of human rights bodies and tribunals. The thing here is that I found citations in quite a number of awards to the European Court on Human Rights, to the Inter-American Court on Human Rights, but I have not found citations of the African Court on Human Rights, even in investment arbitrations, where an African state is a party, right? It's the respondent. And the citation to the European Court of Human Rights is often made even in investment arbitrations where the respondent is not a European state. So they are cited as authority, right? So I go, and I will come back to this afterwards, I go to the point that investment arbitration and human rights are so related, and that we have to interpret investment bilateral treaties together with international law. And of course, we have to apply human rights in investment arbitration. So here we have a model, BIT, that was published by the Africa Arbitration Academy and has been produced by many scholars, African and non-African, that propose that the future bilateral investment treaties that should be signed by African state contain specifically, a mention to human rights that should be complied with foreign investors. So no need of systemic interpretation, just the bilateral investment treaty itself provides the application of human rights in case there is a dispute that arises out of this bilateral investment treaty. What's the potential role of the African Court of Human and People's Rights here? Well, first, in order for investment tribunals to apply decisions on human rights, this has to be cited by councils, okay? And arguments by councils, either the councils of the party of the foreign investor or the council of the state, should argue in the pleadings, right, in the writings submitted to investment tribunals, human rights arguments, right? If not, the investment tribunal will not or will rarely decide on something that has not been cited by the parties, right? And another thing is arbitrators, right? So who appoints arbitrators? The state and the party. So my recommendation here would be either if there is a human rights issue that benefits the state or that benefits the foreign investor, it can be both, appoint an arbitrator that is well-versed in human rights, that knows the decisions of human rights tribunals, that knows the decisions of the African Court on Human and People's Rights. And there are decisions very important that will be very important for investment arbitration, for instance, regarding climate change or the right to a clean environment that could be raised in investment arbitration right now, in the disputes that we have right now, okay? So that's why I say here, by who? Okay, so it is not spontaneous, the application of human rights in investment arbitration proceedings should be raised by councils and, of course, should be applied by experienced human rights arbitrators. And that's the role of parties, either investors or either the states. So, just final remarks. Let me check if I can. Yeah. I have here an unpopular opinion, right? I have a professor in my department that says, do not write on investment arbitration because it's so criticized, it's so unpopular, and it will be ended. We will have another thing, but not investment arbitration. But I still write on this, okay, and I still research on this. So I think that investment arbitration has, and we find out there many bad, investment arbitration awards, but I think that it's a good system to apply human rights. It's independent, right? We don't have, the state is a party. If an investor is a party, they can appoint arbitrators, and there is a lot of room to apply international law and to apply international human rights law in investment arbitration. So, of course, here I won't address this one, but you know that the Exit Convention, the Washington Convention, provides for automatic enforcement of the decisions that have been, issued regarding ISDS in the World Bank, and these decisions should be treated as if they were, according to Article 53 of the Exit Convention, national decisions. It's quite unique in the international law world, according to me, this thing. And also, please, states, councils cite human rights in the investment arbitration, appoint arbitrators that are well-versed in human rights when this is an issue in the investment arbitration. And of course, arbitration tribunals should know and should apply human rights decisions raised by councils, and of course, should apply, if raised, the decisions of the African Court on Human and People's Rights. Thank you very much.
Thank you, Dr. Diego. Another doctor. Those who are not doctors in the room, be challenged. My next presenter is Dr. Jennifer Heaven-Mike. Dr. Jennifer Heaven-Mike is an assistant professor of law at the American University of Nigeria, AUN, Yola Adamawa. You have exactly 12 minutes.
Thank you very much. Good morning, ladies and gentlemen. It is an honor to stand before this exalted audience to give my presentation on the challenges to implementing the decisions of the African Court with specific regards to the economic, social, and cultural rights. A lot has been said today, and I'm here to contribute my quota from another angle, the angle of economic, social, and cultural rights. But before I start off, let me give a little analogy to get you into my presentation. So imagine that you were all locked out of your homes, your accommodation last night. You will not be here today. And that is your right to shelter. Imagine that I was standing naked in front of you. No, not literally. But imagine that I had no clothes to put on to come into this hall. I will not be allowed into the building. This is my right to clothing. Imagine that I had no food to eat yesterday. I will not be talking in front of you today. I'll be shaking. I'm only standing here today because I have a job that has given me the pedigree to develop the ideas that I have today. The only reason why we're here today is because we have been educated enough to develop the ideas that we're sharing today. And what does that tell you? That economic, cultural, and social rights are very, very important. Everybody can relate to it. I'm ashamed to say that I didn't vote in the last election. I was unable to get my voter's card. And so I'm not really that concerned about some of my civil and political rights. But you see, my economic, cultural, and social rights, they are very, very important to me. Unfortunately, states have shied away from implementing economic, cultural, and social rights to catering to these rights. Now, the African Court is in a wonderful position to assist us, the masses. In fact, it is said that the African Court is the last hope of the common man. The establishment of the African Court has signaled a positive direction in clarifying the concept of economic, cultural, and social rights, because it is said that it is very difficult to implement these rights. Apart from the resource constraint, it is said that these rights are a bit vague. Now, the courts are in a position to clarify or to establish standards for the enjoyment of these rights. And I think the African Court is doing well. A friend of mine said something yesterday, and I'm going to repeat what he said. He said, the African Court is doing well. The states are not doing so well. I think the African Court is poised to give adequate expression for the respect, protection, and most importantly, the fulfillment of economic, cultural, and social rights. However, a court is only as important as its impact. The court can make as many decisions as possible, But if the court's decisions are not adequately implemented, I use the word adequate. If they are not adequately implemented, then it is an exercise in futility. And so I'm here to highlight some of the challenges to implementing the court's decisions. Now, for economic, cultural, and social rights, it's a bit different. Most of the discussions in this room, I'm afraid to say, have centered on civil and political rights. And if you look at the decisions of the African Court, most of them have been on civil and political rights. For economic, cultural, and social rights, there are additional reasons. Some may even say justifiable reasons why they are not being implemented. And my presentation sort of highlights some of the resistance to this implementation. The first one has to do with resource constraints and capacity. When I talk about resource, all of you can relate to this if you're a human rights activist or a scholar on human rights. We all know the challenges that economic, cultural, and social rights faces. Resource constraints. A lot of states have said, we simply cannot cater for this. We are African countries, we are developing nations. We can barely survive on what we have. We do not have the money to start setting up hospitals, to start establishing schools and giving free education to youngsters. We do not have the money to start by giving you clothing, establishing shelters, and so on and so forth. Unfortunately, this has been some of the excuses that states have also adopted in refusing or failing to implement the decision of the African Court. My argument is that resource constraint is not really a genuine argument, a genuine justification for a welfare-oriented state that really wants to cater for the social welfare of their citizens. We all know that some of our African countries do have the resources. It goes without saying that African countries have been endowed with natural resources. If only we can channel some of our resources, even if it is progressive realization. So gradually, you take one step, you take another step towards implementing the decision of the African Court. Yes, we all understand that it is difficult to implement economic, cultural, and social rights, but it is doable if only states can realign their budgets. Unfortunately, states are unwilling to take that adequate step. That step of realigning their budgets to the respective ministries, taking those additional measures that will effectively cater for economic, social, and cultural rights. Then again, you have technical expertise. Implementing the rulings of the court on these rights would definitely require technical expertise and administrative capacity. Yesterday, some government officials did tell us some of the challenges that they have faced in this respect. And so it is an ongoing challenge. And states can simply rely on this excuse to say, we do not have the expertise, and so we cannot implement this particular decision. Again, you have competing priorities. I was made to understand that there's someone that can help with the slides. So you have competing priorities. African countries have diverse economic priorities. Where I come from in Nigeria, we're struggling with insecurity. And so the bulk of the budget goes to security. Some nations would rather invest in elections. I cannot tell you how much has gone into the last election that we had and how much they're still investing in the next election. Unfortunately, economic, social, and cultural rights is at the bottom of the list. Again, you have the legal challenges. The lack of domestic incorporation of pertinent human rights instruments has limited the effective realization of economic, social, and cultural rights. Not many African countries have adopted important instruments such as the Conference on Economic, Social, and Cultural Rights. Some have not adopted CEDAW. Even when they have signed and ratified it, you also have the issue of the issue of domestication of these particular instruments. We were arguing yesterday whether or not Nigeria is truly the giant of Africa. Whether or not you think it is, I think it is. I'm from Nigeria. I will defend my country. However, Nigeria is not able to domesticate an important instrument like the Covenant on Economic, Social, and Cultural Rights. CEDAW has not been domesticated in Nigeria. The African Court has the mandate to make decisions relating to rights contained in other human rights instruments in addition to the African Charter. Unfortunately, when a decision is made on those instruments that have not been domesticated in a country, it's very easy for the government to rely on lack of domestic application of those particular laws. Let's look at the African Charter. A lot of countries have adopted the African Charter, a lot of African countries. However, even at that, there's this conflict of laws, conflict between municipal laws and the African Charter. Some may argue that the African Charter exists on the same level with other municipal laws and their constitution reigns supreme. The problem with that is that if the constitution does not make adequate provision for that particular economic, cultural, and social right, then you have an instance where a country may feel we have constitutional limitation. Let me give an example with Nigeria. There are very beautiful provisions on economic, cultural, and social matters in Chapter 2 of the Constitution. However, there's a little bar to the enforceability of those provisions. The African Charter is part of the Nigerian laws. It has been domesticated. But there's been arguments in certain quarters that the African Charter should be subordinate to the constitutional provision, and so we should give true reference to the constitutional provision that limits the justiciability of certain economic, cultural, and social matters. I am of a contrary opinion. I think the African Charter is part of the laws in Nigeria. Unfortunately, our courts have shied away from clarifying that particular position of the law. It will be important for the African court to give us a clear legal interpretation of the position of the African Charter within a national context with respect to constitutional provisions. It is very, very important and imperative that we have a legal clarification of this, because states can choose to come up with this as a clog in the wheel of implementation. Again, we have political and institutional challenges. We have weak governance. Do I need to go into corruption? Corruption is a clock within which a lot of African countries have wrapped themselves around. Like I said earlier on, it's not the absence of resources. Sometimes it's misplaced priorities. And these countries may be unwilling to fulfill their obligations because they will rather use the means towards other vested interests rather than catering for economic, cultural, and social rights. I'll give you an example. In my state, the governor has been building flyovers. We call the governor Mr. Projects, because he will rather build physical projects where the media will come, appreciate him, rather than building schools for the children roaming around on the streets, rather than building hospitals. And so weak governance has actually undermined the implementation of a decision that an African court may come up with respect to economic, cultural, and social rights. Again, you have unstable political environment.
Please wind up.
Okay. The rise in military coups in African countries can actually undermine the rule of law and the implementation of the decisions of the African court, as new regimes may not prioritize or respect the court's decision. Then again, you have lack of political will. We've said lack of political will so many times in this room. For me, political will is political interest, public interest, and interest in adequately catering for these rights. To say, the right of my people to eat today, to have something to eat today, to have a place to lay their heads on today is very, very important. It's as important as the right given to these people to vote me or to vote other people into power. What are the strategies for improving implementation? I've actually identified three. Number one, it starts with the African Union. We need to emphasize the respect for economic, cultural, and social rights. In so many circles, human rights circles, we lay little emphasis on these categories of rights. We put them at the bottom of the chain. These rights are as important, and for me, even more important. And so the African Union should have a public awareness, should have more discussions on these sets of rights, and if possible, call for the domestication of these rights within national contexts. Again, I've called for more judicial activism on the parts of the African court. I would love to see the African court making more pronouncements on economic, cultural, and social rights. If nothing, to clarify the legal contours of these rights. So what are the obligations of the states to these particular rights? Even if states do not implement, even if they do not comply, it is also important to clarify these particular rights, to make pronouncements on them, so that you can establish a standard another state may choose to adopt. Because when you make a decision on economic, cultural, and social rights, it does not only apply to the parties, it applies to the whole of Africa. We've seen examples of this being done. In the case of Samiti against the state of West Bengal, the Indian Supreme Court made a proactive pronouncement, took judicial activism further by linking the right to health to the right to life. If I'm on the hospital bed, nothing else matters to me. And so the African court, I think, in my opinion, should seize the chance, no matter how small, no matter how little, to make a pronouncement, or to kind of assist in the obligations that states are expected to meet with respect to these categories of rights. And then most importantly, domestic implementation, domestic legal reforms, to ensure that these rights are justiciable at the local level. Raising awareness is also important. I noticed that not many decisions have been made on economic, cultural, and social rights before the African court. Perhaps the citizens are not aware of their rights, do not know how to go about it. With more awareness, there will be more cases being presented before the African court. My colleagues have said so much about civil societies' engagement, engaging them. The case of Sarak against Nigeria gained prominence. Why? Because the civil society was quite active in galvanizing attention towards that case. And the Nigerian government was compelled to implement that decision because of the involvement of the public in that matter. This is something that we need to do. We in here in the building, we're just...
Please clap for them one more time. I will welcome interventions, but before I welcome the interventions, as I sat there, I kept thinking of how many meetings I've attended where we talk about recommendations on implementation. And I just wondered, is there any representation of any of the states in the room? By a show of hands? From the government? I just have one question. Do you take these messages back home? Do you go and tell the states, do you go and tell the government that the people of Africa are not happy, that when they get decisions from the African Court, from the African Commission, that they don't get implemented? Because unless this message is being delivered to the rightful people, we will keep having these conversations. We'll come next year. We're going to give recommendations. We'll come the year after that. We'll keep having like musical chairs. So there's need for us to think through, what more can we do? How do we get these messages to them? Do we invite more of them to the room and call them out that they've not implemented so that the message goes home? Or what do we do? Because we can't keep having the same conversation. I welcome interventions. I'll start with the honorable judges of the court, if you have anything.
Thank you, Madam Moderator. The first one is the last speaker, and we thank them for their presentations. I've enjoyed them. Yes, the last speaker was talking about the fact that the African Court has not determined matters with respect to economic, social, and cultural rights. The African Court has delivered some cases from that end. And the only issue here is that if the cases are not brought before the court will not have the opportunity to pronounce upon them. And the court has come out clearly that the International Covenant on Economic, Social and Cultural Rights is part of our law. It is part of the human rights provisions that we enforce against countries. So, Ghana raised a point, not in respect of this one, in the case of Oyomi, that they had not, Ghana has not domesticated a human rights provision, and therefore we cannot use against them. The African Court held that the domestication is at your national level, but when it comes to the African Court, it is the human rights provision that you have ratified. And once you have ratified, whether it is domesticated or not, it is immaterial, and the court will hold it against you. So the African Court enforces the economic, social, and cultural rights. But if cases have not been brought, that is the problem that we are having now. Now, then another interesting one was how to use investment in arbitration to promote human rights. Another very, very interesting area. But I listened to the theory, and it sounds very good. But my question is, at the end of the day, the state and the investors, wouldn't they be interested in their interests rather than the human rights aspect? If that one could be harnessed to educate us that if that is done, they will suppress their interest. But we know human beings as we are. We enter into trading activities to enrich ourselves and not to look at human rights interests of other people. Thank you, Madam President. Madam Moderator.
Thank you. Let me join Justice Ajay to also commend the panel for a job well done, and indeed have brought to us many, many new insights. I particularly like the linkage between the BIT, the foreign investment, bilateral investment treaties, vis-a-vis human rights, and the case cited by the presenter. We appreciate that, and we hope that we'll have such application before us where we'll have to make such linkage in the deliberation of maybe an application that will be before the court that relates to bilateral investment treaties. I also want to just say regarding the last presenter's paper that indeed the theme for the year in the court, that's the theme we have for the year. Every year we have a theme. Is actually enhancing the justifiability of economic, social, and cultural rights, with special emphasis on the right to education. So indeed, it's a thing of concern for us that we need equally to promote economic, social, and cultural rights beyond political and civil rights, which seem to be most of the rights that we have had cause to deliberate on, based also on the applications that have come before us. That being said, we take note of all that has been said, and we'll see how we can integrate the ideas that have been raised while we are having our deliberations, and even why at the end of the day we are looking at the outcome of this entire conference. And it's my hope that we are going to have to issue a communique, and that communique, I want to believe our colleagues from the states, representing the states, should go home with the communique that will be released at the end of this conference, so that they will be able to pass the message down to relevant decision-making bodies, the policy makers. So in effect, we can have a new dimension when it comes to the implementation of the decision of the African courts by the main players, which actually are the state actors. I thank you.
Just one thing, I omitted one thing. Yes, in connection with what the last speaker said about the African countries, talking about the fact that financially they are not sound and they are unable to domesticate those laws on economic, social, and cultural rights. Let us look at the treaty itself. If you look at the covenant itself, in Africa, only 6 countries, African 51 countries have ratified. Only 4 have not. Now, when we talk about the 51, only 6 have made reservation. And the reservation, only 3 of them talk about economic problems. We have South Africa, Guinea, and Kenya. Then the 3 others talk about their cultural and religious rights. And the question is, if at the time that you were ratifying it, you did not raise any reservation, can you now turn around to say that I cannot because of this constraint? You cannot. Thank you.
Thank you very much, Judge. Do you have any more interventions from the judges? Yes, Judge.
Merci, Madame la Moderatrice.
Thank you very much. Madam Moderator, I'm not going to come back to what my colleagues have said. I totally agree with them. With regard to the arbitration, up to now, we've not really discussed on any case on arbitration or investments. But I'd just like to say that the most important thing of the African Court, when you have a litigation before us, it has to be linked with human rights. Whatever the source of the problem, whether it's an investment, a contract, property, private or public property, the most important thing is that the allegations that are brought before us have to be linked with human rights violations. If there is any investment that can help in the arbitration, and if it touches on climate, environment, right to property, the right to health, the African Court is going to make a decision on it if it's linked to human rights violations. If it happens that this kind of investment was done with the consent of the state, the most important thing is that the source of the allegation has to come from a violation of human rights. Now, however this violation was made, so is tomorrow we have an issue linked to arbitration on investment. The African Court will actually take that into consideration if it's linked to human rights violation. Thank you very much, Moderator.
Thank you very much, Judge. Guilford, can I ask for only 5 more minutes in case there's intervention from the floor? Any intervention from the floor? Yes, Madam.
Merci et bonjour à tous.
Thank you very much, and good afternoon. I would like to thank all the panelists since morning for their presentations, for their very rich contributions. Now, my comment is linked to what the moderator has said. I would like you to understand one thing. The party states were invited, they responded or present. That's why we are here. So this shows our commitment. We were asked to come to participate, to provide our contribution, and to propose recommendations. And I would like to assure you that these recommendations from this conference are going to be communicated to the right persons. I would like to make a plea, if possible. I think one of the speakers yesterday talked about political will. They were asking what this concept really means and how we can explain the absence of political will or the lack of political will. It's very important to understand that we all have a role to play with regard to the implementations of the decisions of the mechanisms for protection and promotion of human rights. The state has a primordial role, but they have to be supported by other actors. In our presentation yesterday, we talked about some difficulties at the state level with regard to the implementation, the understanding of the decisions of the court. Another challenge we raised was the discussions with the victim with regard to the execution of the decisions. These are a lot of factors that need to be taken into consideration that are going to contribute to improve execution of decisions. If we focus on the fact that it's only states that are not moving without taking into consideration the challenges they are facing, without talking about the weaknesses of other actors, we are going to remain with non-implementation. Let's all contribute to effective implementation. I'm talking about here the states, the courts, other mechanisms of the human rights, civil society, because the failure is not only on the states. The failure is on all of us who are activists on human rights, civil society actors, other actors. Let's act. Let's not only point the finger to one actor. Thank you.
Thank you. I'll give 50 seconds to each of my panelists to just comment.
Okay, thank you very much for the insightful comments and the commendations as well. I just want to say that I agree with the Honorable Justice Dennis that yes, it is true that the African Court has made some pronouncements with respect to economic, cultural, and social rights. But I guess what I'm pushing for is a more aggressive interpretation. So something very powerful, like what the Indian Supreme Court has done. Let's just see clarification, something that we can adequately rely on to say, this is the obligation that the state is expected to follow. Many of the decisions that I have seen have been more of declarations saying, yes, you do have this right, so it is established that this is your right. But we want to see a revolution, so to speak. Let the bench lead the pace in the interpretation and the enforcement of this particular right. So that is the angle that I am actually coming from. And even the Ghana case that you mentioned. So what my presentation is highlighting is that states can always find a loophole to rely on. And even in the Ghana case that you mentioned, the Attorney General went about implementing the decision of the court rather than the African court, ignored the decision of the African court. Although that was eventually addressed, what I'm saying is that another state can choose to use that as a justification, as an excuse. And so there's a need to put a stamp on this to say that once a state has probably adopted the African Charter, its obligations are binding, and to kind of work with the African Union to work around these particular issues. I've not yet gotten how the African court can do this. I'm not putting so many responsibilities on them right now, because I know that they do have a lot to contend with, but I'm saying that it's a gradual step. And with the cooperation of the African Court, the African Union, and, so people like us, there will be a positive turnaround in years to come, if not now. Then again, my colleague mentioned the issue of political will. Okay.
Okay, thank you very much, Honorable Justices, for the comments and the questions. I got one question regarding that the states and investments in investment arbitration, they will regard on the interest instead of the interest of human rights. Well, I think that that's true, but my point here is that human rights is applicable law in investment arbitration. That's my main point. The decisions of the African Court on Human and People's Rights, they form part of the legal framework of international law, and they should be applied in investment arbitration. So for instance, if we have an investment arbitration against a state because this state withdrew a permit to a foreign investor that is polluting and going against the decisions of the African Court regarding protection of the environment, these decisions are applicable to the merits of the case and should be applied by the arbitrator. So I think that the interests are aligned many times, in the application of human rights and the interest of states and foreign investors. And the other question is regarding that that the African Court will discuss investment when it is related to human rights. Yes, of course, I agree on that. Again, my point here is just a point, of a conflict of law assistant professor. Here the applicable law is to the investment arbitration should contain human rights and should contain, of course, the decisions of the international tribunals and the decisions of the African Court. So, for instance, just citing one, the case Ligue Ivoirienne des droits de l'homme and others against Republic of Côte d'Ivoire, that's international law, that should be applied in investment arbitration when we have a similar case regarding the protection of the environment. Thank you.
Thank you for all the feedback. I just have a remark to make. I agree with the respondent states in saying that we cannot put all the pressure on a state party, but it is also insufficient to make the argument that there's a lack of understanding of the court judgment when there's an interpretation mechanism. So there needs to be some type of action on the state's part. It doesn't fall on the court to follow up in the event that a state doesn't understand a judgment. Thank you.
Okay, thank you, everyone. So maybe just to summarize that in all of this exercise, we should realize that we are pursuing the same goal. And in achieving that goal of engaging domestic actors, the court, the committee, and the commission should look for opportunities to work together. And I identified the state reporting process as one opportunity, our missions as another opportunity, implementation hearing as yet another, and I'm sure there are other ways they can work together, but there is no way, there is no other option than collaborating and cooperating. Thank you.
Thank you to all my panelists, and thank you to all for listening. I didn't see anyone sleeping, so thank you for that. Please clap for them one more time.
Thank you so much, Esther, and the panelists for such a great session. As we move into the final panel, we will delve into the fascinating world of advocacy campaigns for individual access to the African Court, the prospects and the challenges. And I'm going to invite the following panelists to the stage. The first one is Dalmerda Daniel Antonio, Technical Advisor to the Minister for Justice and Legislation of Benin. Linda Maheva from Cameroon. Richard John Kilanga from Tanzania. And Grace Wakio Kaikai, the Deputy Registrar of the African Court. You can think of this as the grand finale episode for that session on the of the other actors specifically. I mean, we still have other sessions to go in the afternoon. I mean, this is the only session where we had 3 panels. So to end up this session, which, you know, this is the third panel of it, and leading us through this is none other than Lloyd Covea, who is someone that knows this journey very well, and he is the Assistant Director for Operations Partnership, Operations Advocacy and Partnerships at the Center for Human Rights, University of Pretoria. So with this panel, we will be winding up the session 6. So this is section 6C. Before we can take lunch break, welcome, Lloyd. Please, I'll be up.
50 minutes. Thank you very much. So the danger of moderating a session just before lunch, you're always asked to compress your time. So once again, so anyway, thank you very much, distinguished delegates, honorable judges, comrades and friends. We have a panel of 4 presenters on the issue of access to the court. Before I hand over to the panelists, I just wanted us to look at 34.6 of the court protocol, just to read it, and get to understand it intrinsically. And it states that at the time of the ratification of the African Court Protocol, or any time thereafter, the state shall make a declaration accepting the competence of the court to receive cases under Article 3 of the protocol. Now, this is addressing, individual access or access by NGOs. What is fascinating about this provision, and I don't know if Dr. Biegon is here, he is one of those people who raised it at a discussion somewhere, that the ratification of the protocol is optional. But what is not optional is the signing of the Article 34.6 declaration, if you read it carefully. So in other words, once you have ratified, you have an obligation to sign Article 34.6. I think the getaway clause that states always utilize in this provision is those 3 words, or any time thereafter. You see. So now states will then say, okay, I've ratified, so I can sign the Article 34.6 at some stage. And the problem is that we don't know when this will happen. And there are only 2 countries that have done the ratification and the signing of the Article 34.6 declaration at the same time. Only 2. Burkina Faso in 1999, and Malawi in 2008. Now, I'll tell you just a small story of how Malawi managed to do that. There's a gentleman called Pacharo Kadira in Malawi who was working in the Ministry of Justice at the time, very passionate about international human rights. Now, at the time when Malawi was hosting the African Union Summit, he approached the president and said, Mr. President, we can't host the summit when we have not ratified the protocol and we have not signed that Article 6 declaration. We have to, otherwise we'll be embarrassed. And so the president, I think, saw a reason in his argument. And he then said, okay, let's go ahead with the ratification. And then he says, we must also do the declaration. He didn't tell them that it can be done anytime thereafter. He says, we must do it now, because the provision is saying we must, at the time of ratifying, we must sign the Article 34.6, So he was a bit clever, in his argument, and the president agreed. I don't know in Burkina Faso, the land of the upright men, how it happened. But, what is disturbing is that you've got countries that did the ratification more than 20 years ago, and the question is, what are they waiting for? That is the question, and I think this is one of the issues that we want the state delegates here to address, okay? I mean, I'll give just a few examples. South Africa ratified in 2002. It's been 22 years. Why is South Africa still waiting? Nobody knows. And with what I think Nigeria, these are the heavyweights on the continent. 2004, it's been 20 years since the ratification. Why are they still waiting? Now, one of the things that the former president of the court, Justice Sophia Akufo, she was the third president of the African court. How she got Ghana to sign the Article 34.6 declaration. When she was appointed judge of the court, she was one of the first judges of the court in 2006. I think she was getting uncomfortable. You know, she was sitting in this court, and yet Ghana, you know, has not yet signed the Article 34.6 declaration. She decided to take it upon herself now, and she approached the Attorney General. She says, Mr. Attorney General, why are you still waiting to sign the Article 34.6 declaration? Are you waiting these are your very words. Are you waiting for horses, for donkeys, I mean, to develop horns before you decide to sign the Article 34.6 declaration? So the AG was also embarrassed. He says, oh, no, Judge. At that time, Justice Akufo was a judge in the Supreme Court. He says, okay, look, if you don't know how to do it, I've prepared the instruments for you. Here they are. Make sure that the Article 34.6 declaration is done. So in 2011, before election as Judge President Court, Ghana then proceeded to sign Article 34.6 declaration. So I mean, these are just a few anecdotal stories I just thought, you know, we should share as we get our panelists to present. So we'll start with my sister from Cameroon. I think Cameroon ratified in 2015. I was just saying to her that President Paul Biya has been in power, what, is it 42 years? Or is it 40 years? I don't know. And if we go by what Justice Ajay said, next year there are elections in Cameroon. Perhaps if there's a new leader, we might get the Article 34.6 declaration. But anyway, Madam, I'll give you this opportunity to present. And just tell us some of the challenges that states are facing in doing the Article 34.6 declaration from the perspective of Cameroon. Thank you very much. You've got 5 minutes. Again, we've been given, okay, we'll give you 7. I think you've got a lot to say, 7 minutes.
Thank you for the introduction. Okay.
I'd like to thank the moderator for these clarifications that have been given. This helps me actually to change a little bit my presentation in the program. When I saw this, I was a little bit lost. We had not been well informed in advance, and I didn't really know what was really expected of us. But now that we're here to share experiences with regard to the ratification of the protocol, the declaration, as well as perspectives. Cameroon ratified the protocol in 2014. The instruments were deposited in 2015. And since September 2015, we are parties to the protocol. But Cameroon has not yet signed Article 34.6 to ensure individuals and civil society organizations to go directly to the court. Why has Cameroon not signed? I would like to explain our processes with regard to international engagements each time that Cameroon plans to ratify text. There is a procedure law. The major issue here is the opportunity. Why? We ask ourselves, why do we need to ratify this text? And so it needs to be looked at from different angles, especially the weight of this text regard to other texts. When you look at the protocol on the creation of the court, we link it to the role of the Commission. But not only that, we also link it to other mechanisms of the promotion and the protection of human rights. Now the question we ask ourselves is to understand why we need to ratify the protocol or the creation of the African Court. What is the advantage? What is the added value this court is going to give compared to other existing mechanisms, and with which Cameroon has a good collaboration, even with regard to the implementation of the decisions coming from these organs. That's why we looked at the clauses of the protocol while also looking at the competences we have, and with direct comparison with the Commission already has a role with regard to protection and promotion of human rights that is founded on the Charter. The court has what role? The role has another role that's linked to the Charter but goes beyond. This role is linked to other instruments, other legal instruments for promotion and protection of human rights on the African continent. So there's a difference by reading the different clauses. We can commit to do that. But with regard to the declaration, should Cameroon sign or not sign? Now we come back on the collaboration between Cameroon as well as other mechanisms. Similar, more or less similar mechanisms, because the court and the other mechanisms is not the same thing, but we have some similarities. And looking at these aspects, we tell ourselves, we're going to take the case of the Commission, for instance. We work with the Commission. We work with the Commission. We've been doing that for quite a number of years. We implement the decisions of the Commission. The Commission has its competence with regard to human rights founded in the Charter. Cameroon already does what is expected of it. Try to do what is expected of it in terms of protection or promotion of human rights now. Why go to the court? Right now, especially right now. After ratification, why didn't we do that? We needed to understand how the court functions and to have a better idea of its activities and the scope of its activities. So we took a position to wait before signing the declaration to observe what's happening. Yes, it's true. We've been waiting for a long time. I understand. Now, it's time to think again. The court has given judgments. We need now to take a position, and we need to advise the state to try to see how to go forward. And so I would like to thank the measures taken by the court to identify national focal points in each country. I'm a focal point. I'm one of the focal points of Cameroon. within the African court and would like to talk to you about the reality. I knew the protocol. I knew the court. But I had not even gone to the website of the court. I had not yet looked at any decisions of the court. It's through this meeting that we were given a list of decisions of the court. I started looking at them yesterday, and then I started to understand. The discussions we had yesterday also helped me understand. You know, we had a lot of discussions. We saw different comments from different actors, academia, judges. So this helps us to have a better idea of what the court is, what the court does. We need to continue to sensitize us. We as focal points, we need to keep on learning to prepare all the necessary arguments to ensure that our states, our political leaders make informed decisions, because we also involve a political dialogue. Now, to conclude, I would like to once again thank the court. The Cameroonian focal points are looking at this issue to see are ready to continue dialogue with the court, make sure that the court teaches us, sensitizes us more on its role, on its functions, and to help us to come up with arguments that we are going to present to our superiors as advisors of the government. We look at things from two angles. The court formulates the declaration, the advantages and the disadvantages of signing. We need to ensure that the focal points have necessary tools to have the necessary arguments. When we talk about giving them tools, giving tools to focal points, we need to focus on the added value. Because the politicians are going to tell you, we're already doing that. We're already doing that, so what could we do more with the court? Yes, individuals can go to the commission, and the work of collaboration is on with regard to the implementation of the decisions, recommendations of the commission. So why go towards the court? This is a question we need to be able to answer. When we are asked with our superiors, we need to undertake advocacy at the national level. And of course, the Commission also needs to undertake this kind of advocacy. I would like to thank you for your kind attention.
Thank you very much. And that's why we want to understand the behavior, the thinking of states, you know, the issues of political will that have been already pointed out, you know, so for us to come up with advocacy strategies on how we can get more ratifications, more signings of Article 34.6 declaration. The challenge, I mean, we all know that only 34 have ratified, 12 did the Article 34.6 declaration, 4 have withdrawn, and we're only left with 8. So essentially it means that the only countries that can be sued by an individual or NGO, there are just 8 in the entire continent. And I think this poses an existential threat to the court. Why should we have a court, you know, that where only 8 states can be sued? So the court might actually not have any cases to deal with if we continue at this rate. But so I just want to perhaps ask Judge Antonio, if you, okay, maybe okay, since you're not, I'll talk to my brother from, you can't hear what I'm saying, interpretation, or maybe you need the, okay, I'll go to my brother from Tanzania. Tanzania is one of the 4 countries that have withdrawn the 34.6 declaration. Maybe you can share with us why Tanzania decided to take that decision, and is there a possibility that Tanzania, is there an opportunity for Tanzania to come back? What are the challenges? Why did that happen? You have 5 minutes just to give us your 5 brief points. Thank you.
Good morning, everyone. Thank you again for being privileged to get this opportunity to address this conference, which is full of practitioners, honorable judges, state representatives, and academicians. The moderators just told me that I should only stick to the reasons which led Tanzania to withdraw. As you know, Tanzania also was one of the countries which had a declaration to accept the competence of the court. I think it was in 2010 and withdrew in 2019. Some of the reasons were given yesterday, as we discussed yesterday. So I'm going to repeat some of them and only add one of them. So Tanzania was, when it deposited the declaration, it was of the views that some of the issues would be left to the Tanzanian authorities, because we know there is a principle of margin of appreciation in some of the issues, even under the human rights regime, margin of appreciation. So the two things which we thought should be left to the national is the issue of nationality. This is one of the contested issues in Africa, but also in Europe, on the issue on what should be considered when to decide who is a national of Tanzania. And this has been decided in various cases, like Robert John Penesis, Anudo Cheng, Onyango. So that was one of the issues which Tanzania was not very much satisfied with the decision of the courts. Another issue which also I highlighted yesterday is concerning the origins of the case, which mostly have been filed against Tanzania to the African courts. Majority of the cases which have been filed in the African court originated from the criminal cases which were decided in Tanzania, and most of them went up to the Court of Appeal of the United Republic of Tanzania. But when the cases reached the African court, the decision went against Tanzania. And most of them, the reasons was for failure for the United Republic of Tanzania to provide legal aid. Most of them. So the court decided, among other things, that the United Republic of Tanzania should pay reparation for failure to provide legal aid. Because at that time in Tanzania, the legal aid, according to the law, was provided to the most serious offenses, which is murder. But some of the applicants were charged with armed robbery and rape, which were not among the offenses which the country was obliged to provide legal aid. So that's the another case which Tanzania made to withdraw his declaration to the African court. Similar to that, we thought that the policy in Tanzania is that the public policy, you cannot reward a criminal who has been convicted by the court of law. So when the court order that the Tanzania should pay reparation to a criminal, that is contrary to the public policy. Suppose an unarmed robber person who has been convicted, or a rapist has been convicted, and the court has gone up to the Court of Appeal. Now the African court is saying that because we failed to provide the legal aids, then we have to pay reparation to the victim. The last reason which I would like to address today is concerning the applicants who are facing the murder charges. According to the law of Tanzania, murder is a legal sentence which is valid. But not only in Tanzania, but also under the convention CCPR, it is in line with the Constitution of Tanzania that murder is not prohibited. It should be only provided with procedure governing the law of the country. So the court now is saying that because Tanzania has not abolished the death penalty, then it is infringing the human rights of the victim. So the Tanzania is still going on to assess it is a decision to withdraw, and we've been meeting with the court. Last year we met twice. One occasion we met in Arusha, and another meeting we met in Dodoma. So we are still assessing our situation in the country, but the country also is improving its criminal justice system. So when we finish improving the criminal justice system, maybe in the future we may come back to the court. But for now, we have first to clean our house. Thank you very much.
Thank you very much, Mr. Kilanga, for your presentation. And I think what is coming out is that so Tanzania was not really happy with the decisions coming from the court. I think it's one of the reasons why Tanzania then decided to pull out. And now it's working on, correcting some of the things that emanated from the decision of the court. And hopefully, Tanzania will reconsider, and come back to the court. Mr. Moderator, there's a complaint that's been raised by the state delegates. They've stated that every time that they come to present, their time is taken away from them, and yet others are being given 10 minutes every time. But when it comes to them, the time for presentations is cut short. So I'm proposing that maybe the 10 minutes that you took away from the state delegates, will you give it back to them so that they can also speak for 10 minutes that has been awarded to every other panelist. Is that in order, Mr. Moderator? Thank you. Thank you very much. So I think you'll have an opportunity to, in your right of reply, to have more minutes rather than just 1 minute. Okay. Thank you very much. We now move on to the third speaker from Benin, Daumeda Daniel Antonio. You have 10 minutes to give us your presentation. You may also talk about the reasons why Benin pulled out and whether, it will be coming back to the court, and what are some of the challenges and opportunities you have faced. Okay. You have 10 minutes.
Merci, Monsieur le Modérateur.
Thank you, Moderator. Hello, everyone. Benin, after the revolutionary period, had had a lot of instability. And then we had all the rules, all the instruments were ratified, were applied in such a manner that all the rights were applied. But Benin was the first to sign the declaration and all the international instruments. And this enabled the citizens to seize freely the African court. But after the expiry of all the local remedies, and this means that today the influx of the remedies internal level in terms of protection, all the violations undertaken. I would like to talk about the abusive actions. A judge who, decides to prolong a case, a citizen who does not get fair justice. Therefore, the Constitutional Court issued a lot of decisions to facilitate the work for the African Court. So, when a public administration officer violates the rights of a citizen, this victim can seize the institutional court. And once this happens, then they can issue a decision. So the Institutional Court of Benin, since its creation after the Fossville Conference, decided that the court will go further and recognize violations of human rights and ordered that there should be repressions. And the court was even forcing the arm of the civil courts. And therefore, there was a case where a lady who was pushed, and the court, for example, estimated that this was an infringement, and therefore the country was supposed to pay the lady for the incident. Therefore, the decisions are taken and offer or issue decisions to ensure that the judges do not violate the Constitution. So all violators could no longer to position themselves. So when we did this declaration, there were certain citizens who did not have confidence on the judges of the country. It's possible, but since the law enables that every time you are a victim, you can always seize the court. And of course, there was this influence, especially after the elections, or where a presidential candidate, I'm going to give the case of our compatriot Ajavo, who seized the African court several times. So several judgments were rendered. He was given the benefit of doubt by the tribunal, and there were issues of terrorism, and of course those people who were condemned, sentenced at the court, and it was estimated that the judges did not obey the law. An obligation, every citizen has an obligation to ensure that they finish with all the local remedies before seizing the African court. As said yesterday, there was this decision that was condemning Benin to pay reparations to the gentleman to ensure that the family members are being paid. The Beninese constitution had not foreseen this. And therefore, people were supposed to go to the Supreme Court before going the African Court. And therefore, seizing African Court, saying that there is discrimination, there is no legal instruments. Benin is a good student and therefore reformed the law. And therefore now, once you are not in agreement with the judgment issued, then you can always go to the appeal court, just like the former Minister of Justice said. During the visit by the African Court, the former minister observed expressed his being unhappy to the African Court. There was some kind of suspicion. Every time a Beninese citizen seizes the court, whatever the explanation or the complaint, Benin always suffers. So this was part of the reasons that pushed Benin to withdraw the possibility of its citizens to seize directly the African Court. It's true that we had noticed this, but we did not have, this was a political decision that was made. So what we recommend is that there should be some strong recommendations, and the court, when it visited Benin, Russia was part of the delegation, and the court requested Benin to review its position. And we are happy that last year there were several states that did the declaration, and I think we need to use all the mechanisms probably to amend things so that this be an obligation to enable all citizens who feel oppressed to be in a position to seize directly the court, and this is for the good of the African people and for better development or evolution of the court. Because when you're in a country where you have no total confidence, then this, of course, raises a lot of problems. I think the possibility of African citizens to seize the African court is something that can be used to measure the liveliness of democracy, because we will see that people who thinks that somebody is not, leading the country well, then they're going to seize the African court. But we need to have confidence to the judges who constitute the court. The former head of state decided to create the union and then the court, and therefore it is now up to the political persons to respect what they created. In our country, we have what we call the voodoo courts, and therefore, once you create your voodoo court, then you have to respect it. So this is the message that I wanted to share, hoping that with the discussions, Benin, just like other countries that withdrew, might now return to the court. Thank you very much. As I said, we were not informed in advance that we were going to make a presentation. Otherwise, we would have had more information to build in the presentations. Thank you very much.
Presentation from Benin, and we hope that Benin will reconsider, coming back to the court and afford access to individuals from Benin to approach the court should they seek access to justice after exhausting remedies at the domestic level in your courts in Benin. I'll now call upon Madam Grace Wakio Kakai, the Deputy Registrar of the Court, to give a presentation on the challenges and opportunities on the issue of access to the court. You have 10 minutes, Madam. Thank you.
Honorable judges, excellencies, ladies and gentlemen, good afternoon. So I'll go straight to the presentation on the advocacy campaign on individual access to the court. Now, the approach is to give you the terrain regarding ratification of AU treaties, and then specifically on the protocol, and make some recommendations. So an overview of ratification of the OAU and AU treaties, just to have a background on this. Some figures here are important. We have a total of 76 legal instruments that have been adopted under the aegis of both the African Union and the OAU, the precursor to the AU. 24 of those instruments were adopted during the time of the OAU, and 52 have been adopted since the AU came into existence. And out of these 76, this total of 76, 59 require states to ratify them. The rest are usually, they enter into force when the Assembly of Heads of State and Government adopt them. And then out of these 59, only 35 have entered into force, these treaties, leaving a total of 24 that are pending entry into force. And of course, we all know that the decision to ratify is the state's prerogative. And again, on average, AU treaties take about 5 years to enter into force. And because of this challenge, some of them take quite a very, very long time. As you well know, recently this year, Angola became the first state to ratify the Malabo Protocol after 10 years of its existence. So it's a very, very slow pace, but on average, it takes about 5 years. And because of this problem, the AU decided, the Executive Council of the AU in July 2012 established a ministerial committee on the challenges of ratification or accession and implementation of OAU treaties. This committee was mandated to develop a plan of action to enhance ratification and implementation of these treaties. And the rules of procedure of the committee were adopted in 2014 in Malabo, Equatorial Guinea. And under this decision, pursuant to this decision, member states are required to establish national sectoral committees on ratification and implementation of treaties. I don't know how many states have these committees in place. We don't have the figures yet. Now, regarding the protocol, the status, as we all aware, only 34 AU member states have ratified it. This represents 62%. Will not go into the details of the states. That is accessible from many public sources. And as has been mentioned previously, 8 are currently having the declaration under Article 34.6 in effect, with the 4 states having withdrawn those declarations. So we come to the importance of the ratification of the protocol, ratification or accession. Why is it important? It is proposed that it helps in monitoring states' human rights protection obligations, determination of the human rights disputes, and providing reparations for human rights violations. And it kind of indirectly improves operational capacities of domestic institutions in providing redress to victims of human rights violation, to avoid them resorting to international adjudication or treaty monitoring bodies such as the court, and generally enhance protection of human rights. What are the main issues hampering ratification of the protocol? So the AU commissioned a study to look into this question on the domestication and implementation of OAU and AU treaties. This was carried out between 2018 and 2020. So this study revealed several issues, several factors that contribute to limited ratification of the AU treaties, including the protocol. The first category relates to political constraints. That is particularly issues of safeguarding national interests and sovereignty. I think this has been talked about since yesterday. And what is coming out is that states are more likely to ratify treaties if the anticipated benefits align with their domestic agenda, political agenda. If they do not, they would hesitate to do that because they might not see what is in it for them, or they are uncertain about the legal implications of doing so. They may also prioritize ratification of treaties in sectors other than human rights, which they may deem more beneficial to their interests. And again, their reluctance may be driven by the desire to control excessive scrutiny of their situation by numerous human rights monitoring mechanisms at the UN, AU, etc. The second leg of this theme, this category of political constraints is there's a complex ratification and domestication procedures in some domestic systems, depending on whether you're monist or dualist, or depending on your political legal structure. So this can also impact on can make the process to be very protracted. And it could also, domestication of the treaties ratified could necessitate complex normative and institutional adjustments within the states, which makes it quite burdensome for them to even think about it. So this could also be a challenge. The second level is B, financial constraints. The process of treaty ratification and domestication can be difficult because it requires some significant intellectual or technical and institutional resources to facilitate understanding and domestication of the treaty, which could be a financial burden for states. So that might be parked while awaiting the resources to become available. The third category is knowledge or information constraints. There could be lack of awareness by state officials, as the Honorable Representative from Cameroon has stated. State officials, citizens, civil society, and other stakeholders may not be aware of the benefits of ratification of the protocol, or even the process to be followed to engage the government, for the government to follow, or to engage the government in regards to the ratification process. As the moderator explained in the anecdote, for the Judge Akufo had gone with the sample ready to provide to the Attorney General in case that information was not available to them for the process to be kick-started. So that is also something as basic as the format of that declaration can be a challenge. Again, insufficient level of awareness of the court's mandate and what the protocol portends, particularly misconception that once the state ratifies the protocol and deposits the declaration, anyone can file cases directly before exhausting local remedies. This is something that could be an issue and could be preventing a ratification. So what are the inconveniences of law ratification? It means the very slow pace. Dr. Yeni had earlier given us a figure. I'll use a similar analogy. At the rate we are going, we'll need 21 more years to attain universal ratification of this protocol because we are getting one ratification a year additional. Then there's inadequate judicial monitoring of the human rights obligation, limited jurisdiction, obviously. Now, what are the strategies and perspectives for accelerating ratification? The court has had direct engagements with member states on ratification during the visits, sensitization visits, and during AU policy organ meetings. It has also sent correspondence to member states to appoint the national focal points. So there are 23 so far. And it's interesting to note that out of these 23, 5 are from states that are not state parties to the protocol. These are Cape Verde, Central African Republic, Botswana, Liberia, and Zimbabwe. So it means, although they are not parties to the protocol, they might be willing to engage with the court in a broader context of human rights protection. Then we could liaison with the ministerial committees that we mentioned and borrow experiences from other ratification campaigns. Here we have in mind the Maputo Protocol, which took 2 years to enter into force, way below the average of 5 years. And then get in touch with national sectoral committees on ratification where they are there and provide them the input or knowledge products for them to advocate for ratification. And organize or participate in national consultation meetings around this question. As well, NGOs to form very strong coalitions in this regard. Just, Mr. Moderator, one interesting thing I just checked on the AU website. Burkina Faso signed, well, I guess they had to deposit the declaration because the protocol was adopted in Ouagadougou. Maybe that was yes, maybe that was, but an interesting dates. The Burkina Faso signed the protocol on 9 June 1998, the same day it was adopted. However, it ratified it later, maybe because of the procedures involved. That is 31 December 1998, and deposited the instrument on 23 February 1999. However, it had signed and deposited the declaration earlier. They had signed the declaration on 14 July 1998 and deposited it on 28 July. So, interesting thing, I just saw that. They were willing to deposit the declaration before the disposition of the instrument of ratification. I will leave it at that. Thank you very much.
Thank you very much, Deputy Registrar, for your presentation, quite comprehensive as well. And so now we have 10 minutes before we have to end so that people can have lunch. I'll open up for any comments, inputs on what can be done to accelerate ratification and the signing of the Article 34.6 declaration. I think we've heard the views of the states and also what the Deputy Registrar has shared in terms of the efforts of the court as well to reach out to states. So I'll first of all give the opportunity to Judge Afia to also give your input.
Thank you, Moderator.
We'll start with Judge Adele.
Thank you, Moderator, and thank the presenters for the good work done. I would like to start with Tanzania. The African court has not held that death sentence is illegal. That is not the position of the court. It is the dissenting opinion of only 2 of the judges. Our position is that a state can still go ahead and execute unless the state has ratified the second optional protocol of the ICCPR. And Tanzania has not ratified, and therefore we cannot hold against them. So it is a dissenting opinion. Two of us. I'm not one of them, but 2 of us. Now the second, yes, 2 out of 11. And the second one is that maybe it is in respect of Articles 4 and 5. Article 4 provides that there shall be respect for life. Then 5 talks about inhuman and degrading treatment. Then the ICCPR, if you read it as a whole, what it says is that once it is a serious offense, then the person the judge must be given the option to decide. So here, what the Tanzania law, including my own country, Ghana, is that once you are convicted for murder, then mandatory imposition, death. It is the mandatory imposition that we are talking about, and not the death sentence, that the judges should be given the opportunity either to say, I will give life, I will give number of years, or death. That is what we are talking about. And the second one is that Ghana and Tanzania, we do the same thing. Whenever we impose death sentence, then we follow it up that the person shall be sentenced to death by hanging. But if you look at Article 5, hanging is degrading and inhuman. So why do we impose such a sentence? So that is why we fault you, and not the fact that death sentence is illegal. That is not the jurisprudence of the court. Now, having said this, Ghana too, well, at the time Ghana ratified the protocol, Justice Ofoye Akufu was the vice president of the court. Gerard was the president. He was the vice president of the court. And she contributed, no doubt. But at that time, the Attorney General of Ghana, Betty Mood, was a woman who was a human rights activist, who even taught me. So the two of them put together to persuade the then president, who was also a lawyer, who also taught me to sign. So all of them contributed. Yes. Then the Benin Republic of Benin, the problem is with Ejavon. But we must always understand that when a matter is before the courts, the judges may go this way or that way, depending on the reasoning. And Ejavon case, even though I wasn't a judge, I have read it. That was the opinion of the court, that it is A, B, C, D. Now, if we think that if judgment is not given in our favor, then we are losing confidence in the judges. Please, it is a wrong misconception. Even at the national court, I am a national judge. I can give a judgment against my state. The state may not be happy, but to say that because of that, the state will not have confidence in me. So in that case, can the state say, go ahead to say that they will not list a case before me, because when the case is brought before me, this is my position. I'm very radical. I think it is unfortunate, and we should all come together. Now, Cameroon, if you look at Cameroon, at the court, you have a judge, you have the registrar. When it comes to interpreter, you have 70%. And still, if the court is not visible in Cameroon, then it is surprising. Yes, the court must be visible, because we, even including me, I complain that why should 70% of interpreters of the court should come from just one country when we have 55 countries? And if still the court is not visible, then to me it is a bit surprising. And the fact that you have ascended to the African Commission, Banjul Commission, and you don't know the importance of the court. The Banjul Commission exercises quasi-judicial power, and the court exercises judicial power. That is why the court was established to complement the role of the Banjul Commission to exercise judicial power. So here we want citizenry to have unfettered access to the African court. That is the essence of the declaration. So if you have not deposited declaration, what you are saying is that nobody in the country, even if the person exhausts local remedy, can seize the court. And the intention of the African Union was that let's give access to everybody in the country whose human rights have been violated and cannot seek redress, or has exhausted local remedy, and the person thinks that yes, my rights have not been exhausted, or my rights have not been well addressed, and therefore I will seize the African court. So that is the rationale. Thank you, moderator.
Thank you very much, Judge. In fact, when President Zuma was sent to prison by the Constitutional Court, he forgot that he had not signed the Article 34.6 declaration. And he was now saying, no, I've advised my lawyers, they are going to the courts. And he was reminded, but you did not sign the Article 34.6 declaration. So there we have it. I think unfettered access to the court, you have to sign the Article 34.6 declaration. Thank you very much. Any other inputs? Yes, Judge Afika.
Merci, modérateur. Et je remercie.
Moderator, thank my colleague. I had the same thing, but I'm going to reiterate. I would like to say, to speak to what the representative from Tanzania said. Towards the end, I said we are waiting before to go back to the African Court to rectify our, to clean our house. This is a very good thing. Yeah, they have noticed that there are some things that can be cleaned at the local level, and when you do this, we will be happy to receive you back at the African Court. If Tanzania, comes, we should be able to receive them well. Now, I would like to understand something. We are a human courts, right? And that means that poor, rich, the assassins, and so on and so forth, will all have to benefit from human rights. The human rights are not only for the rich or those who do not do anything criminal and so on and so forth. Why is it for the criminal as well? Because this is a national law. The national law must be absolutely in line on certain fundamental principles. When you have a refugee, an illiterate, an indigenous person before a judge, and they do not know how to read, and they say, for example, if the thing has taken 10 years or 6 years, then they have no right to a judge. Even a national judge will be not at ease to deal with a person who cannot defend themselves. This is how we need to look at things. These are not cases against Tanzania or any other country. What we are saying is that, please, there are principles that you have ratified the treaties. There are so many principles that you need to include in your national laws. And this is a message to everyone. Why Tanzania has a lot of files? Because our court is in Tanzania, and yeah, it means that Tanzanian people are not as illiterate as we may think. They are coming to defend their laws. So if this court was in my country or in another colleague's country, we would have seen many more cases from that country. So we would like to ensure that our African countries, big countries who really be the first to ratify treaties to protect the populations. Now I have a question to Benin and Tanzania. Are you ready to come back with a conditional declaration to come back to the court? This is a question for you too.
Thank you very much. Any other inputs before I give it back to Judge Ankam?
Yes.
And then we'll give it back to the panelists. Thank you.
Yes, I also wish to appreciate the panelists for the frankness and for their sincerity in telling us actually why they had to withdraw. But one thing that cuts across to me, or that becomes so clear to me, is the fact that it seems as if the judgment of the court sometimes is not well understood by those who are expected to implement. For example, this issue of mandatory imposition of death penalty. I think the judge, Justice Ajay, has cleared that. I hope the person representing Tanzania will take that back home, that we still continue to implement the Article 4 of the African Charter that actually recognizes death penalty, because what the article says is what we interpret and what we apply. And it says no one may be arbitrarily deprived of his right, recognizing that human beings are invaluable. Every human being shall be entitled to respect for his life and integrity of his person. The only caveat there is that no one may be arbitrarily deprived of his right. So when you have a law already in place that recognizes death penalty, we don't have a problem with that, so long as you are not a signatory to the second protocol. But what we are saying is that you can't remove the discretion, the judicial discretion of the judge to say, now, having had the defense and maybe the claim for leniency by the accused person, that it must be death by hanging. That is the issue. So we want you to revisit our decisions before you come so hard on the court. And the issue of margin of appreciation. The court actually does recognize the fact that state parties, domestic courts, they have the margin of appreciation. That is why we don't go to the level of analyzing how you call witness number 1, number 2, except where there is gross miscarriage of justice. That is when we step in. So we do recognize margin of appreciation. And some other issues, the issue of the free legal aid, it is not the creation of the court. You are a signatory to the ICCPR, and it says provide free legal assistance. You are a signatory to the African Charter, and it also recognizes as part of the fair trial rights provision of legal aid. So that is the issue. So we are not rewarding rapists, neither are we rewarding murderers. No, and I think that conception should be changed. That's not what we're doing. What we are saying is that if this accused person is entitled to be provided with legal aid and you fail to do so, there's a violation. And that is as simple as that. So we are not rewarding rapists and murderers. No, that is not the intent. But one thing that gladdens my heart is the fact that the dialogue is still continuing. We are still engaging with Tanzania, and we are ready to engage with, I think we are already also engaging with Benin. And we are engaging and still engaging and ready to engage with those who have withdrawn, with the hope of better understanding and bringing them back. And I'm so glad that we have received assurance from the representative of these state parties that they intend to come back. Why? Because it's for the benefit of the citizens. It's not about us. It's not about you. I think it would be narrow-minded to only think of yourself, or you as president now, like it happened in the case of Zuma. No. If you cannot get access to justice within your domestic setup, the idea is you have an international court that may be able to redress your grievances. That is, it's as simple as that. It could be Mr. A today, it could be and Mr. B tomorrow. So once we have opportunity to advise government, please, let's do so without bias. Let's do so with the intent of the Charter in mind, which is to protect human rights, and we are all supposed to benefit from that. Let's not be short-sighted. Thank you.
Thank you very much, judges. I'll just give the panelists 1 minute each to reply, because we now have to go for lunch. I'm really sorry about that. So 1 minute each, and then we break for lunch. Thank you. I'll start here.
Thank you, moderator. I didn't have any specific question directed to me, but yeah, so it's just, I've also noted the concerns we've also noted the concerns raised by the meeting. Thank you.
Merci.
Thank you. Well, last comment from me. I would like to say that the discussions that we've just had show rather that there's a lot to do to complement the work done by the court. There's been some misunderstanding, a lot of misunderstanding at the state level. It's not enough. Not only enough to understand the court exists, we need to understand what the court does and what it can do. So we need to keep on learning. We need to keep on advocating and to ensure that we give the focal points the necessary tools to help us sign the declaration. I'm talking about the countries that have not signed the declaration. We need to give them tools to have the necessary arguments to make us move forward. Ratification of a document can take many years. ratification can take many years. And it's only through sensitization, awareness training, advocacy that will make things change. I thank you very much. I would like to thank the moderator and the judges, colleagues. I've taken into consideration the different recommendations for Benin. We need to see how to move forward on this and how we are going to take these messages to our authorities once we're back at home. But we don't have the power to decide. We're going to make propositions, suggestions to our authorities to explaining the importance of coming back. Personally, I was about actually to go to the African court because was going to be transferred without my consent. And so actually this is going to help us actually promote democracy. If there is an organ that does not provide justice, there should be another organ that should help us. Yesterday, we saw that it's true, the decision of the court are well-founded. But what I said yesterday, I said that the judges were a little bit already not taking into consideration that the victims had not taken into consideration all the local remedies. In Benin, if in Benin, for instance, the Supreme Court did not make a decision or a judgment in good time, and which makes the victim now to go to the African court. In its decision, this should be clearly explained that they decided on this because the Supreme Court did not actually decide in good time. And from time to time, we would like to have some training initiatives from the court to the different experts, the different actors, to ensure that everybody is sensitized. You see, when citizens are confident that justice works properly in their country, they are not even going to care about going to the African court. So we really need to sensitize the justice actors, and this would help us move forward. Thank you very much.
Okay, thank you for the comments and the response from the judges. I just forgot to say that I've taken note of all the concerns of the judges, and since just as I have said that we are still making dialogue with the court, we will continue to make dialogue with the court to see on the way forward. But also I've said in my presentation area that we are cleaning our houses. There is the commission, Presidential Criminal Justice Commission, which was formed and has already presented this recommendation which are being worked upon. And one of the issues which is being worked upon is the issue of death penalty. So we are still assessing the situation, and once we are ready, the relevant authority will do the necessary action. On my side, I will not be in the position to say we will come back, because that is not within my mandate. We are just experts. We are giving opinion. There are relevant authorities which are mandated to make the final authority on whether to redeposit or not. Finally, I would like to reiterate what I commented yesterday regarding the decision of the Executive Council, which we are giving on 2nd and 3rd February 2022, which required or asked the court also to consider or to appreciate the reasons for the 4 states which have withdrawn their declaration. That's all. Thank you very much.
I would like to thank the state delegates and the deputy registrar of the court for your very good presentations and your honesty, and also for the frank deliberations and discussions, which I think are fruitful and will have given us a way forward. Thank you so much. May we give them a round of applause as I invite the moderator. And apologies for eating into your lunch. Thank you.
Thank you so much, Lloyd, for that good work, and also thank you so much to the panelists. We have a case of time inequality on our hands from the state delegates, but we want to assure you that there is no conspiracy to take away your time, because everyone wants to hear from you. Your contributions are very crucial in this discussion. I believe the judges want to hear from every one of you. But we beg for your understanding as we try to manage time, so that we don't take up time for the other sessions as well. So we will now break for our well-deserved lunch, and we will have to make it a bit short so that we redeem a little bit of that time. We will have it for only 45 minutes, which means we will start the next session at 2:25. So please be on time so that we give enough time to the panelists that are presenting in the others. We have got 2 more sessions in the afternoon, which you don't want to miss. So please don't be late. See you at 2:25. Enjoy your lunch. Bon appetit. Good afternoon. Please take your seats. Welcome back from lunch. Okay, we will start. I hope we have the panelists here ready. I see the moderator for that session, and one of the panelists is already here. So please, yeah, you may begin making your way already, so you don't have to wait for me to call you. So welcome back to the afternoon session, and I want to believe that you had a good lunch, you enjoyed lunch, you had a sumptuous lunch, and you had a good chance to mingle with other distinguished delegates and to recharge. So welcome back for the last afternoon session that we're going to have. For this session, which is panel session 7 on your agenda, we will be focusing on the discussion on the broader influence of decisions of the African Court. And I think this panel session promises to delve into how the court's decisions resonate beyond the immediate cases and impact, and impact on the broader legal and human rights landscape. And guiding us through this important discussion, before that, let me just call upon the other, I think we have both of them. So the first panelist is Dr. Satang Nabena, who is going to be online. I believe she is. She has been waiting for us, by the way. Thank you so much, Dr. Satang, for your patience. And then we have got Dr. Irene Thomas and Dr. Upina Petrotas. I'm just hoping that I pronounced your name right, sir. And then Dr. Cristiano Dorsey. Please take your seats. And taking us through this panel is none other than Professor Nkada Murungi, the acting director of the Center for Human Rights. One of the organization that I think is the mastermind of this conference, and of course continues to do a lot of work supporting the regional human rights bodies. And therefore I believe with the insightful perspectives and experience, she will give us make this session very interesting. So I'd like to welcome Professor Nkada Murungi. Please take the floor.
Thank you very much, Guilford. Good afternoon. Good afternoon. Okay. Yeah, thank you very much. This is called by some people as the graveyard shift. It's a graveyard shift because people are nodding to everything. So please don't do a lot of nodding. Let's try and keep it lively and speak. We are also significantly behind time, so we will try as much as possible to catch up on the time that we have lost in the course of the morning, which is why for my panelists, I have requested that I not be very nice, because I'm going to put on a timer so that we can finish within the 10 minutes presentation, so that at least we have a moment for engagement. As has been introduced, this session looks at the broader influence of the decisions of the African Court. And as part of this panel, we are looking at a number of decisions, starting with the decision in APDF and IHRD versus Mali. And then we're looking at Jebra Kambole and the case against Tanzania, and others, the case against Tanzania. And then we're looking at the court's judgments in relation to Tanzania's restriction of direct access of individuals and NGOs, which is a discussion that had sort of started in the previous session, so you just pick up on it. And finally, we'll be looking at the issue of forced displacement, which Dr. Dorsey will speak to in relation to the Tanzanian Maasai, and maybe drawing some lessons from the Ogiek situation and decision. So the issue of, we don't have enough time, so I will not belabor the point. I think we understand what influence is. We will come back to it to see, actually, what kind of influence do we have, if we can qualify it. To take us through, as the first panelist, I'm going to invite Satang, Dr. Satang, to join us. So she's joining us. I'm not too sure if you're joining us from the US, Satang. I believe you are. and it must be just about morning for you while we are in the graveyard shift. So maybe you have a lot of energy, you can get us started on a good note. So Dr. Satang, can you hear us?
Yeah, I can hear you.
Yeah, I can hear you. Okay,
Yeah.
please proceed. 10 minutes.
Thank you. Thank you. Thank you, Professor
Thank you,
Murung.
Professor Murung.
I am hearing an echo.
Apologies.
I'm greeting from Dakar. Actually, I'm in Senegal. And thank you to the center as well as the court this opportunity to get a little bit 10 minutes as Professor Murung said. Especially after lunch is a bit tricky. But to extend my thanks as well as the President of Georgia, as well as your excellent colleague Isabel. My presentation is titled "My Sister's Keeper." The ripple effect of the African.
Satang, okay, maybe it will get clearer. There was a bit of breaking in your sound. But
yeah, and I'm hearing myself. I'm not sure.
Okay. So just proceed. I'll let you know if it's working.
Okay. Sounds good. Okay. So I now have about 9 minutes. And my presentation is titled "My Sister's Keeper: The Ripple Effect of the African Court Case of EPA and IHRDA versus Mali on end in harm for practice Africa." What I wanted to do really is looking at both the implementation part, but also the broader implication and the impact, especially from a feminist lens. Presentation given my 9 minutes, and also there is a panel for a session that will be focused on the case itself, especially around the legal issues. So that'll give me the time to speak quite a bit, especially on the background, from the zero in on the broader implication. But just briefly. As we all know, in 2018, the court that Mali's family code violated the Mali, but also the African Charter, as well as other rights instruments. This case marked the first instance where the court bans violations of the protocol, which was and still continues to represent a significant human rights in beyond. In relation to the case, the court issues one to especially conformity of the. You hear me? Or did I lose you? All good? Okay. So on the merits of it, the court had to rule on the conformity with various international instruments that have been ratified by Mali on especially with regard to the family code, so related to issues of the minimum age of marriage, the right to consent to marriage, the right to inheritance for women and natural children, as well as looking at and the question around Mali's compliance with its obligation, as I said, as it relates to harmful practices. So just briefly, on the question of the right to respect for the minimum age of marriage, the court did stress Mali's international require age to
Sorry, just 1 minute. Just need to establish whether the interpretation is working.
Okay.
Those who need interpretation, are you fine? Are we okay? Is it okay? Okay, so maybe Satang, because we still have a bit of the not hearing clearly, I think maybe if you remove the video, it might reduce the breaking.
Okay.
If we could try.
Does it sound better?
Okay, please.
Does it sound better?
Yes.
Okay. No problem. So just quickly, as I said, especially on the question of the right to respect for the minimum age, the court held that it was required to eliminate discriminatory practices and set the minimum age at 18 years. Mali did its family code, which was adopted under force majeure, does not meet these international standards. Obviously raises questions about the applicability of the issue as an exemption in human rights jurisprudence. I'll let the next panel to deal with that issue necessary.
Sorry, it's me again.
Yeah.
I'm sorry, we are really just disrupting you. But we have an issue with the translation hearing us or hearing you clearly. Can I request that we take another presentation as we sort it out? Please.
Sounds good.
Please, I'm sorry to have to do that, but I think it's very important so that the colleagues who are listening through interpretation can hear you clearly. In the meantime, if you can find, they suggest to use a headphone. Did I hear correct? If that will help with the sound, please.
Yeah, that's fine.
Okay, just give us a minute then. So I am going to ask that in the meantime, that we rather take the second presentation, and then we will come back to this particular discussion right now. So I'm going to invite you, Irene, to please make your presentation as we sort out the sound issues. Thank you.
Thank you, Chair, Prof. Murungi. All protocol observed. Good afternoon, ladies and gentlemen. I would like to first take this opportunity to applaud the organizers for organizing this very crucial conference, and also to thank them for having me here. I'm absolutely delighted to be back in Arusha, see many familiar faces, and to put even many more faces to the names. I'm equally humbled by this opportunity to share with you a reflection on the implementation and impact, so to say, the influence of African court decisions on 3 cases against Tanzania. These are application 18 of 2018, Jebra Kambole versus Tanzania, application 11 of 2020, Bob Chochawangwe and Legal and Human Rights Center versus Tanzania, and application 42 of 2020, TK Mwame Pile and Equality Now versus Tanzania. I would like to acknowledge, before going any further, the input on the situation on the ground from some of the applicants, including Jebra himself, Chacha, and Magoti. And I also acknowledge preliminary input from my interim research leader, Prof. Hilhyun. Now, given the immense amount of relevant information and reflections already shared yesterday and earlier today, I'm keen to avoid duplication. But bear with me if it's, I seem to do just that. It's not with the intention of duplicating, but rather to pay tribute to the particular relevant information or to emphasize a point. Now, this reflection only has 2 parts, apart from the introduction. Now, it's the case overview and key takeaway reflection points. So the introduction mainly takes stock on the definition of terms, key criteria for effective implementation that was advanced by Prof. Murray and Prof. Hilhyun in their findings of one of the extensive surveys. And the introduction also covers preliminary aspects that are best not repeat, as they are already covered in previous presentations, such as the statistics on the rates of compliance of decisions from the national human rights education bodies. The second part is the case. First of all, the case overview speaks to the decision, implementation, and impact of the cases. Now, since the judgments of the cases are accessible, I'll not I'll probably provide just a quick description and move to the implementation. The impact of submission rather than the merit of the matter. This is one of the aspects that is raised from this case overview. And also not only the implementation and impact of the decision, but also the impact of the compliance and non-compliance of the decision is going to be raised in the case overview. And the second part, which is also my favorite, discusses a few takeaway reflection points, and they mainly highlight the fact that the cases bring to the fore, first of all, the role of the court in the judicialization of electoral processes or electoral contests. They also show the need or otherwise room to rethink the concept of compliance in general. But bear with me here because I understand how the court is limited by the normative framework that it's established on. As I will explain a bit, this entails a shift from the rule-based compliance to achieve the extra compliance effect that is celebrated under the Inter-American Human Rights Court. In other words, drawing inspiration from Viljoen's yesterday presentation, where he spoke of embeddedness in norms. Now, this reimagining or rethinking compliance, the concept of compliance, calls for embeddedness in practice. And from the feedback that was provided from the court so far, as well as scholarly suggestions that have been raised, I was very excited to actually get an impression that the concept, this rethinking of the concept is already happening. It's in progress, right? I'm just here to highlight that this is not a practice without thought. There is developing theory behind it, and also to encourage as scholars as well as the court to keep the fire burning with regard to the rethinking in general of the concept as a whole. And recalling, speaking of the same thing, recalling one participant who joined us virtually yesterday, he called the court to change the focus. On my part, I beg to differ and encourage the court to uphold its focus and the intention to achieve compliance. All right, so the predominant question that I encountered during the drafting of this reflection, and I believe you probably have it in mind at the moment, is why these cases, right? And there are arguably various speculations that can be raised in response to this question, but I'll adopt just strictly scholarly viewpoint to avoid getting trouble. So the selection of these cases was inspired by the fact that apart from emanating from controversial provisions in Tanzanian legislations, including the Constitution, there are cases against a certain point that was raised in the finding of a survey on compliance. The finding was indicated that states that are less susceptible to non-compliance are those which have high level of human rights adherence. Now, in common knowledge, it is common knowledge that the political climate in Tanzania during the 5th presidential term was characterized by shrinking civic political space, and that even led to the withdrawal of the Article 34.6 declaration of the protocol. So this is the environment, or rather the political climate that these cases were filed. So attached to these cases is a significant, desperate attempt really of redeeming critical human rights issues of the time. And you can, so to say, it was a human rights approach to attain effective democracy and access to human rights. So let me just go to the brief case overview. In Jebra Kambole versus Tanzania, Jebra contested Article 41.7 of the Constitution of Tanzania, which bars the court from inquiring into election of presidential candidate after electoral commission has declared a winner. Now the court, just quickly to go to to pick on the merits of the case, the assessment of the court found that Tanzania was in violation of the alleged violations to non-discrimination, as well as the right to have his cause heard. Now, and it ordered Tanzania to amend that article. In terms of implementation, the activity report of the court of 2023 indicated that the Tanzania has not reported, and the respondent has not filed any report, and its time limit to file it already elapsed in January 2021. But the non-implementation of this decision led to the submission of application of about 3 other cases related to alleging violation from provisions of electoral-related provisions of the Constitution. And one of the cases actually prayed to the court to order that, or rather to declare that Tanzania has clearly disobeyed the court orders stipulated in the Mtikila case. So that's the one impact of the case that I will highlight. And going to Bob Chacha Wangwe case, he contested, the applicants contested the provision of National Elections Act of Tanzania that are related to composition of electoral commission. And its authority to appoint some officers among public officers. Now, as an implementation, earlier this year, Tanzania adopted Tanzania made law reforms, and 2 of the legislation that were adopted repealed the National Election Act, and they implemented some of the amendments that were stipulated in the order in that case. All right, and so I have 2 minutes, and I will just say in Tigoma Mpipile case, it was a case concerning the ban of pregnant schoolgirls. Now, although the court found it admissible, the case put a lot of pressure, adding to civil society organization pressure towards the Education Act and regulations of Tanzania to ban pregnant schoolgirls. And so that is a very important point to note here, is that not only the merit that can actually bring impact of the decision, but if the mere submission can actually put a lot of pressure and get the intended impact. The 2 reflection points in conclusion, one is, as I mentioned before, regarding the judicialization of election-related rights violation, that it's a role that the court has actually illustrated in the cases, because 2 of the cases, Jebra Kamboya and Chacha Wangwe, including the 3 cases that were filed after Jebra Kamboya case, they accentuate the role. They give the opportunity for the court to also make a mark on electoral contexts, or rather electoral contexts that arise from election-oriented provisions. But the rethinking, I'm afraid that I'm going to have very few minutes to talk about, how to rethink this concept. But there is a very small group of scholars, unpopular, that advocate for exploring unpopular other aspects which determine effectiveness of decisions of international courts that go beyond focusing on compliance theory. The question literally that, or rather the foundation of this, was that the scholars were asking, so if the inter-American courts' decisions are not complied for in most cases, why are people still, submitting cases to it? And why is the compliance still going up? And they found out that the inter-American court seeks to attain the extra compliance effect. I'm talking about how a decision does not need to be complied to for the the matter, or rather the court's work, to have impact. So it's literally thinking outside the box. And according to Armstrong, sorry, moderator, just one last point. I just want to mention a couple dimensions that the Inter-American Court is going about this. And this is like trying to evolving policies of reparations of Inter-American Court, from monetary compensation of victims to demanding the states to reform the, demanding state reforms of state legal reforms and criminal prosecution. So, for instance, like in the case where Gabriel Kamboi is praying for the court to order or to declare Tanzania to be to have disobeyed the order, I think this is one of the ways that you can rethink compliance. More of this is in the paper, but also I give reference to the article where Armstrong actually clarified further about this. I have to stop now in the interest of time. Thank you so much, moderator. Thank you for your attention. Thank you.
Thank you very much, Irene. I am sorry that I am being that person, but this is what we have to do now in the interest of finishing within the day. I am going to just go directly into the next presentation. I am going to ask Dr. Petrus to please, Petro, to please come and make your presentation. So, because I should hope that the online issues have been sorted, but I think we can finish this presentation, then take the online discussion so that we can just start the questions from there. So please, Dr. Petro, please.
So, good afternoon, everyone. Your Excellencies, colleagues, it's a great honor for me to stand before you today and present a topic on this very important conference on implementation and domestic impact of decisions of the African Court. My topic, which I'm going to present today, is titled Touching Where It Hurts, Revisiting the African Court Judgments in relation to Tanzania's restrictions of direct access for individuals and NGOs. As a way of starting my presentation, it has a number of areas that I want to cover. The very first part is about the background, then going to a part which I titled The Beginning of the End, Reservations by Tanzania. And later on, I will go on to look at a drift which has grown between the legal position in Tanzania and the judgments of the African Court, and I'll try to make some conclusion and recommendations. So to start with, we all know that the African countries have never been, have never hesitated to recognize the need to promote and protect human rights in the continent. However, when you read the literature, you'll be a bit surprised as, a pain of the salt to an open wound. African countries do not actually make full implementation to the obligations they have entered to in a number of global, regional, and sub-regional human rights instruments. And of course, that trend has not left free the judgments of the African Court on Human and People's Rights. And of course, not only that these judgments are not fully implemented by African countries, but they are also increasingly being condemned and used as an excuse for a number of African countries to withdraw their declarations which permit individuals and NGOs to access the court. And therefore, the gist of my paper is now to look into the extent to which now a drift has grown between the judgments of the court and, of course, in relation to Tanzania, which occasioned what we call a non-implementation and ultimately the withdrawal of the declarations in favor of individuals and NGOs. So you can always not be able to go that far without looking first at the reason that was given by Tanzania at a time where it was withdrawing the declaration. And we all know that Tanzania became a part of the protocol in 2006, and of course signed the declaration in 2010. And of course, at a time of signing the declaration, Tanzania actually made two conditions. And those are the conditions that Tanzania said that Tanzania is withdrawing the declaration because it has been implemented against the reservations that she had made at the time of entering into that declaration. And therefore, it forces us to go and look at what reservation, what conditions that Tanzania made at that time. So when you look in the declaration which was made, Tanzania actually said that put two main conditions, that individuals and NGOs can have direct access to the court, except that they should, number one, exhaust domestic legal remedies, and number two, in adherence to the Tanzanian constitution. So these were two conditions in which Tanzania called them as reservations. So my paper had to look at these reasons vis-a-vis the judgment of the court. And of course, I started with the very first reservation, which was exhaustion of domestic legal remedies, and see if this is really a reservation in the eyes of international law. So when you look at it critically, you realize that a reservation as defined in Vienna Conventions on the laws of treaties would only require a state to make a statement at a time of signing, ratifying, or acceding to international treaty, and that statement seeks to modify the certain provisions of the treaty in relation to their applicability to that particular state. So when you look at exhaustion of domestic legal remedies, this is already a recognized principle under the African legal system, and therefore one would be surprised as to why this would be said to be a reservation, because it does not modify any position under the protocol. It's actually acknowledgement of what is already in the protocol. I know some scholars have been a bit rude. They would call a reservation of that nature a fake reservation. So I would not want to join that bus. I would simply say legally this provision to be termed as a reservation has got a bit of misconception. Again, when you look at the second element, which is about adherence to Tanzanian constitution, you would see it is really, really very broad. In a way, it tries to subject international law into a scrutiny of domestic legal framework. And there you start getting a problem. If you read the Vienna Conventions on the laws of treaties, which provide for best criteria for a reservation to operate, you would realize that there are certain criteria that must be observed, and one of which is that a reservation should not defeat the object and purpose of the international law or the treaty. So every time when you have such a reservation, which is really very huge in this nature, it interferes with the purpose. And we have a very good case in Inter-American Court on human rights. It is a case of Hilary vis-a-vis Trinidad and Tobago, a case of 2001. In that case, you know, the Republic of Trinidad and Tobago actually said they would only accept the jurisdiction of the court insofar as it is not inconsistent with the constitution of Trinidad and Tobago. And of course, in that very same case, the court looked at that reservation as too much broad and therefore offend the object and purpose test. All right, so having said so, what do we do when a reservation is invalid or it causes us a lot of problems? If you look at the Vienna Convention on the Laws of Treaties, you will not get a lot of assistance because it does not provide what you do to invalid reservations. But over time, a jurisprudence has developed where we see a number of doctrines that were proposed. We have the so-called surgical doctrine, we have backlash doctrine, and we have severability doctrine. And if, of course, for surgical doctrine, it was proposing that an invalid reservation will not be treated, will not be looked at, but a state will continue to be a member of the treaty. And of course, it was seen, it was challenged because it's as if states were permitted to make reservations that goes against the treaty itself. And you know, there is the backlash and severability. I think I should not go into details. My time is running really quick. Let me go directly to the drift itself. So the very first part of the drift relates to a capital punishment. We all know that the history of capital punishment in Tanzania is really very long, starting from 1990s. In 1994, for example, in the case of Republic vis-a-vis Mbushu alias Dominic Mjaore, the High Court decision, Mbushu and his colleagues challenged the constitutionality of capital punishment in Tanzania. And in that particular judgment, the court actually agreed with Mbushu that indeed the capital punishment is cruel and therefore can offend the Constitution. But on appeal, the Court of Appeal reversed the decision of the High Court by holding that the death penalty can be cruel in a manner in which it is executed, but nevertheless it is still served within the Constitution and it is in harmony with the Constitution. Similarly, a few decades later, in the case of Jebra Kambole, vis-a-vis the Attorney General of Tanzania, Jebra Kambole also wanted to challenge the capital punishment, and of course the Court of Appeal stood to its decision in Mbushu that the capital punishment is actually served under the Constitution. So when you look at this background, a case was brought before the African Court, a case of Ali Rajabu and others vis-a-vis Tanzania, and the African Court ruled that the arbitrary, the imposition of death penalty, compulsory death penalty in Tanzania is actually arbitrary and thereby offending Article 4 of African Charter on Human and People's Rights. Definitely this decision did not please Tanzania, and one would not, perhaps the challenge would be from the reservation itself, because you're looking at the High Court in the land has already said it is in harmony with the Constitution. And now you go to the reservation, you say it should adhere with the Constitution. Immediately you start getting some issues where countries would think the decision is not in harmony with the Constitution, and that is a reservation. So you have that particular challenge. There was also a case of Mtikila. I will not go further with this one. We all know Mtikila challenged the independent candidacy in Tanzania. And of course, to date, the Constitution of Tanzania still does not permit independent candidate. So if you measure the Constitution vis-a-vis the decision of the court, that if you have a provision of that nature, it is discriminatory, you realize that you already have a drift there between the judgment of the court and the position in Tanzania. But what has caused this drift? You would always go back to the beginning of the end, the reservation, the misconceived reservation. I summarize? Thank you. All right, I'll take just 1 minute. to pass us through the case, the judgment of Robert Penesis vis-a-vis Tanzania. This is a case where Robert claimed to be a Tanzanian, and Robert could not succeed in district court, in the High Court, and in the Court of Appeal, the result of which he took the matter to the African Court. And you know, in the African Court, a few things happened there, one of which is that a very new witness who was not in the domestic court appeared, and this was the lady called Anastasia Penesis, who claimed to be the mother of Robert John Penesis. And you know, under Tanzanian law, you would always know once you're born by a Tanzanian, then you have the right to become a citizen of Tanzania. So when I looked into this case, I realized there has been a number of issues, one on the part of Tanzania, but two on the part of the court. I would beg to speak on the part of the court, and we have our justices here who would help us on that regard. And this relates to Anastasia, who was a very important witness, and through her, Penesis would have obtained citizenship in Tanzania. But now, I don't know, justices, what had stopped them from, for example, asking for additional evidence on DNA test to prove the connection between the two. So a good thing they're here, they would provide us with that. Thank you so much. I need to stop here. Maybe you would come for question and answers. Thank you.
As I said, I have a terrible job. The job is to keep people to 10 minutes so you can survive. So I'm just going to move on straight to Dr. Dorsey, and then, 10 minutes.
Yeah, yes. Okay, can you hear me, right? I think also without microphone. Good afternoon, everyone. Thank you so much to the organization for having me here. And thank you to the audience to be here on a Saturday afternoon. That I don't think is usual for you and for me neither. I'm trying to speak about the case of the Maasai at this East African court. I wanted to do quite a proper introduction speaking about the Ogiek case, but I don't have time. But I would just like to give some general information. First of all, just to show how the Ogiek, they are attached to their land. I don't know if you know what Ogiek means in their language. That means caretaker of all animals and plants. That means they are people who are really have rooted in their land. Of course, they've been evicted by the Kenyan authorities, and the African court delivered 2 judgments in 2012 and 2017. They're very important. The 2012, it was on merits. The 2017 was on compensation. And above all, the second one is being considered important because recognize the importance of the Ogiek as an indigenous people and their right their right to property of the land that they were occupying. Unfortunately, there were several forms of compensation that, of course, the honorable judge knows much better than me, because they went from instituting a fund for the Ogiek to monetary compensation to try to enforce a dialogue between Ogiek and the Kenyan authorities. What I would just like to say about this Ogiek case is that, unfortunately, the Kenyan authorities, as it happens also in other cases, doesn't seem to comply a lot with the 2 judgments. In fact, just in November last year, the government evicted 700 households from the territory occupied by the Ogiek. And actually, the government responded, well, not the government, but the Kenya Forest Services and Kenya Wildlife Service responded that the eviction were not targeting the Ogiek per se, but they were targeting people illegally occupying and building houses on a Kenyan, on a public, it was not belonging to anyone, it was belonging to the Kenyan government, that territory. And this is, of course, very unfortunate, what it's happening with them. But yesterday, Daniel Kobe, told you more what's happening on the ground, in fact. Actually, it's a bit unfortunate because when they were delivered the two judgments, above all the second one, it was seen as to opening a door for new judgments for the tens and the hundreds of indigenous people living in Africa, that they could have received justice after years or decades of evictions. And in fact, one of these other cases is the one of the Maasai living in Tanzania, because Maasai also they live in Kenya, of course. And on September 30th, 2022, the East African Court of Justice dismissed the case brought against the Tanzanian government by the Maasai villages, who sought recourse for violent evictions and burning of homes in Loliondo. It was by the government in 2017. So you see, always it's eviction, burning houses, forcing displacement people. The case, which has continued to make headlines, was brought forward after violent government-led eviction in these Maasai villages, which border the Serengeti National Park, that is not even very far from here, in fact. Of concern, the eviction of the Maasai from their lands have been encouraged by international conservation organizations, which have always portrayed indigenous community as a threat to the conservation of this land, in fact. It was interesting reading the judgment of the court, because the court determined that the witness failed to prove the eviction took place outside the Serengeti National Park, in the sense that the Tanzanian government said that Maasai were occupying the Serengeti National Park, while they responded no. They were living outside the Serengeti National Park, that of course it's owned by the Tanzanian government. And that testimonies about violent eviction that were relied only on a hearsay. The court said that, there were not really proof that these forced eviction happened, in fact. And it was even interesting because the Maasai, they also appointed a Kenyan expert to trace borders and to check that, in fact, the eviction were outlawed. And the Tanzanian and the court, in fact, said that this Kenyan expert couldn't really do that job because he failed to prove that he had a work permit to work in Tanzania, so to perform this activity. That is quite, and that is the situation until now. Of course, this is linked to what it was already said by several presentations, that Tanzania, of course, withdraw from Article 34.6 of the protocol, and in that case, of course, the Maasai cannot go because, of course, they were advised now to try to go to the African court, but of course they cannot apply a law, and that's why it was requested by them to apply through the African Commission. In fact, what it can be said that the court paid a blind eye also to the illegal arrests and shootings and displays suffered by the applicants, including women and children. but instead gloss over the compelling multitude of oral and affidavit evidence that tendered by the villagers. Noteworthy, in fact, the 2007 Universal Declaration on the Rights of Indigenous People, in its Article 1, declares that, I'm quoting, that indigenous people have the right to the full enjoyment of all human rights and fundamental freedoms as recognized in the Universal Declaration of Human Rights, 1948, and international human rights law. The declaration, the 2007 declaration, goes on to guarantee the rights of indigenous people to enjoy and practice their culture and customs and their religion. In addition, in the 2011 UN Framework and Guiding Principles on Business and Human Rights provides a global standards for states and corporates to prevent, address and remedy human rights abuses. Informed actually by the African Court on Human Rights decision on the OGIEC, in fact, the Maasai, as I mentioned, they were encouraged and should bring, in my opinion, their claims to the African Commission on Human Rights, which may, of course, afterwards forward the case to the court. Yes, I'm almost done. The Maasai should assert the Tanzanian government violated several articles of the African Charter, of course. And actually, what I would like to finish with that. In January 2023, representative of the African Commission on Human and People Rights visited Tanzania and commented on the plight of the Maasai. And they recognized, in fact, the Commission that Maasai were suffering and encouraged the Tanzanian government to respond appropriately. Thus, the Commission has already indicated that it is aware and sympathetic to the suffering of the Maasai, and informed by this recognition and understanding that the government has not taken remedial measures, the Maasai, I don't think that they have another mean now that use the Commission to try to go to the African Court. In taking such action, Maasai people may not only halt the eviction and firmly establish their rights to their ancestral land, but may also signal the Tanzanian government that they do have a right to participate in national decision-making and government action. In fact, it was proposed that as an important indigenous people, Maasai, how to have significant representation in the Tanzanian government, also perhaps by a way of sitting in the National Assembly. And in an action against, the possible action against the government, the Tanzanian Maasai ought not to stop at halting the ongoing eviction, but should also take steps to ensure that these acts that someone called atrocities cannot recur and their rights can be adequately protected, and Tanzania, if condemned, could comply with the decision of the court differently from what unfortunately is doing Kenya with the OGIEC until now. Thank you very much.
Thank you very much, Dr. Dorsey. We are going to try and go back to the first presentation. Dr. Satang, are you back? Can you hear us?
I'm here.
Yes, please. Can you proceed? You have 10 minutes.
Are you hearing me? Okay.
Yes, we hear you. We hope it will stay that way.
Okay. So if it does, my time.
Okay.
Yeah. Okay. So just thank you again. Thank you again. Quickly, I wouldn't repeat what I already stated before. But as I indicated, I was particularly interested in the case, especially looking at how the broader implications of the addition, especially as it relates to
women's rights.
I'm just looking at the comment here. I don't know whether the person is here or not. It's everything
It's
good
everything
from that side,
good from that side,
translation, everything?
translation, everything?
It's okay.
Yeah.
Yeah.
Oh, okay.
Okay.
Yes. So
yes.
just
So
quickly,
just
as I
quickly,
said,
as I said,
there's a case, panel on the case, so they
panel
can
on the
delve
case,
into the
so they can
merits
delve into the
and
merits
have a
and
discussion on
have a
that.
discussion on that.
But I think for the
But I
purpose
think for the
of this
purpose of this
presentation, I wanted to
presentation,
focus
I
on
wanted to focus
one,
on
especially as
one,
it relates
especially as
to
it relates to
the orders as it relates
the
to
orders as it relates to
revising the Malian
revising
Family
the
Code
Malian
to
Family
make it
Code
compliant with
compliant
the
with
Maputo
the
Protocol
Maputo
as well as the African
Protocol, as well as the African
Children's
Children's Charter.
Also the order
Also the
around
order
awareness
around
campaign that the
awareness
court
campaign that the court
mandated the
mandated the
government
government
to
to
conduct
conduct extensive awareness raising
campaign,
campaign,
which we also
which
know
we also
is in
know
line
is in
with,
for example,
Article 5
Article
of the
5
Maputo
of the Maputo
Protocol,
Protocol, especially around
addressing
addressing
harmful
harmful practices,
as well as a
requirement for Mali to report back to the court within 2 years on the progress of the initiatives.
Just on the status,
and I want to put on record my thanks to
IHRDA
for
information,
both APDF and IHRDA,
along with
other civil society organizations, are continuing to advocate for the implementation of the decision, including holding public dialogues, especially around some of the challenges as it relates to the decision.
So in terms of the reporting,
as we know,
Mali was
given
2 years to
report on the implementation
of
reparation measures. This was expected in 2020. However, according to the court's 2021 activity report, Mali has not submitted
the required
report despite the extension of the deadline to August of 2020.
Generally, the
feedback is that Mali has not yet complied with the African court's orders.
I think
partly looking at this as and discussions yesterday and earlier today as well is really looking at the complexities of the challenges of implementation, and so especially for Mali, given sort of the unstable political security situation where prioritization have been really around national security over social issues,
but most especially within the current context
of what that looks like for prioritization, especially
around rights
reform.
And then the second
biggest issue obviously
has to do with the
influential religious forces
that continue to oppose the court's decision, as well,
especially around
given the fact that this was the first case that really centers Islamic law and rules and customary and rules generally. I think yesterday there was a presentation as well on political will, but partly as well is really this idea that there's a fear of losing popular support if controversial issues like the family code are openly discussed as well. I would like to focus just quickly on the broader implications. As I said, the case will be dealt more in depth in the next panel. One is the precedent setting, which I already alluded to, especially for majority Muslim African countries who have the plural legal system, including those that are rooted in Islamic traditions, and really the precedent setting of the decision, especially rejecting culture and religion as justification for rights violations, in this case, the rights of women and girls. And the second issue, especially around ripple effect, is really thinking about the broader effects, not just on child laws, not just on inheritance, but also other harmful practices such as FGM. And this is something that has really been part of the broader focus, especially given the increasing sort of backlash on gender equality and women's rights, including rollbacks on gender-based violence and FGM laws as well. I wanted to also highlight, especially when we look at comparative law, similar cases and how we should perhaps innovatively think about the broader implications, but also the push for implementation as well. So just quickly,
one is the Zimbabwean case of Loveness,
Mozuru
versus the Minister of Justice,
in which
there was a challenge
on
the constitutionality of a law
that allows
girls to marry at 16.
The
Constitutional Court
ruled that the marriage statute was unconstitutional, which led to a new law in 2022 setting the marriage age at 18 for all. The second case is the Tanzanian case of Attorney General
and Rebecca
Ngumi,
in which it was challenged certain sections of the law of the Marriage Act
that permitted
girls to marry under 18 with parental consent was challenged.
The High Court invalidated these sections,
and in 2019,
the Parliament was
directed to amend the law of Marriage Act to raise the minimum marriage age for 18 years.
However, this law remains unchanged. So similar to the context that we find ourselves, especially
in the Malian context as well.
So I think, and I know I don't have a lot of time. Part of what
I wanted to do with this paper is really thinking about both the complexities
of enforcement,
especially navigating complex legal, political, and social factors,
but also how
the Malian nation can be useful, as I said,
especially
for majority Muslim African countries or that have majority Muslims
as part of their
population.
And so thinking about issues of political will, prioritization,
especially in a country, for example, where issues of addressing counterterrorism have
taken priority
as well.
But I think thinking outside of the box, especially beyond Mali, and leveraging
the broader African human rights system
is really trying to
leverage and utilize, especially the soft laws of the African Commission
and the committee.
So whether that's the Joint General Comment on FGM,
the Joint General Comment
on ending child marriage,
and
the one on General Comment 6 on women's property rights during marriage and divorce.
And so thinking about how to use the judgment, the Malian judgment, the African court judgment, rather,
along with these soft laws as both an advocacy tool, but also a push for reforming our laws as well.
Recently, Equality Now did an Africa-wide study on family law, especially with the existence of the plural legal system, and how that continues to exacerbate inequality for women and girls
right as well.
And then finally, the point
of really trying to bring all the actors in.
So thinking
more innovatively about how to utilize the resources of others
who are best placed to do so,
especially around monitoring, but also utilizing
and developing
monitoring tools, as well as the best approach to be utilized as well.
I had a longer presentation, but I'm scared that the internet might go. So I'm going to stop here, and that also gives us time, especially if there are other follow-up questions and comments as well.
Thank you.
Thank you very much, Satang. Thank you very much. You stuck to the time. So, but I can also see the master of ceremony looking at me funny. Because apparently I'm still, so I am under pressure from someone else. I am not the bad person. Yeah. So we've had some very exciting, in my view, reactions. I'll be the first person to admit that it's very difficult to present in 10 minutes, especially to present a paper that requires you to follow a logic for you to make the point, because you don't have time to do the building, the foundational issues, so that you can actually make your point. So the fact that you will still be able to make your points despite the constraints is a very big plus. So thank you very much to the four of you. Influence, when I started this session, I said influence is one of the big buzzwords. It's a buzzword. And a lot of times we ask ourselves, what exactly do you mean about, the prospect of influence stemming from the decision of the African court? I think the difficulty with it is that we would not be able to contend with all the aspects of influence that we can actually deal with. But I think the good thing about it is that we can always locate a place that we can make a contribution towards assessing the impact of this decision. So I am particularly just thinking about, in the first paper, when you started to talk, first now we have rearranged the system. So Irene, you started to speak about, effects beyond compliance. Just thinking in line with the Inter-American Commission. And I was thinking, when we do strategic litigation, normally we talk about that element of sometimes you go to court not to win, but as a route for certain other things, because by going to court, you have an opportunity to articulate a particular issue, to get jurisprudence, to get clarity, to even just create visibility around that particular issue. And I think, I understand the need for us to see that states implement the judgments of the court to the latter, but I just want to agree with you that all is not lost. In fact, in a majority of these states that are pulling out, maybe if you just want to be cheeky and look the other way, they pull out because they finally, as the representative of Tanzania correctly noted, you realize I actually need to put my house in order. I think that's impact, actually. It is impact. So it's one way to look at it and say states are pulling out of the court, but it's another way to say the court is actually triggering self-reflection and states to think that maybe not everything is in order and we need to do something about it. And in the same way, I was looking at what are the pain points in Petra's presentation, like what are the pain points? And the pain points for states are not new. There are things that we know. But I think up and until these matters come to the court, we don't actually have a moment for the state to admit that this is a pain point for us. We already know, but this provides us with a forum. It provides us with a platform to actually list these issues and say, we have an elephant in the room and we have to deal with it, whether we like it or we don't like it. So whether we call them genuine or we call them disingenuous, whatever label we attach to them, I think, is a very important thing. And just also, again, reflecting on the transferability of, jurisprudence and the possibility that the pronunciations of this court and recognition of the plight of the Ogiek could have, some kind of benefit for the Maasai of Tanzania, despite or in spite of the current circumstances related to Tanzania's ratification of, deposit of the instrument. I think it's an important reflection to have, because once again, being indigenous people on this continent are a key issue. I don't think these issues are going to end at Ogiek and the Maasai. There are probably issues that if we're actually going to get honest about it, we have a very long path to walk in terms of how states respond to indigenous people across this continent. It varies from land, but there is land, there is conservation, there is a multiplicity of different interests that is there, there is language. I'm thinking, like someone began to say in the morning, the case of the San in South Africa, who have been camping outside the president's premises for how many years now? I don't know. It's 3 years. They have been camping outside the union buildings for 3 years. And President Ramaphosa has been in that union buildings all this time. And in all that period, he has never found one moment to walk out down the stairs and meet these guys. Meanwhile, they have set up a camp where they cook, they eat, they grow crops. If you're sitting outside the State House for 3 years, on the one hand, you can talk about tolerance. I'm not sure very many African countries would have you setting up a tent in front of State House for years. But on the other hand, what kind of indifference makes you able to tolerate the presence of a group that is, clamoring for recognition, for basic recognition in front of your premises for 3 years? In such a scenario, would even a judgment of the court help? Would it actually add any value? So maybe those are some things we need to think about. Anyway, the last issue of the case discussion, the case regarding Mali that Satang has raised, we are going to get into the details of that case, but I just also want to recognize the line of thought that she was talking about, looking into similarly situated countries and thinking, how come we achieve results in some countries and we don't achieve results in other countries? What is so different? Is it the manner of engagement? Is it the style of engagement? Or is it the stakeholders that we are bringing on board? And also recognizing the contextual difficulties of trying to deal with a marriage law in the middle of a terrorist conflict. How do you appreciate the state's challenges in such circumstances? Is it a matter? Is it relevant or is it not? I'm going to give an opportunity to reflect on this. We have 5 minutes. 5. Okay. I'm going to give an opportunity to reflect. Of course, first to the court, but if anyone else would have any reflection, I think you are welcome. Tanzania, I recognize you. There's no reflection from the court? Yes, okay. Judge, I think we can start with you, and then we'll come to Tanzania. Thank you.
Thank you, Madam Moderator, and thank the presenters for the good delivery and their well-taught presentation. Yes, the first comment is about Tanzania's reservation. Reservation was made in respect of the protocol and not, it was made in respect of the protocol and not in respect of the African Charter, and not in respect of the ICCPR, and not in respect of the International Covenant on Economic, Social, and Cultural Rights. So that reservation was limited only to access to the court and not the substantive law. That is the difference that Tanzania should draw. And Tanzania should have raised this matter for the court to determine, because our protocol says that whenever there is any issue as to the interpretation, it must be raised and discussed. And Tanzania knew that when it is raised and discussed, it will go against them. They did not raise it. And if the opportunity is there and you do not raise it, it is your defense. And therefore, if you do not raise it, you cannot talk about it. And assuming they were going to raise it, it will be held as invalid. It is invalid to the extent that they're talking about two things: exhaustion of local remedies. And it is part of the charter that without exhausting local remedy, you cannot come to the court. So it is there already. And the second one is that adherence to the Constitution of Tanzania. And the Tanzania Constitution, nowhere, it doesn't say anywhere that if an applicant is coming to the court, the applicant cannot talk about matters under the substantive law. I'm talking about here, we are talking about the Charter, the ICCPR, and others. So here, it is non-starter. Then number 2, we talk about the fact that some of the cases, particularly the one involving the Tanzanian girls, that the court ruled that it was inadmissible. You know, the court is governed by the rules and the procedure and the protocol. It says that we must start with jurisdiction. Then we move to admissibility. And the admissibility, one of the conditions is that where the matter is pending before an organ, you cannot assume jurisdiction. And it was pending before the organ, yes, Committee on the Right of the Child. And therefore, our jurisdiction was ousted. We could not do anything. Then when it comes to the decision that the court held, that Tanzania's Electoral Commission, when it determines a matter, they should allow access to court. Here, access to court is an unfettered right. And the Tanzanian constitution was that if the electoral commissioner declares results, it is final. What is the law on accessibility? It is an international right, and it is an inherent right in everybody for electoral commission to take a decision. And you tell me that I cannot go to any court to challenge it. So their constitution was indeed in conflict with all international instruments. That was why it was held that it was unconstitutional. So in effect, if you have a look at all the Tanzanian cases, none of them could be said that the court held, because what the court did in all those circumstances was that they upheld the law in accordance with international law, international human law, and the statutes that we are bound to operate. Because Article 3 of the protocol says that the court has the right to use African Charter, the protocol, and any other human rights instruments that the state in question has ratified. And Tanzania has ratified ICCPR. And therefore, Tanzania cannot say that it doesn't bind her. So in conclusion, what I would say is that all the Tanzanian cases, none of them was taken, or none of them was decided arbitrarily. All of them were made in accordance with law. Thank you, Madam Moderator.
Thank you very much, Honorable Judge. I'm going to give the opportunity. Okay. I see the Lady Justice. Please go ahead.
Thank you very much. Let me also commend the panel for a job well done. I'm not going to repeat what my learned brother has said, but just to reiterate one point on the issue of reservation. That is to know, we all know basically that parties are bound by their pleadings. That if truly, because in all the Tanzania cases, in fact, majority, they filed their pleadings, they filed their defense, but in none of them was this issue of reservation raised. If it were raised, perhaps the court would have made a pronouncement, not perhaps, the court categorically would have made a pronouncement on it. We only heard about it after the withdrawal. So now the question is, why was that issue, if it was so critical, why was it never raised in any of the pleadings filed by the respondent state? And in most cases, they are represented by the office of the Solicitor General of their country, and a lot of, in fact, sometimes we have up to 7 representatives of the state. None of them. Thank you.
Thank you very much, my lady. So I think the representative from the government of Tanzania, you still need the floor? Sorry. Oh, okay. So, okay, let me hear him, and then I'll come back to Horace, please. Please go ahead, sir.
Okay, thank you. Thank you for the panel. I would like to comment on one issue concerning the case which was decided by the East African Court of Justice concerning the, I think, 3 villages which filed the case in the Eastern Court of Justice, and then the court went to the Court of Appeal. The presenter did not disclose all the facts of the case, and also the case is still pending. I don't think it is proper for the case which is still pending in the court to be discussed, because the case went to the appellate division of the East African Court of Justice, and the court remitted back the case to the first instance, and the court is still pending. The case is still pending, has not been decided. That is my point. Thank you.
Thank you very much. I think that's noted. Then can we hear, please, from Dr. Horace, and then we'll take it back.
Thank you very much. I just wanted, in respect of the issue concerning reservations made by Tanzania, which were appended to the declaration, to reiterate that, well, not only the issue could have been raised in many of the cases that that were adjudicated by the court, but also that it appears a bit curious that Tanzania might have litigated cases for about 10 years before the court, and then raised the issue thereafter. Right from 2012, we've started receiving first cases from Tanzania, and 2013, the initial judgment on the merit. So between 2013 and 2019, the court has adjudicated on admissibility of cases, including exhaustion of local remedies. And I believe the issues that is being raised by Tanzania is in respect of exhaustion of local remedies, because one of the reservations is about exhaustion of local remedies. And for about 6 years, the court has made pronouncement on the issue of exhaustion of local remedies. And we've never seen in any of the pleadings an objection by Tanzania as to whether the court was applying or using the declaration properly or not. It is never a reason. Now, apart from that, I believe even if one would want to argue on the basis of international law, if you want to go on a more of an objective ground, you have to notice that the regulations on reservations in international law have this in common. Some of the reservations are known as being licit, and some others are known as being illicit. Okay? And they are very well categorized. Reservations that are illicit or unnecessary are reservations that reiterate rules already provided for in the applicable law. And exhaustion of local remedy by Article 56(5) of the Charter is a rule that already exists and is being implemented by the court. And therefore, having that as a reservation is not a reservation that is accepted in international, because you are merely reiterating a rule that is already in the applicable statute. That's the first thing. The second thing has got to do with the jurisdiction of the court. If you read decisions of the ICJ, the ICJ has consistently held that any reservation that would amount to annihilating the very purpose of the provision or of the jurisdiction of the international court would amount to an illicit reservation. That is, that a reservation that would amount to saying, I allow you to go to the court, but not in respect of 1, 2, 3, unless it is provided for in the instrument. If it is not, then a reservation to that effect will mean basically annihilating the jurisdiction of the court. Because if you are saying, I have a reservation in respect of the court not being able to hear matters that are contrary to the Constitution of Tanzania, then basically you are telling the court you will never hear any case from Tanzania. Yeah, because basically domestic law of Tanzania is aligned on the Constitution of Tanzania. So anything that you will find not in line with your Constitution, the court will be barred from hearing that. And as such, that kind of reservation in international law is known as illicit reservation. I thought I should add this to the debate. Thank you.
Thank you very much. Very useful discussion. I am way off time and target. And I know that we should come back and take a response from the speakers. We're just going to be very brief. I'm going to ask you to do it in less than a minute. And I think the conversation is clear and the inclinations that we have here are clear. In typical African fashion, we would say that Tanzania and the court need a room. I am just glad that the delegate from Tanzania acknowledged that it's already an ongoing dialogue. Because what I hear, and I began by saying yesterday, we are all on the same side. There's no one here who is here to crucify anyone, right? I think it's important for us to acknowledge that we are all on the same side. We want this thing to work. And so the only thing that we are trying to do is to find out what is making the wheels not turn, and how can we remove that friction. And I think I'm already hearing the ideas coming and clarifications. So please, we hope, we pray. I am sure in this room there's a lot of interest in facilitating this clarification of issues. At least I don't have full authority, but I can say that I am happy to explore support to that regard. But I'm going to give you a minute to please just respond using the mic.
Okay, thank you so much for constructive interventions from the justices and colleagues. I'm noting that Dr. Horace is here, and he's one of those scholars who are not apologetically would write that this is a fake reservation, something like that. But to just add, I would love to have heard from justices, which I have not heard, about how extra miles they could go in terms of evidences. Because my paper focused on looking at the judgments. So I was reading the judgments of the court vis-a-vis the position in Tanzania. And some of the judgment I read, especially that of Robert John Penesis, where I found a very critical witness appearing for the first time before the African court, and this was the woman who said, "Robert is my son." And I was thinking DNA test could be really of very useful to be able to come with a better conclusion. And I was wondering why the court could not order or direct that this evidence, be collected or be brought before the court. I would like to hear that from the court. Otherwise, everything else were, comments, not more of questions. Thank you.
Thank you very much. I am also going to ask you to have a side meeting.
Okay.
Not because we don't want to do it, but because you're going to be here for a very long time. Irene, please.
I just want to respond to the delegate of Tanzania. Yes, I know that it's still pending the case, but this is just the case in appeal can give reason to the Maasai or give reason to the Tanzanian government. So if the Tanzanian government will have reason again, for my sources, the Maasai will continue and will try to seek justice at the African Court of Human Rights. If, on the contrary, the appeal will reverse what has been decided, most probably, I don't know what the Tanzanian government will do. If we'll hope that we'll comply with what the East African will decide, or if we'll decide to seek for some other decision. So that's why I think that it's in any case it's not my presentation that will go to influence the decision of the East African Court of Justice. I was just looking forward. Thank you very much.
Thank you very much. Do you have anything to say in less than a minute, please?
Yeah, thank you. So nothing really was, there was no comment for my paper, which makes me wonder if it was understood or too understood or not understood at all. But as I previously said, that the embeddedness of practice is already evident. So let's keep the fire burning. That's all.
Thank you very much. Dr. Nabane, do you have any comeback?
No, I yield my time.
Okay, thank you very much. Please join me in congratulating our panelists. Apologies for taking very long, but I hand it back over to, thank you.
Thank you so much, Prof. Another round of applause for the panel and the wonderful moderator. As we get to the final stretch of the conference, we would now like to get into the session on the conference outcomes and way forward. This is where we tie the threads together, reflect on the insights gathered from the different presentations, and of course, an opportunity to transform those wonderful discussions into some catalysts for change. So, and to do that, I would like to welcome my brother, Fulushe, who is the Program Manager, Litigation and Implementation Unit, CHR, University of Pretoria, to come and lead us in that. Welcome very much.
Good afternoon, evening, everyone, and thank you so far for this journey. I would like to particularly thank the justices of the court and the registry of the court, and also our presenters and the participants, and also our chair of panel session. It's been wonderful listening to us in the last 2 days. And I must confess, we could leave this place with over 100 recommendations, very, very important ones. But just for this purpose, we have tried to, as much as we can, synthesize some of the key recommendations, which we would quickly talk about. I would just read, and I would like to just give about maybe 5 minutes for us to give any input or comment if there is something particularly important that we think should still find its way to this recommendation. And the reason why we will quickly do this is because shortly after the last panel session, we will be adopting a communique which would reflect this recommendation. So the first recommendation that we've put together is that the African court should consider adding measures of public acknowledgement and apology to the list of reparation orders issued by the African court. And the second one is that the African court should maintain its current practice of engaging in cross-regional dialogues and exchanging information with regional sister courts on mutual interest, including the implementation of decisions. The third recommendation is that the African court and stakeholders alike should continue to improve their engagement with state focal points, and particularly build the capacity of state focal points to be able to track the implementation status of the decision of the court. The fourth one is that there is a need for increased coordination and collaboration between the African Court and other African Union bodies with similar human rights bodies, particularly the African Commission on Human and People's Rights, the African Committee of Experts on the Right and Welfare of the Child, the Pan-African Parliament, APRM, and ECOSOC. And this is to allow these bodies to leverage on each other's mandate and procedure to improve the implementation of the court's decision. And I think particularly the state reporting process of the African Commission and the African Children's Committee was mentioned as a pathway to mandate states to report on the implementation of decisions of the court. The fifth one is that the court should engage with Pan-African Parliament on the adoption of a model law on the implementation of the decisions of the African Court by the Pan-African Parliament, and it was stated that this process should really be led by the Pan-African Parliament. The sixth recommendation is that the African Union Executive Council should, as a matter of importance, prioritize the review and adoption of the draft monitoring and reporting framework for judgments and other decisions of the African Court. This process should involve establishing a technical unit within the AU Permanent Representative Committee on Human Rights and Democracy and Governance. And this technical unit should actively assess the extent to which states should comply with the decision of the African Court. The seventh recommendation is that the African Court should enhance collaboration between the African Court and the African Union policy organs, especially the Permanent Representative Committee and the Executive Council within the context of Article 29 of the African Court Protocol. The eighth recommendation is that the African Court should establish a systematic approach to gathering information on the implementation status of its decision. And this can be achieved through innovative methods such as implementation monitoring tracker database, which will ensure the public availability of specific information regarding the extent of compliance with the African Court's decision and nature of the measures taken by the states. The ninth recommendation is that the African Court should maintain its collaboration with national human rights institutions to ensure, to enhance the capacity of national human rights institutions to follow up on implementation. And this is seen from the perspective of the unique status of national human rights institutions as independent bodies that are separate from state, but yet still have access to state, and in this sense can influence some of the approach of states to implementation. The 10th recommendation is that the African Court should work together with civil society organizations to enhance the understanding of state actors about the activities of the court, and to also train state actors on how to implement the African Court's decision. The 11th and final one is that the African Court should consider the role of social media in increasing visibility and compliance with the decisions of the African Court. That is the summary. Like I said, it's been a very interesting discussion over the last 2 days, and we have tried to capture to the extent possible and synthesize some of the points into this 11 format. So please, at this point, I would like to ask if there are some comments, feedback for us to add to this recommendation. Yes, Justice Anuka.
Thank you very much. Good to know that this could be formulated so soon. But I have an issue regarding the perspective. I think there's so much focus on the African Court, whereas my own takeaway from this court is the responsibility that is on other bodies beyond the court. We are a court, and our mandate is very clear: interpret and apply the charter when an application is before you. Simplicity. So when it comes now to implementation, I wonder why you have roped in the African Court to the extent in which you seem to have done. So I would want you to have a look again in the manner first, the way it's arranged. We seem to be so much the primary target, and I doubt if it should be so. We're a court. I will want you to take that, I will want the committee who did this to take that into consideration. Just refocus the attention, so much attention that has been placed on the court, because we are helpless. When it comes to the implementation, ours is to give the judgment. And I think that is how it should be. Thank you.
Hello. Yes, I'm continuing. Just one point. The first item, that the court should incorporate apology into part of its jurisprudence. Yes. When we talk about just satisfaction, we talk about 6 things. We talk about official apology, public recognition, memorials, commemorations, truth-telling, symbolic acts, condemnation. These 6 come together to form what we term just satisfaction, and the court has been discussing them. If you look at the Ojie case, it was discussed and rejected. So it is not a fact that it doesn't form part of the course. The court's concentration, yeah. Yes, but you must look at the appropriate time and act on it. So where the presentation made is not appropriate, or where the applicant is seeking for that remedy, and the court is satisfied that this remedy is not available at this time, it does not mean that it doesn't form part of the jurisprudence of the court. Sure. Thank you.
Thank you very much, Justice Ajay. Dr. Ajalahan? I thought you raised your hand. Oh, can we please get the microphone to Dr. Ajalahan? It's this side.
Merci. Je crois que...
Thank you. The proposal on the public excuse This proposal came from the discussions in one of the panels during which a certain number of participants thought that the court was not properly integrating this kind of reparation, especially on the victim side. What we need to understand here, as a colleague said, the court adopted directives on reparations that are going to enable the court to say that in this particular case, these are the reparations that are going to be given. And the court adopted this document in virtue of the different clauses of the protocol. So the court understands that Article 47 gives it an opportunity to explore different measures of reparation. So with regard to this, you might get this information on the website of the court. So the court adopted some directives to help it determine what are the most appropriate measures. When you read these directives, they include, of course, public excuses. It's there, it's on the list. Now, when you ask a state to adopt public excuses, this should be taken on a case-by-case as determined by the court. If in this particular case, this can be part of the reparations. What we need to do here is that this recommendation needs to be reformulated to say something like the court can consider with regard to the application of its directives and reparations in whenever necessary to see the possibility of getting public excuses. But if you put it as an obligation, it cannot work because we cannot really determine this if we don't look at particular cases. But nevertheless, the communique is going to be shared with the court, and of course we are going to give our comments. But we thought that it was first and foremost important to get proposals from participants, and then the document might be finalized after, but of course it's going to be presented to us. Thank you very much.
Thank you very much, Dr. Ojolan, and thank you very much for providing also further context into how we arrived at some of these recommendations. I don't know if do we still have any input from the court before. Okay, Deputy Registrar Grace.
Thank you very much, Folusho. I wanted to know, after we discuss this, the document you have presented, I understand it's a summary form, but I would like if we could get information on what the next steps are regarding this communique and the resolutions. I mean, after the discussions, like how do we envisage it, the finalization of this communique or conclusions? Thank you.
So for the finalization of the communique, I think after this presentation, I would meet with Dr. Ojolan, and we can restructure some things for, just summarily for purposes of adopting the communique as instructed by the court. But in terms of the full recommendation, we are going to engage further with the court after this conference to really reflect on the full recommendation, and also look at some of the other details that maybe is missing right now, because we just summarily put all of this together. But this is not going to be it's exactly the final form of the recommendation. Does that answer your question?
Thank you. I would propose consideration of giving room for further inputs from the participants. Maybe just a short timeline. After you do the longer document, perhaps give a timeline to participants here to give their feedback. Thank you. Just a suggestion.
No, thank you very much, Deputy Registrar Grace. That is fully noted. I would then like to ask from the floor, from every other person in the room, if there's one or two things. And I think it's a good one that Deputy Registrar has really given us that leeway to send the final or the first draft with all of our participants to give input. I think that's really good. Thank you very much, Deputy Registrar Grace. Okay, is that okay? Can I take that's Ikechuku, no? Yeah.
All right, thank you so much. My name is Ikechukwu Uzoma, and I just want to contribute to the conversation around the first issue mentioned on public apologies and acknowledgement of responsibility. Again, the panel and the conversation was on comparative analysis, and the point of departure was what the comparative analysis showed. The fact that there's not been, at least to the extent of our research, there's not been a case where the court found appropriate to order that remedy. And now the question is why, and that's like what we are interrogating. That's not a question for the court to answer as such, but that's just what we're interrogating. And interrogating it to find out if the converse would have impacted implementation. It's a bit of a 3 or 4 step process towards implementation. But I'm grateful that Dr. Horace mentioned the practice directions. That's what I got from the interpretation. And I would follow up to get the practice direction, because indeed the goal is implementation, right? And the question is, could there be formulations of reparations that lead us closer to implementation? Understanding the political context and understanding even the interests of the victims or the people who approach the courts. Before the conversation, I didn't even know that it was considered in the Ogay case. So it was learning for me also. But now the question is, was it, like, how do you determine appropriateness or otherwise? So again, I don't think that the recommendation is, it can never be conceived as mandatory. Of course, no one is telling the court exactly what the court should do, but it's just a consideration from that comparative perspective, which, you know, I know that those of us who may have worked on this are willing to continue engaging with the courts to learn more about what the court may have done that is not in the purview of our knowledge, and also continue to work towards the shared goal of implementation and compliance. So that's just what I thought to add. Thanks.
Thank you very much, Ikechukwu. Just before I get to you, Mr. Yarifal, I think a state focal point from Benin.
Merci. Thank you. I would sincerely like to thank the rapporteur for the quality of this report. But I have a challenge. We are in this conference, an international conference, and for me, what counts is the contribution of all the participants. These are recommendations done by participants. Now we need to see who are they targeted to. We have certain recommendations to the court. It's not the court that is being judged today. It's mostly the states, but we need to have recommendations to the focal points, to the heads of state. We have their representatives here. It's actually the representatives of the head of state who made reservations for the governments, or rather the states that withdrew, it was on advice from the experts. So we need to target these recommendations to see which recommendations go to which organ, institution, entity.
Thank you very much for that. Maybe just to say that those are part of the things that we will put into the final full format that we will share with you. But thank you very much for your input. Maybe just to, before I take the next speaker, just to say, Justice Anokam, that I think I totally agree with you that the way in which the recommendations were framed made it look as if the court is the object of those recommendations. So I just want to ask, can you please display the recommendations, number 5, just in terms of, let's say, how number 5 is currently worded, because the understanding is that this is the role of the Pan-African Parliament. Would it be better to say that the Pan-African Parliament should consider the adoption of a model law on the implementation of decisions of the African Court? Thank you very much. Okay, I think Mr. Yarifol.
Merci, Monsieur le Modérateur.
Thank you, Moderator. I'm not going to talk to a particular point, but I would rather like to make a general comment. I don't know if amongst you there are people who love football, but right now we have the European Championships right now. And before yesterday, there was a match between France and Netherlands. And the Netherlands scored a goal. And the whole world thought that this goal was okay. The referee said no, and this goal was cancelled. And Netherlands did not leave the competition. They accepted. So this is how people should learn to adhere to decisions given by authorities. When a judge says something, whether this goes towards your interests or not, you need to accept it. This is how we should go to ensure the survival of our court. It's through hard work that we got this court. Thank you. This is what I wanted to say.
Mr. Yarifol, for that additional input. I think in the interest of time and considering the fact that we now have an established way in which we are going to share these recommendations with all of our participants to give specific input, I think I would like to close this first session of the outcome and way forward. So the second one is just for a specific set of audience who have sent paper presentation and who were actually here because we selected their abstract and they have developed their paper. So with regards to the publication output for those of us that have paper presentations, we would kindly encourage us to improve on our current draft based on the feedback that we have gotten so far from the court and other participants during this conference. Now, the revised paper, we would expect the submission by 31st of July, 2024, and we'll please encourage every one of us to adhere to the timeline. The revised paper, of course, it's going to be a peer review paper, which we would send to the reviewers, and the feedback will be shared with the authors. Then the developed paper, we envisage for now that it will be published in a special issue of a journal, and the specific details we would share with the authors. But please, the paper should not exceed 8,000 words, and it should follow the Pretoria University Law Press writing style. And maybe just to add that for anyone in the room that has not, who also made presentations that were not maybe paper-based, or if there's anyone who has felt inspired in the last 2 days, we also encourage, for now, anyone to send us to the conference organizer presentations, paper presentation, which we can still consider for purposes of this conference. On this note, I would like to once again thank everyone for their input so far on this conference, and I would like to hand over to the moderator for the day.
Thank you so much, Felicia. And now we are into the final substantive panel discussion. And before then, maybe just to highlight that we are not taking a break. We do just like we did in the morning. In case you need a cup of coffee, you can just walk out silently and grab one and come back in the middle of the session. So we're going into the next panel session, and I would like to invite the panelists on the stage. These are Justice Shafika Bensouda, Mugushi Maswi, Professor Nkadha Murungi, and Professor Ebenezer Durajaye, who will be joining us online. I do hope that they are ready and waiting for us. And this session will be moderated by Dr. Raisa Nyirongo. Dr. Raisa is a postdoctoral research fellow at the Center for Comparative Law in Africa, based at the University of Cape Town. Welcome, and over to you, Dr. Raisa. We hope you can finalize in an hour.
Thank you. We will try. Good afternoon. We're still in the afternoon, so good afternoon once again to all those who are joining us today. So this is a special part of the conference. This is a case discussion, and it is a case discussion on implementation of decisions of the African Court on Human and People's Rights. And what makes this special is actually it is part of the broader efforts of the center to increase the visibility of the decisions of the African Court on the visibility of the decisions of the African human rights bodies. So in this session, we have our panel of experts who have joined us today, and they will be discussing the case of in APDF and IHRDA versus the Republic of Mali. So this case challenged a law in Mali that permitted teenage girls to marry as young as 15 years old. I think we heard a presentation on it earlier as well, with parental or guardian consent. So the applicants successfully challenged this law, marking a very positive step towards respecting and promoting the sexual reproductive rights of women in Africa. This case has been widely regarded as a landmark decision of the African Court and a watershed moment in the promotion and protection of women's rights in Africa. So this discussion brings together a panel of selected experts from academia, representatives of the applicant, representatives of the court, and also representatives of civil society organizations. And by bringing together these representatives, the discussion will enable insight into the different perspectives and interests relating to one case, to this case. The panelists will use this as an opportunity to spotlight the opportunities available for the court to ensure effective adjudication of women's rights in Africa. So without further ado, I would like to call up our first panelist, the Lady Justice Bensouda, who is a judge of the African Court. She is currently serving her second term. She is also a lecturer at the National School of Magistracy in Algeria, and she holds a PhD in law. So we can welcome up the Lady Justice.
Bonsoir tout le monde, pour ne pas dire good evening.
Hello, everyone. It's been the whole day, but I would like first and foremost to say something that in Muslim countries, including mine, which is Algeria, we have a law for the family, which we call a family law. And this governs the family relations, marriage, succession, and so on and so forth. So Mali is a Muslim country which applies these rules. So how did the issue, the case start? So this was for the progress of human rights in Mali and another NGO. So they started this case in African court following this case, but to respect the history of this law, you need to go into details. In 1998, the Malian government looked at all these laws and linked them with the treaty. So the Malian country wanted to ensure that these laws be in the same realm as the source of the human rights, and they wanted also to link them up with laws of marriage and succession and so on and so forth. But unfortunately, when this law was adopted, there was an Islamist movement which wanted to reject this modification because they wanted to keep the Muslim rules. So this did not happened, so it was taken back to the parliament so that it can be modified, and this law appeared in 2011, and after that there was automatically the NGOs that noticed that certain rules are against women, children, legality of women, and so on and so forth, and therefore the judgment was given by African court. So that was just the history part of it. It is very important because when you go into implementation, these small details are very important. It's these small details that make the difference. So these NGOs came before us to tell us that this law is going against so many treaties, and we are talking about these allegations. Kindly highlight the allegations. So the applicants, what did they allege? First, as the allegations, please. So they alleged that there was a violation of the marriage age for girls. They said this is in Protocol of Maputo, Protocol 6B. So violation of the right to consent to marriage. This is also Article 16A and B on elimination of all forms of discrimination against women, violation of the right to succession, Article 21 of the Maputo Protocol, and violation of the obligation to eliminate traditional attitude of women. So in Muslim law, there is no age for marriage. There is no age fixed, so it's maturity that enables one to get married. So the issue of 16 years, 18 years is not there in the Islamic law. So I would like to precise this rule because there are allegations that there is age in Muslim law. So in Islamic law, this rule has a basis, and there was a lot of wars, and after these wars, there was a lot of deaths of many men. So there are so many women who were left with all funds, and therefore they had to find a solution with regard to the support of these women. So it was decided that it's the man who is supposed to be responsible and take to ensure that the family is in good shape. So it is a rule that does not come from nowhere, but there is a basis. So many of you do not know this basis. So what are the parties requesting? First and all order the state to modify the family code and bring back the marriage, minimal age for marriage at 18. And it is justice that determines whether a girl can be married or not, despite the fact that they do not have the age required by the state, and then sensitize the population on dangers or the risks of early marriages. And then we have the Family Code of 1997, which requires women to get consent for marriage, because there was a problem. They said he or she got married without, the families are being aware. So to modify this law so that they can bring in place a penal code insert some conditions to request consent when from the family members when they are absent in the marriage. Also, ensure that the family code is well known to ensure implementation. And now, for the state, how did it react? So it reminded the court the history of creation of this law. It said that unfortunately there was a violence that led to the adoption of this law in 2011. So the court was told to declare itself not to have the competence or jurisdiction, because for them these applicants were not, in line with the law. So the court, after discussions, and I'm going to not to go to the details. So after the discussion, they looked at the human rights and the competence of the court, and it was considered that all these articles that were revised and the human rights were considered, and it was considered that the court had the competence and had the jurisdiction. So the state required the people to look at the constitution. So when we look at the national law, it was noted that the NGOs had no right to take the state to court. So automatically the court it was decided that the court had the competence. Now, with regard to funds, when it comes to the minimal age for marriage, looking at the Maputo Protocol, when we look at the defending state, we reminded these provisions, and we declared the allegation that was well founded. Second violation, which is that of the consent to marriage, we referred to Maputo Protocol, and we looked at the procedure done at the National Assembly, and the state was considered to have violated this condition of the Maputo Protocol. Now, with regard to the allegation on the right of succession, the Muslim went to Maputo Protocol and noticed that there was an illegality in terms of succession between men and women. The violation, the alleged violation to eliminate a traditional attitude that deal with women, They looked at the national laws with regard to elimination of any illegality between men and women, children who are adopted, and natural children, and so on and so forth. We retained the violation. Now, with regard to reparations, the state was required to amend the law and ensure that they sensitize the population. The state the court ordered that the legislation was supposed to be amended so that it can be in line with the other commitments under the Article 25 of the Charter, and education, ensure education and sensitization of the population with regard to the same article. And then we are going to see, with regard to this provision, since yesterday we've been talking about different types of applications and so on and so forth. This judgment raises the issue of defending state on how it should reflect on the modification of the law of 2019, because the state wanted to put in place a system that is in line with the human rights. But unfortunately, there was what happened, and the parliament beat its track. So, given that the execution is supposed to be voluntary, so there is no way you can put pressure. So, as we received a feedback of the defending state and the parties, therefore, this was not applied as a decision. So, first of all, we have now to launch a public hearing to see how this will be handled. So, see what happened. Secondly, the focal points. This is where the focal points have to start their work. Just like it was said yesterday and this morning, we are now sure that the focal points play an important role in the relations between us and the states. And they have to explain why the decisions have to be applied. There's also something else, and I want to say that the state is not the only one responsible for the application of the law, because there is the religious movement, which made the state not to have a choice but to work, and this can only be done when you work with the civil society. The civil society must work to explain why it's better at 18 years for marriage and not 16 years. So I think this judgment is not difficult to implement. Why? Because in certain Muslim countries, these rules were modified. We take an example of Tunisia. It was enacted. In Algeria, there is a problem of child marriages. Even if the child has has 50 years, they have to seek consent. So I think we need to work a lot, do diplomacy, social diplomacy, and do a lot of things upfront in order to move forward with implementation and ensure the peaceful implementation of these decisions. Thank you for your attention.
Thank you to the Lady Justice. I think we can give her another round of applause. In her presentation, she highlighted the role of civil society in the execution of the judgment as well. And so with the next panelist, we will be hearing from Magushi Maswi, who is from the Pan-African Lawyers Union. So she's representing civil society today. She is a Tanzanian lawyer, and she's also a legal fellow. So we can invite up Ms. Magushi for your presentation.
Thank you so much, Madam Chair. All protocols observed. Good afternoon, honorable judges and all attending members. It's such an honor to be standing before you this particular evening. And on this particular panel, I will be speaking on CSO's perspective in regards to implementation of the Mali case. So my presentation is going to highlight the CSO's perspective on the importance of the case in the context of human and people's rights in Africa, but also it's going to look on the role of CSOs in implementation of the findings of this case. And lastly, it's going to highlight challenges and recommendations related to implementation of this decision. Now, moving on the CSO's perspective on the importance of this case, the first importance of this case is that it sets a legal precedent, which is in regards to the standards of practice, in regards to minimum age of marriage, the right to consent to marriage, equal rights to inheritance, and elimination of traditional practices and conduct harmful to the rights of women and children. So it also reinforces the need for national laws to comply with international treaties. Another importance is that this case, or this decision rather, stands as an advocacy tool. The case provides a robust framework for CSOs to advocate for legal frameworks in Mali and other countries. It highlights the importance of aligning national laws with international human rights standards. Also, this decision empowers the affected communities in a sense that it strengthens the position of victims and survivors of child marriages and discrimination practices in Africa, and provides a legal basis for demanding their rights and protections. Such judgment has potential to change the lives of thousands of women and girls and boys in Mali, so that everyone can enjoy their right to wait until they're adults before marriage, freely choose their partner, and receive inheritance in a fair way. Another importance of this decision is that it acts as a catalyst for broader reforms. The decision encourages comprehensive reforms in family law and demands intentional efforts for member states in promoting gender equality and serving the best interests of the child. It serves as a model for addressing similar issues in different jurisdictions. Now, moving on, let's look now at the role of CSOs in implementation of the findings of this case. CSOs assume a significant role, not only in shaping and informing decisions of regional and international bodies, but also participating in the formulation and implementation of such decisions. So the implementation of this decision will require an adoption of a holistic approach and collective efforts of different stakeholders, including CSOs, to assessing challenges associated with compliance and pushing the respondent state, in this case, the Republic of Mali, into executing the court's decision. Apart from just the political will of the respondent states, or rather commitment of that member state, CSO's interventions have arguably become one of the mediums by which compliance is being driven in the African system. So many CSOs already play an important role in supporting the work of these organs through human rights monitoring, standard setting, provision of assistance, education, and sensitization. In this capacity, CSOs can put pressure on the respective state parties into implementation. In regards to this case of Mali, CSOs can engage into monitoring and reporting. They could establish monitoring frameworks to track the government's progress in implementing the court's decision. This includes collecting data, documenting instances of non-compliance, and preparing detailed reports. And submit shadow reports to international bodies, such as the African Commission on Human People's Rights, detailing the government's non-compliance. In this particular case, it's been almost 6 years since the court decided or ordered Mali to amend this law, but we see that the respondent state is still reluctant into amending this law, which continues to subject women, girls, and children into grave violations. Another angle CSOs can play a great role is through public awareness and mobilization campaigns. It is crucial to educate the public about court's decision and its implications. Awareness campaigns can help shift societal norms and promote acceptance of new legal standards. This can include using media, social media, and community outreach. These campaigns can steer public action into demanding implementation of the court's finding and the importance of adhering to international human rights standards. Another angle is through policy advocacy and lobbying. Policy advocacy in a sense that to pressure legislators and policymakers to amend this law in line with the African Court's decision, and working with parliamentarians and the government officials to draft now these provisions in line or in compliance with the court's decision. Also through collaboration with other stakeholders, CSOs could engage with stakeholders including government agencies and international organizations to ensure a holistic approach to push implementation of this decision, address challenges associated to it. Reporting to international mechanism, the non-compliance to international human rights bodies, but also utilizing treaty bodies such as the Committee of Convention on Elimination of All Forms of Discrimination Against Women that oversee the implementation of international human rights instruments to which the country, in this case Mali, is party to, and urging them to take action against the non-compliant state. Another angle is through partnership and alliances. CSOs play a vital role in building coalitions with other CSOs and international organizations to amplify advocacy efforts and increase pressure on the government. Partner with academic institutions, think tanks, and legal experts to provide research, analysis, and evidence-based recommendation for implementation of this court's decision. Another angle is through providing legal assistance and representation to victims or survivors of these violations and helping them to seek justice through domestic and international legal avenues. Collaborate with law firms and other legal professions to provide pro bono services for cases related to the enforcement of this particular decision. But another angle is through the use of media and communication. CSOs can utilize traditional and news media platforms to highlight instances of non-compliance and advocate for government accountability, but also leverage storytelling of affected individuals and communities to humanize this issue and garner public support for the implementation of this court's decision. And lastly, engage with traditional and religious leaders, because for this particular case, in 2009, Mali had adopted a family code, but was highly crushed by Islamic institutions, which led into adopting the now present code that has these violations. So CSOs could sit and engage into meaningful dialogues with traditional and religious leaders in Mali to educate them on the importance of the court's decision and seek their support in advocating for its implementation. On the last part of my presentation now, I will highlight the challenges and recommendations related to the implementation of this decision. On the challenge side, one of the challenges is resistance or backlash from traditional and religious groups. As I said previously, that in this case of Mali, this has already happened when they were drafting the first family code. So even implementing this current decision, it is expected to face a lot of resistance and backlash from religious or traditional groups. Another challenge is lack of political will, because it's almost now 6 years since the decision, but the respondent state has not yet executed the decision, so we see no political will to do so. Another challenge will be insufficient funding and resources to support CSOs and other stakeholders to engage into extensive policy advocacy, but also limited public awareness and understanding of this decision. On the recommendation side, I would recommend to engage CSOs and other stakeholders to engage into dialogues with traditional and religious leaders to build support, mobilize international pressure and support, find innovative financial mechanisms such as international funds dedicated to specific courts decision or crowdfunding platforms. Also conduct extensive awareness campaigns using local language and media channels. Call for member states' accountability into abiding with international standards and instruments that it has ratified. But also lastly, develop new innovative ways for implementation of decision. For example, sanctions for non-compliance, such as targeted economic sanctions or diplomatic isolations. And conclusively, I would like to conclude with one of my favorite quotes that says, "Violence against women and girls is our individual and collective shame, a gross violation of human rights happening on an epic scale. It is a systematic issue that must be addressed at every level of the community." Thank you so much for listening.
Thank you for the wonderful presentation on behalf of civil society. So without any further ado, I would like to call up our next panelist, Professor Murungi. She does not need much introduction, as she's been before us quite a few times, but she is the acting director of the Center for Human Rights, and she's also a very seasoned academic, so she will be coming in with the perspective of academia. So please, 10 minutes.
Thank you very much. I have 10 minutes, and because I'm the one who was enforcing it previously, I will try to stick to the 10 minutes. We have been given a very succinct, or I would say comprehensive introduction to the context and the background of the case that we are discussing this afternoon. So I will not belabor it, but I have been asked to comment on it as an academic, so I'm going to put on another hat. But the problem is I can't put on that hat and also not be the activist that I probably more naturally are. So I'm going to maybe combine those sides together. So the case that was presented is, if you read from the judgment, and as has largely been presented by the Honorable Lady Justice, it's really about adoption of a law, and this law being accepted or not accepted at a national level. That is how it sounds in writing. But then, as an academic, I think my curiosity also goes to what is not being said. What is the salient narrative behind this issue that is before us? And this is what I think, that the case, as much as it was about amendment of, or rather the adoption of family code and specific provisions relating to the minimum age of marriage, consent to marriage, harmful practices, and all that, was really about a disagreement related to gender discrimination and the disadvantages that women and girls face in the context of making decisions related to their own bodies. And secondly, about unequal power relationships, because it was more a question of protesting the fact that the choice to be married, the choice to decide, to consent to marriage was being taken away. So there was an element of unequal power relationships. So from that point of view, the question that I asked myself is, and which came up yesterday as well, was, when these cases come before the court, as litigants, we can be very married to the letter of the law, to the black and white of what the treaty says, of what the specific provision says, of which aspects of the code are you interpreting and which aspects you're not interpreting. But I think from yesterday's discussion, we start to realize that, in fact, the cases that get implemented, the impact that stays with us is about the narratives underlying the cases, the people behind the cases, what were actually the driving factors. So the provision, the specific provision, is just an entry point to the court. But the grievance of the people behind it is the helplessness of not being able to decide whether you get married or not, or who you get married to, or your consent not being taken very seriously. I think, of course, the court has limitations in how it can deal with these cases, maybe as was emphasized by previous speakers, that there are conventions and rules and procedures of reference of how the court operates, and that might be a limiting factor, because if these issues are not raised before the court, then they probably don't find themselves in the judgment. But then I think, and again, cautioning myself, the whole argument around the court, the difference between the court being an activist and an active court, not to ask that the court must, be activist, but to wonder, if you are an active court, do you then appraise yourself with the grievance beyond what, like we say, there's what public notice, it's public knowledge that in fact the contention in this case is about gender discrimination as opposed to purely about a law. This is also a unique case, and this is where I agree with the Lady Justice, that it's an easy case to implement because it's a one case where, quietly, between the lines, the government was actually on the side of the applicants. I know that is a contentious issue to put, but the arguments of the government in the Mali case were actually almost as if, actually we agree that this law should have been like that, but we are here, so we have to say something. So we are going to oppose anyway, but not necessarily because we don't believe fundamentally that this law is problematic. From that point of view, the government was already aware that this law was, in fact, I think that the government was seeking to be rescued by the court. So a decision that says that this law is inconsistent with your international obligations was actually a welcome decision. But substantively, and again going back to the comment that was made yesterday, I wonder what would have been the value of actually adopting a theoretical paradigm to this case, as opposed to just assessing the merits on the basis of just the letter of the law. This is what I mean. This case would have been very different if it was written from a feminist theoretical framework. It would have, the discourse would have been slightly different, perhaps a little bit more substantive. Because, as I said, the social grievance behind this is actually inequality, is gender inequality. It's not about the code, it's gender inequality. And if you don't address gender inequality, changing the code will not change the situation of women in Mali. So from that point of view, I thought that that is something that probably would have come, to bear. The second aspect of it is, again, from a theoretical framework, here is a case where you're dealing with the rights of girls and women. But a distinction wasn't necessarily made between the theoretical approach to the rights of girls and the particular considerations that could have gone. Like, yes, there is reference to the best interest, but there is already sufficient, if I would say, extensive jurisprudence around how does best interest look in decision-making related to reproductive rights for girls. I think that is something that would also have come if a theoretical framework had sort of been adopted. So in my view, there was a missed opportunity. I think it is a good decision in as far as it affirms the state's duty to guarantee equality of men and women and non-discrimination. But I think, this was an opportunity to actually affirm, like make an affirmative statement related to gender equality. And I think in African context where gender equality is a big issue, this would have been a very, very welcome and progressive opportunity. And especially because to date, we have not had a case on the Maputo Protocol. And the Maputo Protocol is the bedrock of gender equality on this continent. I think this was really an opportunity for us to actually bring that Maputo Protocol. This is not an indictment on the court. It's also on all the parties and everyone who was involved. So I think affirmation of gender equality would have been done very well in this case. Yeah, and also, I think given the advisory opinion of the court in relation to the status, or rather to access to the court by the committee, that's a decision dating back all the way to 2014, which then by effect means that the committee, the African Committee of Experts on the Rights and Welfare of the Child, is not able to bring cases before the court. I thought actually this was a good opportunity, again, to sort of embed the mandate of the committee in a decision that concerns children, because the African Union already recognizes that that mandate lies with the committee. I think there was maybe some opportunity that we could have explored to that end. This is exactly 9 minutes, so I have 1 minute to go. One last thing. The nature of the remedies that we have. Okay, so I should have prefaced my comments. I am an academic, and being postgraduate students, we get chastised when you describe things. You're told, at this level, you must be analytical. So it's taken for granted that you're actually critical, not just analytical, but you must be critical. So do not take it that I don't recognize the good side of this, or I am just an angel of doom. I'm just doing what I do, which is the critical side. I can maybe come back to the positive side if we have time. I want to sort of contradict myself. I say this is an easy judgment to fulfill, but it's not an easy judgment to fulfill because, as we noted, we are 6 years in, and much as we may give credit to the whole idea of terrorism and other disruptions, there is, in fact, a reluctance on the part of the government to prioritize and actually put this to action. Why? It has been noted clearly. This is a sensitive issue. You're talking about gender equality in a majority Muslim country that has generally accepted the application of Sharia and by extension the inequality of men and women. So the state is going to buy time. If you have such a situation, going back to my issue of maybe needing to appreciate the contextual issues, I think this judgment should have been very, very specific. I know that the prayers of the applicant were, a bit general. Amend the law. Yeah, you can amend the law, but you may not actually. I think in cases where it's a sensitive matter that leaving a lot of discretion defeats the point of coming to the court, because that's the reason why we couldn't agree in the first place. So if you push back discretion without addressing the power imbalances, the discretion means that the same kind of interpretation or legislation will be amended only to reinforce existing power imbalances. So in this case, I think this is an appropriate case for a prescriptive amendment of what this could look like. Not amending the law yourself as a court, but sort of giving parameters of what that could look like in the amendment and what needs to be the supporting legislation. The second thing is that the measures are also a bit difficult to do. I take, for instance, the requirement to undertake public education. Public education about gender inequality, the dangers of early marriage. I think the court was being very safe, agreeing with the applicants, not wanting to push the state very far, because this is in fact a recommendation that the state itself acknowledged that they needed to do. They said the reason why we are here is because we got pushback. There was pushback from the general population. So in a case where it has already been acknowledged, I think if we say public education, it becomes very difficult then to know at what point do we say actually we have achieved public participation. Now, tie that to the requirement to the state to come back and report in 2 years. How does education, social education and social transformation doesn't happen in 2 years? This probably is an opportunity for asking the state to submit a plan for public education and clear milestones of what will that look like? What are the targeting groups? How will we actually make this work? And I think it has already been noted by the previous speaker in the other session, Dr. Nabane, about the request for an implementation plan within the 2 years, which of course, up to today, has not happened. But taking into account the issues that I've just mentioned, I wonder whether we just need an implementation plan or a reporting back, or whether you actually need to revisit the entire attitude and approach of the state in redressing the issues that underlie the case. 13 minutes, sorry, thank you.
Thank you very much, Prof, for that very insightful conversation and discussion. So we have one more speaker. We have Professor Durojaye, who's supposed to be online. I'm not sure if you are online.
Yes, I am. Yes, I am.
Okay, amazing. So I think now we will hear from Professor Durojaye, who is a professor of law at the Center for Human Rights, and his areas of interest include human rights, socio-economic rights, sexual and reproductive health and rights, and gender and constitutionalism. So you have 10 minutes, Professor Durojaye. The floor is over to you.
Thank you very much. Thank you very much. I think one of the difficulties in a situation like this is that you are speaking almost everyone has to say. Yeah. But regarding the case, I will make few remarks. One of the first thing I would like to highlight that this is an important case for our continent. Like previous speakers said, it was almost the first so a regional rights body will be making an attempt to clarify the provision of protocol. So the African region has always been regarded as a continent with one of the most progressive human rights instruments. Of course, I'm regarding to the protocol. Yeah. It's regarded to first in terms of its provisions. The first instrument to address HIV from the right perspective. If you look at Article 14 and E, which provide that women should be protected from sexually transmitted infections, including HIV and AIDS. And the Commission a general comment regarding that. The first general comment ever to be issued from the African Commission was on Article 14, the Article 41D and E in relation to HIV and AIDS. And similarly, we also know that 42C of the Maputo is also the first human rights instrument to really allow women to go for abortion on certain grounds, which is very important for our continent. So it was a good opportunity for the court when the Amalia case was brought for the court to really set the clarifying some of the state's obligations in relation to the provision of the protocol as the case may be. It is interesting that the court was given the court in 2018, May or June. There was a general comment early marriage, which was adopted toward the end of 2017. I think it was a miss for the court not to refer to that general comment in this decision. I thought it would have been a good opportunity to just refer to very important elaboration given by the commission on the part of Judge. And then I'm also looking broadly in terms of sexual against and women. Study of studies when a girl under 18 gets married, that's likely of death, five times than when a gay due to some of these challenges with the body of that. So I think that was an important situation. Once you look at that issue of early marriage, and this was clearly addressed in that general comment by the commission and the committee to look at that part of and of course also like I said, the commission in general when trying to address the issue of HIV and AIDS. It mentioned that one of the obligations of states is to ensure that it remove all cultural and religious barriers that often perpetuate discrimination against women and girls in society. So I thought also the court could have emphasized on that using that general comment as an opportunity. one of the biggest challenges that this case exhibit has to do with the issue of the influence of religious leaders or religious groups, as the case may be. And I think one of the speakers referred to it. So it is more paradox. We have one of the most progressive instruments. Our continents were holding sexual projects. About mortality. Talk about safe abortion in Africa, teenage pregnancy rates in Africa. And then so it one wonders why the fact that we have these instruments that our government and states are failing us in terms of proper effective implementation. And it can be a good opportunity for the court to emphasize on that in terms of how our government implements some of this in the so that the influence of religious groups with relation to sexual is a big challenge, which we are almost in every when you talk about sexual education, it's there. Safe abortion, it's there. Even access to contraception services is a big challenge. Yeah. And I think if you look at what is happening, for instance, in Uganda, a few years back, there was this government adopted guideline for sexuality education, but it has to be withdrawn because of opposition from religious groups. The same thing in Kenya, sometimes guideline on abortion services was adopted. It has also to be withdrawn due to religious pressure. So this is very disturbing, and of course, it also tells us that we need to do more in terms of the role of religious groups and the general right, including sexual and reproductive rights. I think what we need to do as well is sometimes we engage them more as we should. I think they are very important in terms of how it would advance the right of women including their sexual rights, right? So we must always be thinking about it in our advocacy and of our policy decision or planning. Maybe. We have seen it in this money. It was interesting that the government of Mali was to elevate the role of religious as a personal job. Interesting argument presented before the court. Although the court did not so much, the court did also accept that as an excuse not for you to implement your decision. The instrument you has ratified. So what it means is that thinking about implementation, we must also be positive. Non-state actors, stakeholders like religious. We need to really try as much as possible to also reach out to them. We can't prevent as if they are not important. Like I said, they always sometimes serve as stopping blocks to advance the sexual proliferation in our continent, and so it's very important that we consider them. And I think we also think civil society groups have importance as been said, and I think that's a very important thing. And one of the speakers talk about the therapies in Nigeria, where civil society groups play an important role, at least making the government to try to respond to the decision. I think we need it in this situation as well. I'm not sure how strong civil society is in Mali, but I would get to one or two people from Mali about that decision, and they're still worried that government is not complying with the decision. And so more advocacy in that regard. And I think for academics, we need to write more. And some of our academics are already doing that. And we also see that the paper presented earlier on that shows there's interest about it. But I think we need to do more. And of course, academics, society groups, HU groups, together to see how we can also. I think the fact that we have a joint general committee which talk about child marriage, so we can combine it with this decision in order to engage engage with other stakeholders that can be non-indigenous groups to really ensure that the decision of this board is truly implemented at the national level. Yes. We have said this before morning about this in terms of implementing by international marine bodies at the national level. It's not peculiar to Africa, but I think we should find a way of dealing with it. We should try as much as possible to be creative about it. I'm not sure whether the court beyond waiting for the executive council to follow through with this decision. To also be trying to reach out to states in terms of how they can understand their dialogue to ensure that this decisions are implemented at the national level. Those are things for now. Thank you.
Thank you very much, Professor Durojaiye. Maybe we can give him a round of applause. And once again, perhaps we can give our panelists a round of applause as they have completed their part. Yes, so I think from the discussion, it was very clearly highlighted the role that different stakeholders have to play in the implementation of a court decision. From the time that a matter is even brought to the case, I think Professor highlighted the potentially lacking aspect of the prayers that were made to the court, if they could have been a little bit more detailed. And we've seen that civil society can also play a very strong part in implementing the decision. So a decision that you would think would be easy to implement, because it seems as though that is what the state wanted, has taken or is taking 6 years to implement. So I think this really ties together the conversation we've been having over the last 2 days about implementation and the role that the different stakeholders can play in this. So I think I will open up the floor to any questions, and I think the first opportunity will be given to the court if there are any questions or any comments. Okay, I think there's nothing from the court. Okay, then I will open up the floor to everyone else if there's any questions, any comments. Oh, sorry, yes. Honorable Justice.
Merci à tous. Thank you, everyone. Hello, everyone. I would like to thank you for the great presentations, the analysis done in the issue. I am in a situation that is relatively difficult, and I am in a dilemma in taking the floor this afternoon and give an opinion for Mali. When this decision was issued, I was the head of human rights in Mali. So this really, this means that I am aware of what happened. Have appreciated the analysis done by Judge Ben Saula, which was very much clear with regard to what is happening in certain countries in the society level, and especially the pressure on the religious institutions. So at the departmental level, I will not want to go to the details, but I would like to ensure you that the government of Mali did not miss the opportunity to try and implement this decision. But the social pressure made it very difficult to move forward. I know there are some technical documents that were drafted at the internal level with regard to family rights. Meetings were organized even by the department in charge of rights of women and children, Department of Justice. But at a given time, it was becoming difficult to change the law, because for those who are following the news, there was a lot of instability in Mali, and therefore the decision was rendered. And sometimes later, there was a change of regime through a coup. The authorities did not take up the issue immediately, and therefore this is still at that level. So we are faced with this kind of situation. So when we worked on the thematic, I tried to inform myself on the latest developments, but I noticed that the country is also faced with issues of terrorism, insecurity, and therefore this does not give a favorable environment to adopt a law. Given the different principles that have different opinions in terms of the religion, so decisions, the implementation of the decisions in Mali has not happened. This is not because of bad faith. I am not representing the government of Mali, but I am giving this as a personal opinion. But given that I have followed this, and also having taught in a university in Mali, issues related to human rights, we have really undertaken a lot of research on the issue, but we are still facing challenges because the environment is not favorable. So you notice that several issues have been facing Mali, but has never withdrawn its declaration. So despite the condemnation that Mali has received, but it still continues to participate in the procedures and does not even think of withdrawing from African Court. I know the judges can say the same thing, but implementation is becoming difficult given the context. So we need time to implement this. For example, there is the penal code. This needs to be in line with the international instruments. And last time we tried to do this, but it has not been possible. So I would like to, I wanted to explain what the situation is at the national level. So it is not because the government does not want to implement the decisions, but things are very difficult because of the pressure. So when you look at the documents presented at the National Assembly, you will notice that there has been dialogues that has been organized. It has to be dialogues for parties to come to an understanding. Thank you very much.
Thank you to the Honorable Justice for providing context on the situation on the ground as well. I think something that I've realized through this conference as well is the importance of having these conversations, because it's easy to see something from your perspective, but not to really understand the context that is taking place. So we thank you so much for that input and that intervention. Is there any other? Yes, Justice.
Thank you very much. I stand by the same protocol extended to the panelists by the Vice President of the Court. My issue is about the judicial activism, that we should have gone further to make it look like we are being activists. We don't interpret treaty in the form of activism. We interpret treaty in the form of purposive interpretation. What is the purpose of the law? And not that you are going overboard the law to make your own treaties. You can't do that, because treaty is made by countries, and that is their understanding. That is why at times they issue general comments to inform people that this is what we mean, this is what we mean. And therefore, when we are talking about activism, it should be limited to national courts and not the international courts. Then another issue about the fact that the Malians case, the court did not take into account cultural and other factors. a court is not bound to take into account somebody's religion, somebody's culture, if it is a treaty. The reason is that if it is a treaty and nobody forces you to go and sign, and you're going to sign, and you think that part of the treaty will not be in your favor, the law requires you to deposit a reservation. And therefore, if you fail to deposit it, then the law is that we treat it like any other person. And Mali did not deposit any reservation or declaration saying that, please, when we are interpreting it, don't interpret to affect my culture or religion. And once it is not there, the court did not err in any way. That is the proper way to do. Otherwise, the court will be discriminating without legal basis. That we take judicial notice that if it is Mali, let's do it this way. If it is Ghana, let's do it way. Is that the law? Where is your reservation restricting the power of the court to give purposive interpretation to the treaty? Thank you.
Thank you very much, Honorable Justice. Is there any other interventions? Yes. It's over there.
Thank you very much. As a matter of fact, the Charter does not have any reservation clause. Well, so to say. So then what you do is you go to the law of treaties. Yeah, and therefore, the law of treaties is very clear in terms of how reservations operate. Yeah, so that one is, we are not going to reinvent the wheel. Now, about the court being activist, you know, here you find a court which is between a rock and a hard place. Now, you do have parties before you. And at times, remember, we've been discussing since yesterday instances where states complain about a certain quote-unquote position of the state, a position of the court, okay? Because the court seems to be too lax, because the court seems to be too hard, etc., etc. Then the state is saying you are not using a proper interpretation of the Charter. Now, if then the court engages in an activist approach, then you have a party saying, you know, the court is going too much toward this side. Again, you may want to check a number of instances where applicants have complained about the court. Usually, states complain about the court for being pro-applicant. But we have had a number of instances where applicants also have complained. I remember those judgments against Rwanda where the applicant came and actually civil society to complain that the court was leaning towards state. So if you choose the activist approach, you may have the state to complain that you are leaning toward the applicant and vice versa. Again, we must give credit to the court. And I'm not defending the court here. Why? I can give you a number of judgments, 6 or 7, where the court has used obiter dictum. That's being activist. The court has done that in a number of judgments, where the court goes out of the way. Actually, it goes to what the applicant has not requested for, and goes to say, here, I believe, you know, because I am a human rights court, I believe, even though the applicant didn't raise A, B, C, D, E, as a court, it is within my power to do so. If you check some of the recent judgment on the mandatory death penalty concerning Tanzania, the court has taken a systematic approach to finding that even in instances where the applicant is not raising the issue of the mandatory death penalty at all, an applicant comes and says, I didn't have access to a lawyer. But the court says, this is a mandatory death penalty case. And I've said in the past 10 cases that this is the position, and therefore, I reiterate the position in this particular case. And in some of the other cases, it was more of obiter, the court saying, okay, even if this is not going to bind the parties, I find the opportunity here to say that in this particular case, you know, this should be the position, and this should be interpretation of the law. This should be the understanding of the law by both parties. So we cannot actually say that the court has not been, it's not been activist. It has done so in a number of instances, namely through the practice of obiter dictum. Thank you.
Thank you so much for that intervention and comment. Yes, Lady Justice.
Yes, thank you very much. What Professor has just said reminds me of a landmark case where we actually used the obiter dictum. That is the Morocco occupation of Sahrawi. It's a case we want to recommend to you to read, because there's so many things peculiar about that particular application, because the applicant, a Ghanaian, sued the entire 8 state parties that have made the declaration. Very interesting case. You want to look at it. The court delved beyond the prayer and went to make certain judicial pronouncement by way of obiter dictum. Thank you.
Thank you, Honorable Lady Justice. In the interest of time, I think I will not take any more questions or any more interventions, but rather now I will hand back over to the panelists to make any final remarks or to address the comments made. So you will have 1 minute each. So we can start with the Honorable Lady Justice.
Merci beaucoup, modératrice. Qu'est-ce que je...
Thank you, moderator. Would like to refer to the doctor who said that a judge is supposed to look at what's been requested by the parties. But as a woman, I try to position myself in my country and IAS. But as a judge, I'm obliged, I have an obligation to work with the request and the file. Sometimes because we have a jurisprudence and we have to apply it even if it's not required, but the best principle is to deal with the application as it is, not to go outside the application. So I would like to thank finally everyone. I would like to confirm that I've really learned a lot of things, even though I am a judge. So thank you for the new learnings that we've had with regard to the decisions. We hope that we shall see you soon. Thank you very much.
Thank you.
Thank you so much, Madam Chair. I want to base my final remarks on the deliberation made by Honorable Justice, who was then the head of human rights during the case. This brings me back to thinking now with how the social situations in Mali makes it difficult in executing of this decision. It brings me back to thinking how we need to adopt a holistic approach in implementation of this decision, how each stakeholders, including CSO, can play a vital role into enforcing this decision. So that's what I wanted to say as remarks. Thanks.
Thank you very much. I don't have much of a comeback as well. I think there is the question about, activism. I think it's a discussion we can have a long time. I'll still hang on the difference between activism and being active. And I think there is a fundamental, institutions don't just exist in abstraction. They exist in a particular society. And so that is, I agree with the judges that a purposive interpretation would get us to where we're trying to do. A lot of the times, these differences in how we view these things, in what the CSOs are demanding, what the claimants are expressing as their own notions of justice, and what the court deems to be its mandate, is purely a matter of communication, that we speaking different languages about the same thing, and probably being able to articulate those narratives in a consistent manner would actually help us to make sure that the judgment serves all of us, not just the purpose of, having an outcome, but that it actually delivers a substantive meaning for the victims. At the end, the bottom line is social transformation and delivery of justice. I think we can keep that in mind. As if an institution impacts at that level, it wouldn't be an issue to actually push for accountability, because then people would, respond to it naturally. That's my view.
Thank you, Prof. And once again, thank you to the panelists. I think this has left us with a lot of food for thought as well. So I think we can give a final round of applause to the panelists. And my apologies, Prof. Dorojaya, do you have any comments?
Yes, thank you very much.
Thank you very much.
The final point I need to make is that this decision is very important for our continent. We should try as much as possible to disseminate it and talk about it, engage with relevant stakeholders, so that we can reap the benefit of that decision. Thank you.
Thank you. Thank you so much, Prof. Dorojaya. And yes, once again, thank you so much. And I can invite the moderator back for the day.
Thank you so much, moderator and the entire panel. As you will notice, time is so much spent, so I would like to move on to the next session. This is on the adoption of the communique. So we have a team that was putting this together, and to do that, I would like to invite the State Focal Point for Cameroon. This is Madame Mekwelinda. Madame Mekwelinda is the Deputy Director of Agreements, Treaties, and Monitoring of International Commitments in Cameroon. So I'd like to invite her to come and take us through the adoption of the communique.
Conference on Implementation and Domestic Impact of Decisions of the African Courts on Human and People's Rights, the Arusha Communique, 22 June 2024. Adopted by the participants of the Conference on the Implementation and Domestic Impact of the Decisions of the African Courts on Human and People's Rights, held from 21 to 22 June 2024, Arusha, United Republic of Tanzania. The Center for Human Rights at the University of Pretoria, in conjunction with the Coalition for an Effective African Court and the participation of the African Courts on Human and People's Rights, the courts, with the support of the Open Society Foundations, GIZ, Raoul Wallenberg Institute, organized the Conference on Implementation and Domestic Impact of the Decisions of the African Court from 21 to 22 June 2024 in Arusha, United Republic of Tanzania. The conference was conducted in a hybrid format, with some participants joining virtually, while the majority attended in person. The conference was attended by more than 80 participants representing the African Court, African Union member states, the Pan-African Parliament, the African Commission on Human and People's Rights, the African Committee of Experts on the Rights and Welfare of the Child, Network of National Human Rights Institutions, the academia and civil society. Proceedings of the conference were conducted in English and French with simultaneous interpretation to facilitate communication and active participation during the discussions. Objective of the conference. The objective of this conference was to provide a platform for an intellectual engagement between stakeholders of the African courts on improving the compliance with and the implementation of the decisions, judgment of the African courts. The conference held 8 thematic sessions: assessing the influence of decisions of international human rights bodies, a conceptual discussions. The role of state focal points in the implementation of decisions of the African human rights bodies. perspective on implementation of human rights decisions by the African human bodies, comparative analysis on the challenges of implementation of decisions of international human rights bodies, the role of African court in monitoring the implementation of its decisions, the role of other actors in the implementation of the decisions of the African courts, discussion on the broader influence of the decisions of the African court, case study discussion on the influence of decision of the African court, outcomes and recommendations. After 2 days of extensive and constructive deliberations, the participants agreed as follows. Engagement with the other African human rights bodies. The African Commission, African Children's Committee, and the African Court should embrace complementarity in their respective mandates, including by making better use of their existing tools and mechanisms to monitor the implementation of their decisions. The treaties bodies should join hands in their engagement with the AU policies organ for increased leverage of political will. Engagement with AU policies organ and other bodies. The PAP, APRM, and ECOSOC should expand his stakeholders' engagement with the African courts. The PAP should make a more inter-institutional use of his mandate to harness support among his members and parliament of UN member states to ensure a better awareness and understanding of decisions of the African court, especially those involving legislative changes. The PAP should collaborate with the African courts to develop and adopt a model law on enabling legislation to assist in the domestic implementation of the African court's decisions. The African Union Executive Council should expedite the process of reviewing and adopting the draft monitoring and reporting framework for judgments and orders, decisions of the African courts. The AU policies organ, especially the PRC and the Executive Council, should strengthen the engagement with the African Court within the concept of Article 29 of the African Court Protocol. Engagement with member states. Member states are encouraged to ratify the African Court Protocol and further deposit their required declaration under Article 34(6) to allow individuals access to the court. Member states should undertake measures to implement the decision of the African Court, including legislative, such as adoption of enabling laws to enforce the decision of the courts, administrative, judiciary, and the budgetary measures. The African Court should continue its engagement with states that have withdrawn the declaration under Article 34(6) of the protocol. Role of other stakeholders. In line with the Memorandum of Understanding signed between NANRI and the African courts, NHRIs should actively follow up on the implementation of the decisions of the African courts. CSOs should continue to complement the African court's efforts in raising awareness of his decisions and advocate for implementation of the decisions of the court at the national level. Relevant stakeholders should explore the role of the media, in particular social media, in increasing awareness for the implementation of the African Court's decisions, strengthening the African Court processes. Relevant stakeholders should support the effort of the African Court in its current practice of cross-regional dialogues and exchange with sub-regional and regional sister courts on issues of mutual interest, including the implementation of decisions. Relevant stakeholders should continue to support the African courts in the engagement of the African Court with state focal points and capacitate them on how to track the implementation of the African Court's decisions. Stakeholders should support the African Court in developing a systematized and public database on the status of the implementation of his decisions. Thank you.
Fellowship, was there supposed to be an adoption of the same? Kindly.
Thank you very much, Ms. Ekwe. I think we can see that we have tried to, as much as possible in the short time, take into account the recommendations that we got from the floor. I would probably like to ask the justices of the court and the court if we agree with this communique at this point. Yes, Justice Anuka.
Thank you so much. I want to say, on my part, I think it's a much improved version, and I truly have no objection.
Thank you very much.
Yeah, but you know, until we see it in paper, I didn't say anything. I only heard what she read. Thank you.
If we are happy with the communique. Thank you very much. I would hand over back to Gifford.
Thank you so much. I think that marks the end of our sessions, and now as we draw to a close, it's now my honor, it's an honor for me to invite the Vice President of the Court, Honorable Justice Sako Modibo, for some closing remarks. Honorable Justice Sako.
Ladies and gentlemen, honorable judges, national focal points designated by the African Union member states, Professor Nkata Murungi, Interim Director, Center for Human Rights, University of Pretoria, Abi Sophie, Coordinator, the Coalition of African Court, ladies and gentlemen, representatives of the civil society, academia, partners, all protocols observed. It's an honor for me, on behalf of the court, to pronounce this short speech during the closure of this conference on the implementation of the decision of the African Court. This conference was rich. Time went so fast. The presentations on different thematics. Other themes have been with us for some time. Others, one new, are going to enrich your experience. We had 7 major sessions And of course, these sessions were organized in a thematic manner. We had discussions that provided for presentation of different opinions, suggestions, propositions. We also talked about the use of technology, the issue of the implementation of the decisions, and the impact at the national level is extremely important. It touches also on the existence of the court. That's why the court collaborated with the Center for the Human Rights as well as the Coalition for the African Court to organize this conference. Ladies and gentlemen, we wait with the publication of the report from this conference, and we hope that it's going to help in the advocacy with regard to the ratification of the protocol and the apposition of the declaration for countries that have not done this. We hope that the national focal point designated by the AU member states are going to work hand in hand with the court to ensure that we attain our common objective to ensure the follow-up of the implementation of the decisions. We have also to collaborate with the different organs of the African Union to enable us go forward. We have the Banjul Commission, the Committee on Children's Rights, the African Peer Review Mechanism, Pan-African Parliament, ECOSOC, to integrate the clauses with regard to ensuring implementation of the decisions. We also talked about the use of technology, social media, to reach more people in explaining the mandate of the court. We need to also ensure that people understand how to seize the court, the functioning of the court, or the necessity of also ensuring each and every person gets these messages. We are going to go through the recommendation of this conference to ensure that the procedures for protection and promotion of human rights are adhered to. We come to the close of this conference. I encourage each one of you to collaborate, to provide innovative solutions, and to respect the commitments we've taken. I would like once again to thank you and congratulate each one of you for the success of this conference, and wish each and every one of you a safe journey back home. Thank you.
Thank you so much, the Honorable Justice Sako. I would like to thank you all for your time, and I'll be your moderator for the day. My apologies for those that I pushed, the moderators that are moderating the sessions, but I'm glad that we managed to pull the day off. And to close off this, I would like to invite the organizers. I'd like to hand over the conference to the organizers of this. This is Lloyd Covea, the Assistant Director of the Center for Human Rights, University of Pretoria. After which we will be free to disperse. So, Mr. Lloyd Covea, please take the floor.
Thank you very much, Mr. Moderator. My role is very simple, to give a vote of thanks. I see it says 10 minutes. I'm not going to take 10 minutes at all. Just much less than that, so that we can do other things. It's very successful deliberations. So on behalf of the Center for Human Rights, University of Pretoria, I would like to thank all of you participants, those who traveled from different corners of the globe and across the continent to come here in person to participate in what I think was a very important conference aimed at strengthening our human rights mechanisms, particularly the African Court, on Human and People's Rights, focusing on the implementation of decisions of the court, taking note of the fact that the strengthening of our institutions on the continent is our collective responsibility. And it's not just the role of the African Court to ensure that its decisions are implemented, but each of us have a role to play. So thank you so much, really. We are so grateful that you took time from your respective duties, from wherever you are based, and you found it important to attend this conference and give your views, your opinions, and the papers that were well researched. So thank you so much. The Vice President of the Court, Justice Modibo Sako, thank you very much for allowing us to partner with the court and have this conference. And also, may you convey our gratitude to the President of the court, who also graciously accepted to be with us next month in Kigali at the African Human Rights Moot Court competition. She will be one of the judges in the final, where young human rights advocates from universities across the continent will be arguing a hypothetical case on the contentious issue of unconstitutional changes of government and business and human rights problems on the continent. I would like to thank all the judges of the court who were with us throughout. You can see that our judges are working hard. It's not easy. They've got a lot of work that they are doing, but they also saw it fit to be with us throughout the proceedings. I want to thank the registry of the court, all the senior legal officers who assisted in conceptualizing the deliberations today, the deputy registrar, the senior legal officers, Dr. Oras, Dr. Serge, Madam Grace Wakio Kakai. Thank you very much for this time. Dr. Misha, and all the other senior legal officers, Victor, and including the interns that contributed to the conceptualization of this conference. I would like to thank all the academics. Thank you so much for your intellectual rigor in these discussions. Colleagues from civil society, with your activism, thank you very much. Representative of NHRIs, represented here, thank you so, so much. And I would like to thank, special thanks for me, really is to the special guests, the state representatives from national focal points, from Benin, Cameroon, DRC, Malawi, and Tanzania. You know, always when you bring everyone into the same room, you are likely to come up with fruitful deliberations. And it's good that all sectors were represented in this room today. And all the deliberations, I think, will lead, which has led to the adoption of this communique. And also, I think the commitments, I think all of us should look at the communique and see where we fit into that communique in terms of the commitments made, so that we implement those commitments and contribute really to the improvement of implementation of decisions of the African Court. I would like to thank our partners, the Coalition for an Effective African Court. We have been doing sterling work with the court, particularly the leader of that coalition, Sophia, and your assistant, Rebecca. I would like to thank the development partners, GIZ, Raoul Wallenberg Institute, and the Open Society Foundation for assisting with funding this conference. I would like to thank also representatives of the other human rights mechanisms that are also doing work in their respective areas, the Committee of Experts on the Rights and Welfare of Children, the African Commission, the Pan-African Parliament. Thank you so much, the representatives who were with us throughout the conference. And I would like to thank, of course, the interpreters who made this possible. Of course, we come from different linguistic jurisdictions, and so I think the interpreters did a sterling job in terms of simultaneous interpretation to ensure that we understand each other. I want to thank the media, the IT experts who made it possible for us to have online participants. Thank you so much for your input, and also for streamlining the proceedings of this conference. And also to the participants who took part online, thank you so much for your patience. And lastly, I want to thank the Center for Human Rights team, who really were running around with this conference and making sure that it is successful. For Lucio, Brian, Zainab, Ruth, and I also want to thank our communications manager, Simpiwe Kumalo, who was also ensuring that most of the events here were captured and everything will be posted on our website with your permission to show that we had a very successful event. And lastly, I want to thank Mount Meru for hosting us here at this beautiful hotel and making sure that we have a safe space to have our deliberations. And I want to thank, lastly, our acting director for your leadership. Thank you very much. I want to say goodbye and safe travels to everyone as you depart to your respective stations. We wish you safe flights back to your homes. And maybe at this stage, I'll call upon for Lucio to give us any logistical announcements so that those who may be traveling know when they are going to be picked up and whether the development partners have organized a cocktail for the participants or we are just going to our respective hotels to prepare for our departures. Thank you so much and au revoir.
Thank you so much, Lloyd, for the wonderful vote of thanks. Maybe just to start from Lloyd's last point, unfortunately, our developing partners have not made any cocktail provisions for us. And then I think it's been a very long 2 days for us, and it's just really good for us to, start applying our mind to other things. Thank you very much once again for this very fruitful discussion. In terms of logistics arrangement, we will, of course, just like yesterday, depart from here. For those of us that are staying at Palace, we would go back to Palace. The coaster should be outside. And then with regards to the pickup arrangement, we would just communicate. It's going to be similar with how we were picked from Kilimanjaro Airport. So we will all live in groups. And for people that are also leaving a bit later, I would be communicating directly with them with regards to how the pickup arrangement would go. I think that is all on my side, except if there's any specific question quickly. Okay, I see there's a hand.
Thank you. I'm sorry. It's not logistics. I just had a concern. If we had amended the program, I would have asked that we go and visit the African court to ensure that if it's not possible, next time think about it. We need at least to go and visit the court because we've only seen it on TV. We would have liked to go and have a look at it.
That's an interesting feedback. And
recording stopped.
Well, the Honorable Justice Shafika said you can actually go to the court. It's just that I think they have to travel back, unfortunately. But the court has promised the next time you're in Arusha, you will definitely visit the court. And maybe I should just apologize and say that we would have really to do that, but the 2 days were really packed. And but I'm pretty sure this is the beginning of an engagement, and we will always be back in Arusha, and we will have the opportunity to visit the court. Oh, you see.
Well, it's only 6 o'clock and the court is not far. So I don't know, but